the hearing in the general rate case, I just want to make an observation for the attorneys primarily. I count that we still have 11 witnesses to cover, and we're scheduled to conclude this part of the hearing today, and I'm determined to do that. So we may end up going late if we need to. I apologize. On a Friday night, that would be something that you could hold against me, and I would if I was you. But I say that to perhaps help us to prioritize our questions on cross and see if we can get through this. On the information was provided in advance, I only count what's been identified as 3 hours of cross. Some witnesses don't have any cross time by their names. I don't know if that's an indication that there is no cross, or we just don't have it provided. So we'll plow forward. We'll take one break in the morning. I got a reminder yesterday that maybe 10 minutes is not adequate, so we'll try to do 15-minute breaks, and we'll do that once in the morning, once in the afternoon, and a 1-hour lunch break. Okay. With that said, I believe Ms. Koblia will be the first witness today, and she's appearing remotely. Is that correct?
Yes, Chair, that's correct. The company will be calling witness Nikki Koblia to the stand, and she will be appearing remotely.
Okay, we can't see her yet. Ms. Koblia, are you there? There you are. Great.
I am here. Yeah, hopefully you can hear me. I'm dialed on the phone because my computer wouldn't work, but hopefully you can hear and see me.
Yeah, we can hear you right now. That's perfect. Would you raise your right arm to the square, please? Thank you. Do you solemnly swear the testimony you're about to give in this matter pending before the Public Service Commission of the State of Utah will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Okay, thank you. All right, go ahead.
Thank you,
Mr.
Chair.
Dallas.
Good morning, Ms. Koblia. Can you please state and spell your last name for the record?
Yes, so it's Nikki Koblia. Last name is Koblia.
And Ms. Koblia, what is your position at Rocky Mountain Power?
I'm the company's chief financial officer.
And Ms. Koblia, did you submit rebuttal testimony in this proceeding on March 7th, 2025?
Yes, I did.
And do you have any changes you would like to make to that testimony?
Nope, no changes.
And Ms. Koblia, if I asked you the same questions in that testimony today, would your answers be the same?
Yes, they would.
Chair, I move that Ms. Koblia's rebuttal testimony be submitted to the record.
Thank you. Is there any objection to that? Seeing none, we'll admit Ms. Koblia's, I think it's a rebuttal testimony. Rebuttal testimony. Thank you.
And Ms. Koblia, can you please provide a summary of the rebuttal testimony you submitted?
Yes, I can. So thank you. Good morning, Commissioners. I'm pleased to be here to discuss my rebuttal testimony that was in this phase 3 of our general rate case. In phase 3, parties assert that the company did not act prudently to conserve cash after the Labor Day fires. In my phase 3 rebuttal testimony, I disagree with this assertion and reiterate how the company manages its capital structure to be in line with levels authorized across its 6 state jurisdictions. Pacificorp has the ability to suspend dividends to shareholders in managing its capital structure and has chosen to do so until at least 2028. And we did that once we became aware of the increased liabilities associated with wildfire. That concludes my summary.
Thank you, Ms. Coblia. And Chair, with that, Ms. Coblia is available for cross-examination and any questions from the bench.
Okay, thank you, Ms. Coblia, for your short, succinct summary, and we'll turn to the division for any cross-examination they have.
I have no questions, thank you.
Okay, great. Mr. Moore for the office.
No questions, thank you.
Okay. Captain Rivera,
No questions, thank you.
Mr. Russell.
No questions.
Okay.
No
Ms. King.
questions, thank
Okay,
you.
Ms. Hayes.
Also no questions.
Okay, great. We're turning to Commissioner Harvey to see what questions he has. Go for it.
All right. In your summary, you said that the company suspended dividends once you became aware of potential liabilities. When did you come be aware, and what event do you count as becoming aware?
Yeah, in this case, I think it was a matter of the size and scale of the liabilities that really was triggered by the trial verdicts that happened in that June of 2023 time period. Leading up to that point, while we had accrued liabilities, they weren't of the significant nature that happened sort of after that, I'll say, triggering event, and just more information was available to us.
So you'd characterize it not necessarily became aware of the potential liabilities, but a certainty.
Our estimate significantly increased after the trial verdicts came out.
All right, thank you, that's all my questions.
Commissioner Clark.
No questions, thank you.
I don't have any questions either. Thank you, Ms. Coblia. Appreciate you being with us remotely today. We'll excuse you, and you can stay on if you want by video, but you don't need to. So, thank you.
Great, thank you.
All right, I believe that concludes all of the witnesses for Rocky Mountain Power for their case in chief here. Is that correct?
That's correct, Mr. Chairman.
All right, thank you, Mr. Magnus. We'll next go to Mr. Kelly for the Division of Public Utilities.
Thank you, Mr. Chair. The division calls Peter Kelly.
Thank you, Mr. Kelly. Appreciate you being here today. Will you raise your right arm to the square? Do you solemnly swear the testimony you're about to give in this matter pending before the Public Service Commission of the State of Utah shall be the truth, the whole truth, and nothing but the truth, so help you God? I do. Thank you very much. You may be seated. Mr. Grieco, to you.
Mr. Kelly, could you please state and spell your name for the record?
Peter Kelly, K-E-L-L-Y.
Can you make sure that your mic's on?
Peter Kelly, K-E-L-L-Y.
By whom are you employed and what is your position?
I'm employed by FTI Consulting. I'm a partner and senior managing director.
And what is your business address?
200 Aldersgate, London.
Have you participated in this docket on behalf of the division?
Yes, I have.
Could you briefly describe the scope of your participation in this docket?
Yes, I've been asked by the DPU to provide underwriting and actuarial insights into the issues raised by the RMP requests in Phase 3 of this rate case, and in particular, the Utah allocation of the wildfire excess liability insurance premiums paid by the parent company of RMP.
And have you provided testimony to this commission before?
In written form, yes.
But before this docket?
Not before this docket, no.
Can you provide a brief overview of your education and relevant work experience?
Yes. I graduated from Boston University with a degree in business administration and received my MBA from Babson College in Wellesley, Massachusetts. I worked until 2015 in the USA and moved to the UK, then where I live and work today. I was trained as a commercial insurance underwriter in the 1980s and early 1990s, and I worked for 32 years in insurance before moving to consulting 6 years ago. I've underwritten and priced many commercial insurance policies and have used underwriting manuals and guidelines like the excerpts presented in this case. I've authored underwriting manuals and I've authored insurance policies, some of which are still in use in the United States today. I have extensive experience in catastrophe modeling, a technology that's the basis of risk assessment and wildfire premium determination in the insurance and the reinsurance industry. And this experience comes from using the models as well as working for one of the modeling firms. In the course of my career, I've personally built or led teams who have built underwriting and rating plans and pricing models. I built my first model in 1993 and my most recent one in mid-2004, a span of 31 years. As an underwriter and pricing professional, I have intimate familiarity with the algorithms and the processes used in the areas of commercial insurance risk assessment, loss history analysis, loss and exposure modifications, and everything for the purposes of premium determination. Working for insurers, I sold insurance and purchased reinsurance specifically for aggregate risks, such as wildfire. I also led teams that have sold and purchased aggregate and catastrophe alternative risk instruments such as cat bonds and industry loss warranties. And I authored cat model validation methodologies, which have been formally adopted by U.S. regulators. I work directly for a cat modeling company in the capacity of product development. Today, as a consultant, I have clients in 6 countries, but about half of my clients are here in the United States. My clients include regulators, law firms, private equity firms, brokers, but my largest client group is insurers and reinsurers. Most of the insurers discussed in this case are clients of my firm, and several of the insurers discussed in this case are actually clients of mine specifically, although in work unrelated to this matter. We have extensive experience in my practice in the areas of power and risk generation. For instance, we were directly involved as experts in the PG&E bankruptcy.
And have you reviewed the company's filed application, amended application, exhibits, and testimonies in this docket, as well as the filings from the other parties?
Yes, I have.
Have you also reviewed responses to data requests?
Yes, I have.
Did you prepare and cause to be filed your Phase 3 direct rebuttal and surrebuttal testimonies in this docket?
Yes, I did.
And I would like to alert the commission and the parties that the division has filed corrected versions of Mr. Kelly's testimonies to address information that wasn't redacted and information that was redacted and shouldn't have been. So that's the only changes to those corrected testimonies. And those were filed this morning.
Has Rocky Mountain Power received that, reviewed it, and do you have any objection to the?
We have
That's
not seen the
correct.
document, but we actually discussed this with counsel for DPU. There were some designations that really didn't need to be designated as confidential, and we thought if they could de-designate, we could get through quickly. So we
Okay,
don't
so it's
object.
pretty straightforward, you have no objection?
No objection.
Okay, all right.
Thank you. Mr. Kelly, do you have, other than the corrected filings that were filed today, do you have any changes or corrections to those filings?
No.
If I asked you the same questions posed in that testimony today, would you provide the same answers?
Yes, I would.
Do you adopt your pre-filed testimony as part of your testimony today?
Yes.
At this point, I'd like to move to admit Mr. Kelly's testimony is filed in this docket.
Is there any objection? Okay, without objection, we'll admit Mr. Kelly's direct rebuttal and surrebuttal testimony filed in Phase 3 of this docket.
Thank you. Mr. Kelly, do you have a summary to share?
I do.
Please proceed.
Thank you. Chairman Fenn and Commissioners Clark and Harvey. My name is Peter Kelly, and I'm a partner at FTI Consulting. As I mentioned, we've been engaged by DPU to provide underwriting and actuarial insights into this matter. I appear before you today to offer additional and clarifying oral testimony to assist in this proceeding. On behalf of the DPU, I provided written direct rebuttal and surrebuttal testimony to offer my opinions on the norms and customs of commercial insurance underwriting, including individual account pricing and the influence of market forces upon the underwriters who determine what coverages and prices to offer their commercial insurance customers. My opinions in this area are rooted in the 36 years of experience that I have working for and with insurers and reinsurers, as well as serving commercial customers with large portfolios of risks, which are exposed to aggregate events like wildfires and other natural disasters. I'd like to say at the outset, I am not a lawyer. I am not an actuary. I am not an expert in utility regulations. I am best described as a commercial insurance underwriter. And my opinions are based in underwriting training and 3 decades of experience in underwriting risks. There are 2 core points in my testimony. The first is that the SO mechanism used by RMP in its allocation of wildfire liability insurance premiums departs from the norms I have seen used by risk management professionals, actuaries, and underwriters over the course of my career. Incorporating a more industry-standard, risk-based approach could materially change and very likely lower the amount of premium allocated to RMP in Utah. Because I possess an in-depth understanding of the underwriting guidelines and know specifically how insurers price these risks, my practice-based opinion is that the use of risk-based techniques, including industry-standard models acknowledged by rebutters as reputable, have driven the premium calculations of this insurance program. And I believe the contribution of Utah to the total program premiums is very likely to have been far lower than the proportional amount allocated by the SO mechanism. If Utah were to be extracted from the insurance program, the reduction in the premium of the remaining insurance cost would very likely be much smaller than the premium allocated by the SO mechanism to Utah. Additionally, I was asked to assess the extent to which recent increases in wildfire liability insurance premiums are likely due to events involving negligence. In summary, I reject the assertions in the case materials and in the testimony yesterday that because a fire like James is not in the paid loss history of one single insurer, that this event or other non-paid events involving negligence are not influencing the price of recent renewal of wildfire liability insurance premiums. The presence of discretion in the underwriting process described in the excerpt of the insurer's underwriting manual should leave no one confused that an underwriter at that insurer has at least 7 different ways in which he or she can, and indeed in which he or she is expected to, incorporate judgment so as to reflect the information value of the verdict of the James fire. This is completely consistent with the underwriting processes that I have seen at other insurers. I additionally looked at the portfolio of paid wildfire liability losses at PacifiCorp, as well as the statistics of all the wildfire losses with respect to human involvement. Unsurprisingly, almost all paid liability losses related to fires which involved at least some level of negligence, as one would expect given that the coverage is principally for legal liability. I therefore conclude that given the nature of liability insurance coverage and the nature of wildfire ignition and propagation, the majority of the recent increases seen by PacifiCorp are, in my opinion, due to wildfire losses involving some level of negligence. Thank you. This concludes my summary.
All right, thank you very much, Mr. Kelly.
The witness is available for cross-examination and questions from the
Okay.
commission.
All right, let's go to Rocky Mountain Power for any cross-examination that you folks have.
Thank you, Mr. Chairman. Mr. Kelly, I mentioned to council before we got started that at the outset, I've got a couple of things I want to talk to you about. They're in Mr. Gleba's and Mr. Einfeld's testimony. Do you have a copy of those?
I do not.
Okay, you don't? Okay. We get him one. And I'll start in because I'm going to start with your testimony. On line 868, which I think you'll find on page 46 of the direct.
Please, you may.
Thank you.
Thank you, Patrick.
Yes, go right ahead.
At line 868, you say, from a commercial perspective, negligence is generally associated with a behavior which was wrongful and unreasonable because it violated some duty of care, resulting in what would otherwise be avoidable harm. Did I read that correctly?
You did.
Okay. And we had a lot of discussion about these terms, including negligence yesterday, so I just want to be sure we sort of level set and don't get out of sync as we discuss them today. If you could look at line 746 in Mr. Gleba's testimony, his direct. He discusses some similar concepts. And just let me know when you get there.
746.
Seven 46.
Sorry, I'm having a problem finding it in this book. Direct testimony of, direct. I have it. Line 746. Yes.
There at 746, I think you'll find Mr. Gleba says, strict liability, strict liability holds a person legally responsible for harm even if no negligence was found. Is that correct?
That is what that says.
Okay, and then I think if you look at line 755, he adds, simple negligence holds a person liable for damages only if they can be proven negligent, right?
That is what it says, yes.
And would you agree that there is a distinction between negligence and strict liability as you and Mr. Gleba describe in your various testimonies? I guess I could back up. Do you agree there's a difference between what's known as negligence and what's known as strict liability?
The word negligence in my testimony is an insurance term, not a legal term. Insurance, specifically, the training of underwriters for insurance is related to the consequences which lead to legal liability and therefore coverage application.
Mm-hmm.
Some of the phrases you're using are legal phrases, and I'm not qualified to offer an opinion on that.
Is Mr. Gleba?
I'll have to leave that to Mr. Lieber
Okay,
to
so,
answer that question.
so based on your experience, do you understand that there's a difference between a concept called negligence and one called strict liability, whether in a commercial sense or a legal sense?
As a layman,
Okay,
they're two different terms.
okay. And would you agree with Mr. Gleba that strict liability holds a person responsible for harm even if no negligence is found?
As a layman, I believe that's accurate.
Okay. And then in Mr. Einfeld's testimony, this is the last time I'll make you hop around, I promise. In Mr. Einfeld's Mr. Einfeld's surrebuttal, the last one filed at line 108 is where we're headed.
The surrebuttal of Mr. Einfeld.
Yes, sir. Line 108.
Okay.
And at line 108, he refers to California's concept of inverse condemnation and its corresponding expansion of utility liability. You were here in the hearing room yesterday, correct?
Yes, I was.
You heard Ms. Coleman, I think, discuss with Commissioner Clark that concept in California.
Yeah.
Do you understand that neither strict liability nor inverse condemnation requires a finding of negligence before someone's liable for
I believe that
damages?
to be true, yeah.
Okay. Now, back to your testimony. And we can just go back to line 868 where we started.
Yeah.
And you mentioned it's a commercial definition,
Yes.
but as I said, since I'm a lawyer and you're an insurance expert, I don't want to get our wires crossed as we talk to each other. So I recognize the elements of traditional legal negligence in your definition of commercial negligence, so I just want to walk through that and be sure we don't have a disagreement. 'Cause
Fine.
as I look at your definition, for there to be negligence, there needs to be a behavior which was wrongful and unreasonable because it violated some duty of care, right?
Yes,
Okay, and we call that, so there's a duty of care that needs to be proven as part of negligence, I guess.
yes,
Okay. And then you say there needs to be wrongful and unreasonable behavior, right? Mm-hmm. And would it be,
yes.
Yeah, I think you'll need to answer with a audible yes or no. You can't do the so.
Thank you. I will.
and wrongful and unreasonable behavior, I think in the legal term, you'd call that a breach of that duty of care. Does that sound familiar from the commercial world?
Yes,
And then if the breach, and I'll quote you again, results or result in what would otherwise be avoidable harm, so the breach of the duty of care has to be the cause of the harm. And we can, in lawyer language, we call that the proximate cause. You're familiar with that concept of negligence requiring that there be a cause of harm from the breach.
yes,
Okay. Now, at line 870 and 872, still in your direct, you say, generally, an insurance policy does not discriminate between liability in the absence of fault versus liability from negligence. A little further down at line 881 and 882, you testify, liability insurance, as was stated, is generally blind on the issues of fault or negligence. So based on this testimony, would it be fair to say that insurers are not making value judgments about an insured's fault or negligence when they offer policy renewals?
no.
Well, what does generally blind on the issues of fault and negligence mean?
This is a coverage statement. The
But what does it
coverage will
mean?
apply.
I'm sorry.
The coverage will apply regardless of the issues identified here. But your question was, would an insurer disregard? And the question of how an insurer incorporates that information goes beyond the application of coverage.
So it says an insurance policy does not discriminate between liability in the absence of fault. So there could be liability that was due to fault. There could be liability where there wasn't a finding of fault, and the insurance is still going to pay or not pay according to its terms, right?
The insurance will pay if there's liability, regardless of fault or negligence.
Okay. If you could go to lines 941 and 942. This is just a few pages after your definition of negligence. Negligence comes up again. You say, it is your, or rather, I'll ask you, is it your testimony that in reviewing wildfire events involving the company, you, and I'll quote here, assumed 100% negligence if there are any signs of negligence? Is that correct?
That's correct.
And Mr. Dallas, would you pass out an exhibit for us, please? It is DR 4.18. And this is, I'll tell you as he's getting it to you, this is the division's response to RMP data request 4.18. And I'll let Mr. Dallas pass it out so you can get a look at it. All right, I think everyone has a copy. So in RMP data request 4.18 that we've placed before you, the question was, referring to this part of your testimony, please refer to the testimony and direct testimony at lines 9, 41, 42, stating that Mr. Kelly assumed 100% negligence if there are any signs of negligence. This is a prudent assumption. I'm sorry, I will. assumed 100% negligence if there are any signs of negligence.
Was
Yes,
the
sir.
next line.
That's correct. The
That's
last
a
sentence-
quote from lines 941 to 942, just for the record.
Thank you. And then subpart A says, please explain how Mr. Kelly determined whether a circumstance was a, quote, sign of negligence, unquote. And the answer in A there is sign of negligence is interpreted as wildfires which are started by human activity. Now, the concept of negligence, I think that we went over, and in your commercial definition, requires, does an action qualify as negligent simply if it's caused by human activity?
Does what qualify?
An action. Does an action that causes damage, does that mean it is negligent because it is caused by a human? Is it necessarily negligent because a human did it?
Generally speaking,
Okay. And
there
so-
there are scenarios where there could be yes or no.
Okay, so, and you remember negligence involves a duty of care to the person who is injured?
Yes.
Requires a breach of that duty, right?
That's correct.
Requires harm, right?
Correct. Yes.
Requires proximate cause, linking the action to the harm. But what you're saying here is that when you use the term signs of negligence, you're just saying if it's caused by human activity, it's 100% negligent.
For purposes of this analysis, that is the methodology I used, yes.
Okay, well, let's talk then some about the analysis. Let's go to your Phase 3 direct at lines 919. I'm sorry, let me pause here for a second. We'd move to admit as Cross Exhibit 1, RMP data request 418, or rather the DPU response to RMP data request 4.18.
Okay, is there any objection to that admission? Okay, that exhibit will be admitted.
Okay, here at line 919, and this starts, or actually, I'll just read the question at line 916. Describe the methodology you recommend be used for estimating the negligence portion of excess liability premium and how it should be applied. And then at 919, you say, our aim is to estimate the portion of increase in excess liability premium from the 2023 to the 2024 policy period, which can be attributed towards wildfire negligence. That's correct?
That's correct.
Okay. So that's, as we talk about this, and this is the analysis you were referencing a moment ago, right? Okay. And so as we talk
Yes.
about this analysis, I'm so sorry.
Just, would you just start your question over again,
I'm
Mr.
sorry, yeah, I'm
Magnus?
sorry, I interrupted. This is the analysis that you referred to a few moments ago, correct?
Yes.
Okay. And so your analysis attributes any fire that appears to you to be started by human activity as negligent. Is that correct?
Yes.
Now, when I say the fire appears to you to be caused in a certain way, I guess I'm really asking, do the attributions of negligence that you make in this analysis rely on court findings or other adjudications that it meets the commercial or the legal standard for negligence?
Yes.
Does it rely exclusively on those?
They are part of the analysis.
Okay. Well, let's take a look at the analysis. First, I'm going to hand you, or Mr. Dallas is going to hand you, this one. Yes. Okay, this is a document from the website of the National Interagency Fire Center. It's entitled Wildfire Investigation, Common Wildfire Causes. Do you agree that's what's in front of you?
Yes.
Now, I believe you cited, if we could go to line 946 in your direct. I think you cited, is this the report that you cited at footnote 56 in your direct?
I believe so.
Okay. And in about line 946, you say the National Interagency Fire Center states that nationally, using 10-year average annual data, as of 2023, human-caused fires accounted for 88% of all wildfires. That was your testimony?
Yes.
Okay. And let's look at this document from the National Interagency Wildfire Center. I believe the statistic you cited in your testimony, if you look at page 1 of this document, the second paragraph, as of 2023, the 10-year average of human-caused fires accounted for 88% of all wildfires nationally. Is that where you got the statistic in your testimony?
Yes.
Okay. And then on page 2 of this document, it lists several common wildfire causes, I believe. It may say that. Yeah, on the bottom of page 1, it says general human-caused fire categories, and you see a list of several causes. Is that correct?
Yes.
So in your understanding, the 88% figure on human-caused includes fires caused by arson, debris, equipment, fireworks, power generation, all of these causes. Is that your understanding?
The items that you referenced are part of my understanding. I don't know if the list that you've referenced is the totality of human activity related to wildfire.
But it's the list that's in this document that you cited, correct?
Ending with the words other causes.
Including anything that's not listed that can cause a
Exactly.
spark, right?
You're right.
Okay, fair enough. And did you test this 88% figure looking at anything that's more specific to Utah, for example?
I did not.
We have another exhibit. This is RMP exhibit. I guess while you're handing that out, this is this one right here. This one, yeah. I would move for admission of, we'll call RMP, I believe it's exhibit 2. This is the National Interagency Fire Center report referenced in testimony.
It's been moved that Rocky Mountain Power be able to submit cross Exhibit 2 on the National Interagency Fire Center report, which is referenced in footnote 56 of Mr. Kelly's direct testimony. Is there any objection? All right, it's admitted. Thank you.
And what we've placed before you is a document from the website wildfirerisk.org that's put together by the United States Department of Agriculture and the U.S. Forest Service. The overall title of the website is Wildfire Risk to Communities. Had you reviewed this information before we provided it to you on Tuesday?
I don't recall.
Did you look at wildfirerisk.org in your research?
I believe so, yes.
Did you look at Utah-specific data on wildfirerisk.org?
I don't recall.
Okay. And you see, this indicates that in Utah, 40% of wildfires were determined to be human-caused from 1992 to 2020. You see what I'm talking about?
I see that, yes.
And do you have any reason to believe that's inaccurate, untrue?
I have no reason to believe it's inaccurate.
Okay. So how would you account for the difference between this federal government generated report that says in Utah wildfires are about 40% human-caused, and the national data that's 88% human-caused?
The national data is obviously far more credible. It has a much larger sample size. There could be specific aspects of the local topography, vegetation, where a departure from the 88% would be warranted. As an underwriter, I might make an adjustment to Utah's loading or something like that. But I'm not surprised that an individual state differs dramatically from a national average.
Why is it more credible? Why is the National Interagency Fire Center website data more credible than the United States Department of Agriculture and U.S. Forest Service data?
Absolutely, it's a sample size issue. This is possibly barely credible because of the small sample size. And in the entire nation is, in all likelihood, an order of magnitude more data points. And credibility generally scales with data points.
Now, you seem to recall that you had looked at data on wildfirerisk.org, is that right?
Could you repeat your question, please?
Sure. When I asked you if you had seen this proposed exhibit, you said you had not. But I asked you if you had looked at the information at wildfirerisk.org as part of your research, and I thought you had indicated that you thought you had.
I think my memory on that is not perfect, but I believe that was one of the many resources examined by myself and others.
So you know that it's based on national data?
I could not provide you with the mandate or the data set underlying wildfirerisk.org. It's not something I am aware of.
Okay. Do you understand that data from USDA and the Forest Service takes national data and breaks it down into local community-based risk levels?
I accept that as being true. It seems very plausible, but that's the methodology of how they do that, and whether they do that is not something I'm aware of.
And what's the methodology that the National Interagency Fire Center used to get to 88%?
Well, I have to say I'm not a wildfire researcher. It's the national statistics, and I accepted it as the largest, most credible data point I could find.
Are you aware that if you review state-by-state human-caused data, that human-caused wildfires are more common in the eastern part of the United States than in the western part as a percentage basis?
I'm not.
Okay. So you trust the one you cited, but not this one, I take it?
I did not say that.
Okay. If we wanted to plug in 40% rather than 88%, is that just as credible?
No.
Okay. I'd like to move the admission of this wildfirerisk.org exhibit.
Are you going to number it as an
I'm sorry,
exhibit?
I think we had it 3.
Okay. This, we'll see if there's any objection to the admission of Rocky Mountain Power's Cross Exhibit 3. Seeing none, we'll admit this human-caused wildfires is the title of the document into the record. Thank you.
Sorry, Your Honor. Now let's go back to Exhibit 2, the National Interagency Fire Center document. If you could go to page 9 of that exhibit, I think it's 15 pages. Are you there?
I am.
Okay. I think you see this is the page where the document discusses various human-caused sources of wildfire. This is the power generation / distribution, power generation / transmission / distribution page. Do you agree?
Yes, I do.
Okay. And in the second paragraph, would you agree we have power line caused wildfires are often due to high winds, contact with vegetation, equipment failure, or human or animal contact with a power line, conductor wire, close paren, Sometimes several of these factors may work to cause a fire, such as wind blowing vegetation into contact with the electrical equipment. You see where it says that, correct?
Yes,
Okay. And so would you agree there's several documented possible causes of fire associated with utility infrastructure?
yes,
Now, if a power line caused fire is, to quote from this document, due to high winds, is it your opinion that the utility is always negligent?
that is not my opinion.
And what about high winds blowing vegetation into power line conductor wire? Would that always be negligent?
That's not my opinion.
So no?
They may or may not be negligent.
But in your analysis, where you call things negligent, 100% negligent, or 88% negligent, would you say that's always going to qualify if that's what the cause was?
The context of your question has an inaccuracy in it.
What's that?
The always prudent negligent is with respect to claims that are already paid associated with wildfire liability. So we start with a population of claims. This is scenario A in my testimony. These are paid wildfire liability claims. One would think it's 100% because it's liability. Now, there may be circumstances where you don't have liability from a negligence perspective, but you were still liable and the company paid. Now, how much of a number less than 100 could it be? We look somewhere else. We apply certain assumptions, and one of the alternative methodologies we looked at was human causation. So you're going back and forth between my two scenarios and mixing the concept of negligence.
Okay. Well, let's look at this. A little further down in the interagency fire document, in that second full paragraph, about 3/4 of the way down, there's a sentence that says, birds and small animals are also known to cause wildfires by inappropriate contact with power line high voltage equipment. They can be electrocuted and cause the power line to arc and spark or catch themselves on fire, igniting the dry vegetation below. You see that, correct?
I do see that.
Now, if a fire is caused by animal contact, is it your opinion that the utility is negligent because the fire is associated with utility equipment?
That is not my opinion.
If the utility paid, or the insurer of the utility paid a claim that was based on a fire that was started by an animal making contact, would you classify that as negligent in your analysis?
The methodology I used in scenario A would, yes.
Because it was,
A paid liability claim.
okay, so when you say signs of negligence, can I take it what you really mean is there was liability because a claim got paid?
No.
Okay, well, let's keep looking at it then. One more on this. If fire is started by lightning, I think you've generally said that's going to count as a natural cause and not a human cause. Is that correct?
I would agree, lightning is a natural cause.
Okay, and that's how you categorize it in your analysis?
Yes.
Okay. So if a fire starts by lightning and later the progress of the fire is accelerated because power lines went down in the fire, and there were claims paid based on that, would you count that as 100% utility negligence?
There's a claim paid
Correct.
on a lightning-caused fire, is your premise, correct?
My premise is that a fire was started by lightning. Some of these fires get very complex.
Indeed.
Fires started by lightning, it continues, the progress of the fire is accelerated because the fire got into a place, lines were down, those electrified lines accelerated the fire and there was more damage. Is that a 100% utility negligent wildfire in your analysis?
I'd like to correct what you just said,
Well, it was a question, so,
but the premise is incorrect.
okay.
Nowhere have I said I am analyzing that a fire is 100% negligent. The assignment from the mandate we received was, to what extent are premium increases associated with losses that have been paid on fires where there has been negligence? And that's remarkably different from a fire which is 100% negligent.
And how did you establish it's a fire where there has been negligence?
So there's been a liability paid,
Okay,
and there are some human activities or other aspects of the record that indicate fault or causation was part of a jury verdict or some other aspect of the loss. The fact that it is a liability paid claim, there's a presumption that there's liability because the claim was paid. So you're looking for what may have been revealed in the public record associated with where that liability stemmed from. And if it has downed power lines, unmaintained vegetation and things like that, and it's had a liability claim paid, that falls into the population of negligent-related claims.
negligent related.
Exactly. Not 100% negligent.
Okay, let's look at your analysis that we've been referencing. Let's start at line 935 in your testimony, where I believe you say, I think you're describing this analysis, to assess the proportion of total claims paid which are attributable to negligence, I first assessed the wildfire claims and incidents reported by PacifiCorp for claims from 2015 which were above $250,000, it's written as $250K, and identified the cause of each claim for these large wildfires. That was your methodology?
Yes.
And the analysis included is in your Phase 3 direct testimony at Appendix 2, is that correct?
Yes.
Okay, so let's turn to Appendix 2. And I'll ask, you identified, I think I counted 20 events here that occurred in the company's service territory, is that right or close to it?
Yes.
Okay. Would you agree that Appendix 2 is derived in part from discovery responses that were provided by the company?
Yes.
And let me note, before we start talking about the appendix in detail, this was marked as confidential. I think the only thing that would require any sort of confidential treatment in our discussion is if you say a dollar number. So the names of the fires, that is under claim name, not confidential. The state, the date of claim, the description is something you prepared, correct?
Yes.
Okay. So I don't believe we need to go into closed session unless you feel the need to identify a dollar number on any of these.
So I think that's a very good way to handle this, Mr. Kelly. Please don't identify a dollar number. If you feel like you need to do, alert us in advance before you disclose the number, and we'll go into a closed session. Okay?
Yes.
All right, thank you. You may continue.
Thank you, Mr. Chairman. Okay, so the column labeled description, which is your work, as you said, I want to look at a few of these fires here. And let me ask first, in the information the company provided you, which served as the basis for this appendix, they listed types of utility equipment that had been associated with that liability claim. Is that correct?
I don't recollect.
Okay. So you don't remember it saying failed conductor or transmission line or any attribution to a piece of equipment?
I can't call to mind.
Okay, now the company summary didn't identify how that equipment was alleged to have been involved in the event, did it?
I don't believe it did.
Okay. And it didn't include any judgments about negligence or fault, commercial negligence, legal negligence, anything like that, did it?
I don't recall.
Okay. Let's look at Appendix 2 and your column called Description. Let's look at the one, it's a few down, called the Hugo Fire.
Yes.
And your description says, thorough investigation revealed that the cause of the Hugo Road fire was a result of a tree falling into a power line. Is that a correct reading?
Yes.
And you listed this as no negligence present, right? You have a negligence
Yes.
present N or Y column,
Yes.
correct? And that means yes or no.
Mhm.
So you put an N here, so that's no, and then that is 0% due to negligence, correct?
That is not a fire which involved negligence, to my recollection, is how you should interpret the letter no.
Okay, so who conducted the thorough investigation that you referenced?
I don't recall where that investigation was performed.
It wasn't by you, was it?
Oh, no, no.
Was it something you found on the internet?
Court dockets, a variety of source documents were used, and yes, the internet was searched for this information.
And did this case involve a legal finding by a court of liability or of negligence?
I do not know.
Okay. And then the Slater fire is the next one I'd ask you to look at. Further down the list, about 2/3 of the way down. It's a fire in California. The Slater fire was reported to be caused by power lines downed by a fallen tree. Is that what you wrote?
That is what, yes, is an exhibit.
Okay. And it has negligence presence, yes, and percent due to negligence, 100%. Is that what you put down in Appendix 2?
Yes.
Okay, so how did you decide that a tree falling on a line is not negligent in one fire and it's 100% negligent in a different fire where there were apparently liability claims paid in both of them?
There's additional information not present on the exhibit that led to the determination there. I will not refer to the dollar amounts, but they are obviously very different.
What information did you rely on to make your attribution of negligence?
I don't recollect. I don't have that with me.
You don't have any idea?
I don't recollect and don't have that with me.
Was it a plaintiff's court filing?
I don't recollect and don't
Don't
have that
know.
information with me.
Okay.
No.
Okay, and you recall that you answered before that vegetation blowing into a conductor is not necessarily negligence. I think I asked you, would that always be negligence? And you said,
I said that was not my opinion.
okay. And in looking at a fire like this and attributing negligence to the company, would it make any difference if you had a down power line that sparked a fire, but the line was down because somebody drove their truck into the pole and knocked it down?
Would it make any difference with respect to what?
Well, does it get a Y or an N, and is the company given 100% negligence attribution in your analysis?
Is it a loss that involves negligence is my analysis, and that's the 100%. So
Well, wait, is it a loss that involves negligence?
that's
Your
scenario A.
determination of whether it's negligent depends on your decision about whether, well, that guy knocked down the pole, but, you know, the fire started earlier, and you call that either 100% negligence or 0% negligence in your analysis.
That is correct.
Okay, so which one would that be? 100% or 0%? Guy drives his truck into a pole, pole goes down, fire starts from the pole, from the wire.
And the individual's an employee of the utility?
No. Still human caused, right?
It could be yes or no, depending on other facts.
Well, any of these could be yes or no, depending on other facts, right? Anything in Appendix 2. So what's the basis that you use to make these decisions?
Once a review of the facts of the loss, which is a liability loss which has been paid, once the presence of something that is negligent, these are, as you said, very complex losses. Once a reading of the circumstances uncovers there is some kind of negligence, there's no need to look any further, because the mandate was, to what extent have the premiums increased associated with paid losses which involve negligence?
Okay, and you remember when I asked you what signs of negligence meant in this analysis? It's wildfires that are started by human activity. So in my example, it's cross exhibit 1. Please explain how Mr. Kelly determined whether a circumstance was a sign of negligence. A sign of negligence is interpreted as wildfires which are started by human activity, right? That's what you said, right? I mean, you can read it. It's in cross exhibit 1. Uh-oh.
Excuse me.
Oh.
May I pick this piece of paper up?
When you use that term negligence, I want to be careful because you defined it 2 different ways in your testimony. You've got commercial negligence, which is very much like the legal term, but then when you do this analysis, negligence becomes, well, it was caused by a human. So my driver who drove that truck into the pole, he's a human. The utility that put up the pole, they're humans. What does your attribution of negligence mean in a circumstance like that?
The losses have been paid under a liability policy. So someone found that there is liability.
Someone found that there was
Found or
liability?
determined that they should pay. These are losses that were paid on a liability policy. Someone has determined that either coverage applies or anticipating coverage might apply, there's going to be a payment that's going to be made. If a loss, an entire reading of the loss, has no signs whatsoever of human activity, then for whatever reason it was paid, it's not negligent.
Okay.
If there are signs of the human activity, we classified it under scenario A as negligent, because the mandate was, to what extent are the increased premiums associated with losses where there has been negligence?
So, as I understand what you just said, guy drives the truck into the pole and the fire starts. You would call that 100% negligence. You'd say if the utility, right?
If it's an employee of the utility.
It's not.
May I finish my answer?
Sure.
If it's an employee of the utility, clearly. If it's not an employee of the utility, I would continue to read the facts and circumstances.
Okay. Let's look at another one of the fires that occurred. The Pike Fire.
Yes?
And I promise we're not going through all of them, but there are a few examples I wanted to highlight. The Pike Fire is down near the bottom. This is one of the Labor Day weekend fires, as it notes, in 2020. And in your description, it says, the cause remains under investigation. Steady and strong east winds gusting more than 40 miles per hour pushed the fire into the Vaughn and Murphy Creek drainages. So how do you get to 100% negligence attribution when the fire is still under investigation and the cause you list is wind causing a devastating spread of fire in that event?
Recall that scenario in methodology A requires either 0% or 100%.
But you made that up. I mean, if it requires 0% or 100%, it's your analysis. You
It's
could have
the-
said, you could have decided, we're gonna do 0, 50, and 100. We're gonna do 0, 25, 75, and 100. You're making all this up. So when you say it requires 0 or 100, this is your thing, right? Saying you said 100% on a fire that's still under investigation. I'm trying to understand why, if a fire is still under investigation, you're saying, well, if the fact that there was a liability insurance claim made and paid, settlement, we don't know exactly why it was settled. I guess it was, there was a claim paid. Well, the utility was clearly negligent.
Objection. That question was really long. Can we get him to restate that, please?
That was probably very difficult for him to answer that. I think Mr. Magnus, if you could rephrase that without the long narrative, I think that might be best.
I apologize. I did go on. Okay, so I am asking you how you got to 100% negligence from the description of the Pike fire.
Recall that this methodology requires every loss is either 0 or 100 to conform with the requirements presented to me by the DPU on how to do this analysis.
Okay, let me just ask you a question about that. So the DPU told you if it's human caused and Pacificor paid a claim on third-party excess liability insurance, it's 100% negligent. And let's work your analysis from that assumption. Is that what they told you?
That's not correct.
Okay. Why did they tell you it had to be 0% or 100%?
They did not.
Okay, what did they tell you?
Please tell us what percent, please tell us to what extent the increase in recent wildfire liability insurance premiums have been associated with wildfires where there has been negligence.
And when they said negligence, did they say, the way we want you to define it is it's a human-caused event? Or did they say negligence is duty of care breached, your commercial definition of negligence? Which did they advise you to use in your analysis?
They did not provide any advice on that matter.
Okay, so when you use the word negligence over and over again, we have to be careful because sometimes you mean duty of care, breached, proximate cause, damage. Other times you mean a human caused this. We just need to be aware of that as we look at your analysis. Is that correct?
No,
No?
that is not correct.
So are these descriptions that result in Ys and Ns based on your view that there was a duty of care that was breached and the damages were caused and the proximate cause was Pacificor?
In these losses, this is a frequency analysis. So putting aside the relative contribution of negligence or randomness, if there's evidence that there's some negligence, it falls in the category of losses where there has been some negligence.
Well,
If-
and when you said that in your testimony, I asked you, please explain how he determined what a sign of negligence is, and you said a sign of negligence is interpreted as wildfires which are started by human activity, right?
I did say that.
Okay. Okay, so let's stay with the Pike fire for just a minute. In the documents you look at, sometimes, well, let me start with this to be sure we're square. Excess liability insurance is not property insurance, right?
That's correct.
Okay. Excess liability insurance comes into play when somebody says, some third party, not the insurer, not the insured, says, I got damaged and it's your fault, right? So every single time that a claim is made on an excess liability policy, somebody is standing there saying, this was your fault and you owe me for it. Is that fair?
Yes.
So you can always find somebody on any excess liability claim who's going to say, oh yeah, it was their fault, right?
Yes.
Okay. And sometimes in a settlement, the parties will, and the insurance company will agree, it is prudent to pay out from our excess liability insurance. No one has admitted negligence, let's say. Let's use the term. No one has admitted negligence. In that case, if there was a settlement on, say, the Pike fire, And there was no admission of negligence, there was no court finding of negligence, but the parties agreed, the insurer agreed, this is covered by our excess liability insurance, we'll cover it. You're telling the commission that they should consider that 100% negligence.
I don't use the phrase 100% negligence in the context in which you just used it. As I've described it, whether or not it belongs in the population of losses where there has been some negligence. And secondly, I accept the, excuse me, the premise that there are claims where, in the absence of any negligence, it's expedient to settle. By and large, this attempted to avoid those kinds of claims by ignoring smaller claims.
Just to be clear, on Appendix 2, there's a columns labeled Scenario A and Scenario B up at the top.
Yes.
And each one of them has a column called percent due to negligence, right?
Yes.
If I read that as just a regular old person, I'm going to go, well, this guy must be saying percent due to negligence on the Uinta fire is 100%. Is that fair reading of that?
Column, Scenario B?
Scenario A.
No.
Okay. Okay, let's look at the Beachy fire. And I think this is the last one I'm going to ask you about. You go with 100% utility negligence in Scenario A, and then you go 50% utility negligence in Scenario B. Is that correct?
Yes.
Okay, every other fire in Scenario B, was either 0%, and it had an N associated with it, or if there was any kind of negligence, you said it was 88%, correct?
That's correct.
Okay. And could you hand him the DPU's response to DR 4.21? Your Honor, so as to say the step, we know the next one's going to be another exhibit.
Yeah, let's go ahead and just pass them all out. Pass the rest of your exhibits out, I think would be good.
Actually, we could go ahead and do that. We've got them all. These are the others that you passed out. They're not marked, these are the numbers.
You can pass them out now, and then we'll mark them and admit them at the time they're discussed.
Yes, please.
One of the exhibits we're circulating is the document I think we circulated yesterday from the Oregon Department of Forestry, but we'll recirculate it.
We circulated and marked it yesterday, though, did we not mark it as a,
We did not mark it as an exhibit. I think we circulated it because we thought it would be an exhibit. Is that correct, or?
So yesterday, this was the one where before the proceeding, the company passed out their limits.
okay, okay, and we haven't yet admitted it? Okay, all right, good. Okay, great.
All of these that we're passing around now, the parties have, this is just like a courtesy copy of the resolution, if that makes sense. Except for the Oregon Fire report that came out yesterday.
So have you passed out all the documents you're gonna pass out?
Yes, sir.
Okay, so I count 5, is that correct?
I
that we
believe that's
should have
correct.
received? Okay, all right. Thank you for doing that all together. That, I think, will save us a little bit of time.
Sure.
When you get ready to talk about each one that you want admitted as a cross-examination exhibit, you'll let me know.
Okay, will do. So where we started, when we started passing out things, was the Beachy fire that's on Appendix 2, and you had 100% utility negligence in scenario A, 50% utility negligence in scenario B. And I'm going to ask you to look at what's marked as RMP cross-exhibit. Well, it's not marked yet, I'm sorry. I'm going to ask you to look at DPU response to RMP data request 4.21. You got that?
I do.
Okay. And I'll go ahead and ask that we enter this as an exhibit with exhibit number 4.
Okay, this has been proposed as Rocky Mountain Power's cross-examination exhibit 4. Is there any objection to it? The RMP data request 4.21 and response. Seeing none, it is admitted.
Thank you, Your Honor. And in this data request, we referred you to your Appendix 2, which we've just been discussing, the Beachy Creek attributions. And the response is, according to the National Council for Air and Stream Improvement, or NCASI, Labor Day Fires 2020 briefing note, the Beachy Creek fire was started by both natural causes, paren, lightning, close paren, and human causes, paren, negligence, close paren. That's a correct reading of your answer, right?
Yes.
Okay. And if you could look at the next exhibit, or that is this, this is the National Council for Air and Stream Improvement Labor Day Fires 2020 briefing note. You have that
I do.
before you? Was this the document that you referenced to your best of your recollection?
It appears to be so.
Okay. And would you agree with me that the NCASI is an association that's organized to serve the forest products industry?
Yes.
Okay. And its summary of the 2020 Labor Day fires, do you see where NCASI has a table, Table 1, that lists fire ignition sources either as human or as lightning?
Mr. Magnus, before you get too far in it, do you want to admit this as a cross-examination exhibit?
Let's exhibit number 5.
Okay, all right.
We've moved to admit this is cross-exhibit number 5. Thank you.
All right, the briefing note from NCASI has been moved to be admitted as Rocky Mountain Power's cross-exhibit 5. Any objection? Okay, now, the parties have all seen these in advance, right? Is that correct?
They were all distributed on Tuesday,
Okay, perfect.
except the Oregon Department of Forestry.
Which just
Right.
came out?
Just came out.
Okay, all right, okay, it is received.
Okay, they've had them since Tuesday. And in this briefing note, you see Table 1 lists the ignition sources for these Labor Day fires that they report on as either lightning/human, human, or lightning. You see that?
I do.
Okay. Would you show us where it characterizes the human ignitions as negligent?
It does not.
Anywhere in the document, right?
Not to my recollection.
Okay. Is there anywhere in this summary where utilities are mentioned as the source of the human-caused ignitions?
I do not see any.
Okay. And the foresters, in this briefing note, explain in section 2, I believe, that's entitled, "Why Here and Why Now?" Question mark. You see that?
I do.
And let me just read from it a bit. Start again. 3 primary factors contributed to the quick spread and high intensity of the 2020 Labor Day fires. First, significant late fire season drought created dry fuels in western Oregon. In the 2 weeks preceding the fires, evaporative demand drought index and energy release component, 2 commonly used measures of fuel dryness, reached the 98th and 90th percentiles respectively of 30-year normals. Second, smaller fires that were already burning throughout August and the first week of September, and new ignitions from human sources in the second week of September provided multiple opportunities for fires to rapidly propagate. And you agree I've read that correctly?
You have.
And then finally, it says, third, and most importantly, extremely strong easterly winds contributed to the rapid spread of fire and the large area burned in the second week of September. See that?
I do.
So would you agree that the forest products service industry group that published this attributed the fire most importantly to those easterly winds that came on the Labor Day weekend in September?
They attributed the propagation, most importantly, to those factors, yes.
Okay. And in addition, go back to RMP data request 4.21. You cited as your source the NCASI document we just looked at. And you said, additionally, according to Willamette Weekly, the Beachy Creek fire was originally caused by lightning. However, power lines started more of the fires. Is that correct?
Yes.
Willamette Week's a newspaper, right?
Yes.
Online newspaper? Okay, so you read, it was a newspaper article.
I am indeed.
What's that?
I am referencing that article.
Okay, but it's not a study, it's not a report of an agency, or it's a newspaper article, right?
Indeed it is.
Okay. I'd like you to look at what we've marked, what we have not marked, but we soon will, as cross exhibit 6. And that is, from the Oregon Department of Forestry, we've provided you a press release and then a report that was published earlier this week.
I think at this point, I'm going to object to the introduction of this report into evidence. This was just issued a few days ago. And if we're talking about the witness's analysis of this particular fire, he has not had an opportunity to include this as part of his analysis at all. So that's the basis of my objection.
Okay, if you want to respond to his objection before I rule on it.
I'm introducing this for the purpose of impeaching the witness and the credibility of his analysis, and the attributions of negligence to very particular fires identified in his testimony.
But this witness hasn't had an opportunity to include it as part of his analysis.
Okay,
I can ask him about that.
I appreciate what you're saying. The fact is the document was issued on, what was the date on it?
The 19th.
March 19th. So he would not have, it wasn't in existence before then. For purpose of impeachment and cross, I'm going to allow both exhibits to be admitted. We're going to mark them here in a second. And to the extent Mr. Kelly can respond to these, he will, and to the extent he can't answer the questions, that's, we'll have that in the record as well. So the objection's overruled. You want to mark the exhibits, and we'll, which ones are they? Which is
Mr.
which?
Chairman, if we could, the one page press release is called ODF publishes 2020 Santiam Canyon Wildfire Event Investigation Report. If we could mark that as 6. And then mark as 7, what we'll call Oregon Department of Forestry Santiam Canyon Wildfire Event Incident Investigation Report would be number 7.
Okay, we have submitted to us Rocky Mountain Power's Cross Exhibit 6 and Cross Exhibit 7. We've noted Mr. Griecu's objection. Any other objections that we need to consider before we admit these?
Mr. Chairman, I don't have an objection to add, but I would seek a clarification. Given the discussion, it seems as though the exhibit is being presented to this witness for purposes of impeachment, and it's been admitted on that basis. Is that the limitation of the commission's ruling on the objection and on the admissibility of this document?
That's correct at present. If an issue comes up later, we'll address it at that point in time.
Okay, and if it does come up later, then we'll address any other concerns I might have.
Okay, great, thank you. We'll receive them into the record.
Mr. Kelly, have you had an opportunity to review these documents?
No.
So when they were passed out to your counsel, you didn't bother to read them?
Are they in my possession?
They were in your lawyer's possession?
This-
That's part of why we passed them out? I
This
believe
morning?
so. No, yesterday. Doesn't matter. I'll just talk you through them. The press release, if you look at this third paragraph, the Santiam Canyon wildfire event is comprised of 19 reports of fire located within the protection boundaries of ODF's North Cascade District, 7 of which were originally caused by downed power lines, but determined to not contribute to the spread of large fires in the Santiam Canyon.
I'm sorry, I just want to make sure the witness has the document that you're reading from.
I'm sorry, if I'm in possession of it, I don't see it in my collection.
Do we not pass it out to him?
I thought we did.
It's got a Oregon Department of Forestry mark on the right.
You can have my copy.
Okay.
Thank you.
Is that the report as well?
He has the report.
It's Exhibit 6.
Okay, thank you.
The report is Exhibit 7.
Okay, thank you.
Sure. I think I even highlighted it for you, the passage I just read, which I think the part.
Wait just a second here. Would you say that again, Mr. Magnus? Because I think you said this was the press release and that Exhibit 7 was the report. Isn't that?
Is that correct?
Yeah.
Oh, I'm sorry. I've marked this document as the.
Okay.
That was my mistake. I apologize. All right, so it is the incident investigation report that's Exhibit 7. All right, thank you, thank you.
have both of those, Mr. Kelly, both of those documents before you?
I do,
Okay.
I believe.
And I bring this to your attention because it notes, and as that third paragraph in the press release, that 7 of the fires were caused by downed power lines, but determined to not contribute to the spread of large fires in the Santiam Canyon. The 7 ignitions were suppressed by residents and/or other fire personnel. And then if you look at the report, let's just go to page A12.
I might suggest, would now be an appropriate time to take a break and to give our witness time to review this report if he's going to be asked questions about it.
Is there any objection to that? I think that would be appropriate.
I think it'd be very productive. Thank you,
Okay,
Your
let's
Honor.
do that. We'll take a 15-minute break, be back here at quarter to the hour.
Thank you.
Examination.
Mr. Kelly,
Yes,
I believe we were looking at what's been marked as Cross Exhibit 7. That's the Oregon Department of Forestry Incident Investigation Report. Do you still have that with you?
yes, I do.
Have you had a chance to review it?
I have.
Okay. Let's start with page A1.
I'm just going to interject just one thing. So I think the record ought to know it's a 17-page document. We've been on a 15-minute break, and he has reviewed it, and those are the facts of the time he's had to review it. But that's just by way of observation. He's going to be able to respond to whatever he's reviewed in your questions. But I just wanted to point out that it is a somewhat lengthy document. 15 minutes has gone by. All right, so that's all. Thanks.
You know, actually, before we go to that page A1, could you look back at your Appendix 2?
Yes,
You've got the Beachy Fire listed, one of the Labor Day weekend fires, and we've discussed that a bit. And in your description, you say the original Beachy Fire ignited after a lightning storm that started a number of wildfires across the Cascade Range credit on August 16. Fire managers stated on September 10 that at least 13 new fires were started between Detroit and Mahama from down power lines during peak of a wind event in the days prior, that is the days prior to September 10th. And that's your description of the event, right?
yes,
Okay, so Beachy Creek fire started in August, then expanded into a much more devastating event in the Labor Day weekend. Is that fair?
that's fair.
Okay. And if you look at page A1 of Exhibit 7, the ODF report, just to make sure we're putting this in context, about the middle of the page, there is a quote, and it's attributed to, it looks like it's a U.S. Forest Service press release from 2020, right around the time of the Labor Day fires. It says, originally named the Beachy Creek Fire, it has been renamed the Santiam Fire, acknowledging that the Beachy Creek Fire no longer was the main cause of rapid fire growth, and it was instead fed by a series of small fires, largely caused by downed power lines and other ignition sources throughout the area. And that, you'd say, was pretty consistent with what you said the cause of the Beachy Creek Fire was in your analysis in Appendix 2, right?
That is consistent with what I have in the description of the fire.
Okay. And then the next paragraph says, part of the ODF investigation was to determine where fires started and the cause of ignition associated with those fires. Excuse me. Multiple fires were suppressed by rural fire protection districts that were reported by U.S. Forest Service as having been caused by power lines. And let me just flip to the next page. Page A2. ODF investigators did not find any evidence that reported power line ignitions had contributed to the overall spread of the fire in the Santiam Canyon. So as you understand what we're reading here, I guess now 5-year investigation by the Oregon Department of Forestry concluded that those additional fires that expanded Beachy Creek into Santiam were not caused by the down power lines. Is that a fair reading of their conclusion? The spread of the fire was not due to power lines.
That is not what it says. It says the investigators did not find any evidence that reported power line ignitions had contributed to the overall spread of fire in the Santiam Canyon.
Okay, so since they found no evidence, that is not consistent with what you say about the Beachy Creek fire, is it? That fire managers stated new fires were started by downed power lines.
Again, I'll object again, but he didn't have an opportunity to include this as part of his report, so I'll just note that objection again.
Okay, the objection.
So, I mean, of course, it's going to be different because he wasn't able to review the document before he conducted his analysis.
Okay, I understand that, the document's been admitted and to the extent that his review has been limited, I've already noted that that's a factor to be considered. This goes to weight, to whatever weight we give this, but we're gonna allow the questioning to continue.
Then I guess, second to last paragraph before that fire weather information says, the spread of the fires through the Santiam Canyon was primarily affected by the east wind event, which occurred on the evening of September 7th and morning of September 8th, 2020. That Nkasi document that you relied on in your description of Beachy Creek, when we were reading it earlier, didn't it say that the most important factor in the Labor Day fires was the strong easterly wind event? I read it to you, I think. It says there's 3 reasons. That was the third one.
My recollection is it was the most important factor in propagation.
The strong easterly winds contributed to the rapid spread of fire. I'm reading from the exhibit. You'd agree, that's what it says, right? I mean,
Yes.
You read it, okay. So the result of the investigation is consistent with what the forest industry was reporting about the 2020 Labor Day fires, as far as one of the main causes, right? That it was the easterly wind event.
No, the wind is not the cause of the fire. The wind is the predominant cause of the propagation of the fire.
Fair enough. Both the ODF report and what you cited in your testimony indicate that the biggest factor, it appears, in the propagation of the fire that became the Santiam fire from Beachy Creek was the easterly wind event.
That is what that report says, yes.
Okay. And I'm just, one more thing here, and then we'll leave the document. If I could ask you to turn to A12. These are the findings of the ODF investigation. And let me just highlight a few of them for the record, and we can discuss them. Number 4, the area in the Santiam Canyon where these ignitions occurred was a very high fire danger level. Number 6, the power to Gates, Oregon was completely de-energized as of 12:09:35 a.m. I'm sorry, 12:09 and then 35 seconds. 12:09:35 a.m. on September 8th, 2020. Number 7, ODF investigators determined 7 of the reported ignitions in the Santiam Canyon were caused by power lines, but did not contribute to the spread of the fire in the Santiam Canyon. Number 8, the investigators determined that the remaining ignitions were probably caused by firebrands from the fire in the Santiam Canyon. Do you know what a firebrand is?
I do not.
Okay. I will represent that it is an ember that flies through the air.
Thank
Okay?
you.
Okay. Number 9, ODF investigators found no evidence of power line ignitions contributing to the spread of the fire in the Santiam Canyon. Now, if you had seen these conclusions at the time that you prepared Appendix 2, would you have said that the Beachy Creek Labor Day weekend fire was in your 100% negligence category for the company? Still human caused, isn't it?
This is the most complex fire on the page in Appendix 2, I'll grant you that. If I had this information, I would reevaluate the yes and the 50%.
Okay, so the causation attribution that you make in Appendix 2 would likely have changed.
I did not say that. I would revisit.
You
I would
revisit it?
I would perform analysis to include this, and I might very well alter the content of Exhibit 2.
Okay. Mr. Chairman, I think I need to revisit the admission of this exhibit because Mr. Kelly has made an attribution of causation that blames the company. This document is an official document from the Oregon Department of Forestry that I would say contradicts He may say, question the attribution of causation that he's made. I think if the record's going to be complete on attributions of causation of fires to the company, this event report, which is an official document pulled down from the Oregon Department of Forestry, should be admitted both for its truth and as impeachment.
All right, let's see if there's any response to that. Go to the division first.
Yeah, I'm going to object in the sense that I think that they're talking about two different things. I don't believe that the witness is making some sort of legal determination as to, or factual determination as to whether the company was negligent and by what percentage they were negligent. I think it's an analysis in his experience as an underwriter that he would use to determine the amount of how these sorts of events would affect premiums. So the fact that he hasn't had a chance to review, and I think they're not talking about the same concepts in the same way, I would object.
Okay, Mr. Russell, do you have anything that you'd like to add, or anybody else?
Sure. I do object to the request to admit the document for the truth of the matter asserted. It appears that the company is seeking to introduce this document as a collateral attack on the James verdict itself, which I think implicates the issue preclusion doctrine, and for that reason, I think it's inadmissible. To the extent that all we're asking to do is introduce a document in response to some written testimony, I didn't object to that, but it seems like we're trying to expand the request to admit the document. And I think to the extent that we're trying to undermine the jury verdict in Oregon, I think it's inappropriate.
May I respond?
You may.
Number one, I didn't say anything about the jury verdict in Oregon, and that absolutely has nothing to do why I'm asking him these questions and asking for this document to be fully in evidence. That's not the purpose, that's not what we said. He addressed this fire and talked about a cause of this fire in his testimony. There is new evidence. I understand he didn't have this when he wrote his testimony, but there is new evidence from an authoritative source that contradicts, I believe, what he's saying in his testimony. So I think it should be introduced. And number two, to counsel's point for DPU, Mr. Kelly agreed that his testimony, the purpose of his testimony, he says, our aim is to estimate the portion of increase in excess liability premium from the 23 to the 2024 policy period, which can be attributed toward wildfire negligence. Of course he's talking about negligence. He agreed with me that that's the purpose of his testimony, and that statement was in his direct.
I think the purpose of his testimony, as I understand it, is his underwriting experience to offer an opinion as to why premiums increased for excess liability insurance. That's the purpose of his testimony. Is that your understanding?
Yes, Mr. Chair.
Okay. We have a record that has been established over several months. We're going to admit the document. We'll give it whatever weight we consider it to receive. We have this, as you say, this is not, you're not using this as a collateral attack upon the jury verdict in the James case. The James case verdict has not been overturned on appeal. It continues to be relevant, and so we're gonna admit the document for whatever purpose that we're not gonna accept this as this document represents the we're not represented, except with respect to whether there's veracity or no veracity to give to it. We're going to admit it as an official document that comes from the Oregon Department of Forestry, and that's the basis on which will be admitted. You ask questions, whatever you want to ask about that. If there's an objection to the specific question, we'll deal with that at the time. But the document will be admitted into evidence for whatever purpose that is relevant as the proceeding continues.
Thank you,
Okay.
Mr. Chairman.
All right.
Continue.
Yes, you may continue. I will note again, that I do think that while you can call attention to specific portions of the document, and he can answer the questions, or any witness can answer the question, there is the fact that we have a document that has not been able to be reviewed at length by any of the parties, just because of the circumstances of it having been issued 2 days ago, all right? And so that's, just, I'll note that on the record, and we can proceed.
Okay. Understood. Thank you, Mr. Chairman. And we already have it marked as, yes, ma'am, Exhibit 7.
Document, yes, cross Exhibit 7.
And I don't have any additional questions on Exhibit 7. Just to wrap up on your analysis, well, I was going to ask you to reiterate what you said at lines 919 and 920, which was the purpose of your analysis was to estimate the portion of increases in excess liability premium from the 2023 to the 2024 policy period, which can be attributed toward wildfire negligence. That is what you said, right? At line 919 and 920. I think we went over it earlier.
Yes.
Okay. And I think the way, as you've talked about it today, that you described what you mean by negligence is that, one, and I'm going to stop and let you answer. One, a claim was paid, correct? All of these involved some claim being paid, is that right?
They do involve a claim being made. A claim being made is not part of the definition of negligence.
Okay. And they involve claims paid on excess liability insurance policies, correct?
That's correct.
Okay. And so, once again, is the meaning you're trying to tell us negligence has in this document, in this analysis, that if an insurer paid a claim, there was liability, correct? You have said there was liability if they paid a claim. Is that your testimony?
The insurer paid a claim on the liability coverage of the policy.
Okay. And then the nexus over to the next step of negligence is what exactly? What makes a liability claim payment negligent for purposes of Appendix 2 analysis?
So we start with the assumption that it's a liability claim. And under the definition of the coverage of liability, the insurer will pay when the insured has become legally liable to pay. The policy goes on to allow the policy to pay defense and settlements where there has not been a legal liability, but the principal structure of the policy is when the company has become legally liable to pay. The predominant reason companies become legally liable to pay is when there has been some form of negligence. I'm relying on my history, my experience of thousands of claims. But the purpose of the legal liability language is the insured is legally liable to pay, and the insured is going to either indemnify or pay them in lieu of indemnity. Now, we could simply say, therefore, 100% of all the claims, every claim gets a 1. We just say every one must be negligent. It seems prudent to look to see if some of these claims are completely devoid of any human activity or signs of negligence. If we cannot find some presence of language related to something that looks like negligence, make it a 0, exclude it. For purposes of premium, we're talking about premium causality here, not any kind of legal evidence about the issue of negligence. But what would insurers look at this language and think, that's a loss related to
That's the
negligence.
language you wrote?
Yes, yes.
If the insurers looked at your description on behalf of DPU of what caused the fires, is that what you're saying?
If insurers had the information I had available, as I've written in the description, would they consider it? Well,
Well, let me, if I could just stop you there for a second to be sure we're clear on it. You looked at newspaper articles and other things you found on the internet, right?
absolutely.
Okay. All right. So is the company, I think you've certainly read Ms. Coleman's testimony, and I think you were here to hear her testify. Is the company legally liable to pay for any damages from the James litigation as of right now?
I cannot make a comment about a legal matter. I'm not a trained lawyer.
Okay, well, I think, did you read any of the testimony that James is not in the loss history of Rocky Mountain Power?
Absolutely have read that testimony.
Okay, so your premise around fires attributable to what you are now calling negligence in this not legal, not commercial way, seems to be relying on a claim being paid and the insured being legally liable to pay it, then it's going to affect those premiums. That's the linkage to the negligence here?
I confess I didn't follow your compound question.
Okay, so let's say, and the testimony from Ms. Coleman was that James is not in the loss history of the company. You understand that?
That is Ms. Coleman's testimony, I
Okay.
believe.
Do you assert that that's not true?
It is not in the paid loss history of the company.
Okay. And did you read Ms. Coleman's testimony that the company has not, cannot, and will not file claims on the liabilities in the James litigation?
I have read that.
Okay, so it won't become part of the paid loss history of the company, right?
It could.
Of the paid loss history of the
Yes,
company?
it could.
But right now, is there a legal liability to pay?
I can't say what the legal
Okay, but it's that legal
characteristics
liability.
of anything are. I cannot say what the legal qualification of anything is.
I think we all know this, Mr. Magnus is very experienced counsel, but we just need to be careful that we don't speak over the top of each other, so.
That was
maybe-
my fault, I'm sorry.
Maybe slow down a little bit, it would help all the way around.
Okay, to step back from the analysis a little bit, we talked about this a little bit before, but the company provided you information and discovery that you used to assemble your list of claims in Appendix 2, is that correct?
Yes,
Okay. And all of these claims, I think, in response to your discovery were, one, wildfires, right?
yes,
Two, they were claims over $250,000, correct?
yes.
Three, they were involved paid claims, correct?
I believe so, yes.
Okay. And if you're, and let's not, we're not talking about the company, we're just talking about you as an insurance professional, right? If you're working from a list of claims made against a company, aren't you always going to be able to find some source alleging that the company caused the damages? It's liability insurance. Aren't claims made by people who say, you're liable to me?
That is the essence of liability insurance.
So if anybody gave you a list of paid claims, it's not going to be real hard to like look on the internet or look at a plaintiff's complaint or something and find some evidence, some claim that the insured's at fault, right?
I can't characterize what internet searches would provide
Well,
on
that's what
other
you did.
topics.
You found internet, you found all this stuff in internet searches, right?
We were provided a vast array of documentation from the department, and we augmented that with independent research.
I guess they didn't, well, I don't think we, okay, thank you. All right. So let's turn to line 952 in your direct testimony. And I think you're going to find table 1, no, I'm sorry, table 5.1. And just let me know when you got it.
I have it.
Okay. Now, this table's entitled Figure 5.1, Scenario A, and that's the one with the 100% or 0% attributions of negligence, correct?
That is the one that identifies every claim as being related to negligence in some way. We give it 100 or a 1 or whatever. Or not related to negligence, we give it a 0.
Okay, so it's not 100 or a 1 or whatever, it's either 100 or 0, right?
Yes, for the sake of the calculation, that's how we've represented it.
Okay, so it's represented in Scenario A as percent due to negligence, 100%, or percent due to negligence, 0%, right?
That is what that says. That's an unfortunate shorthand title. What it would be better to say is the percent to which it belongs in the population of claims which have some negligence.
Some human activity cause.
The percent to which it belongs in the population of claims which have some negligence. One of the sources of negligence is human causation.
Okay, but you've defined negligence 2 ways, so I really got to be clear here. Is this negligence like commercial negligence, duty, breach, cause harm, or is this caused by human activity? Which one do you mean?
It is negligence which could give rise to legal liability that would suffice for an insurance claim.
Okay, now, could you tell us what Figure 5.1, I think I called it Table 5.1, it's actually Figure 5.1. Could you tell us what it's communicating to the commission? What's it about?
Yes. Figure 5.1 says if the insured had a 10% rate increase, which we believe, based on Fitch, is the market average for this particular year, of the remainder of their premium increase, what would be associated with losses that had some negligence and what would be associated with something else. And the percentages come from table 5.1.
And
So-
where's that?
It's in the preceding page.
Okay,
I cannot reference the entirety of that table. It is confidential, but the large percentage at the bottom accounts for the large bar in the middle, indicating that the majority of the premium increase, after taking into account the market increase, would appear to be related to losses which had some negligence involvement. And there's only a small remainder related to things other than losses that had negligence involvement if we use methodology A.
okay, and I appreciate you being considerate of the confidential issues. You can say the percentages. Again, it's just the dollar figures, I think, that are problematic. So,
Okay.
I'll say one. In Scenario A, you attribute 98.5% of the wildfire claims to negligence.
In scenario A, we attribute 98.5% of the premium increase after taking into account the market rate increase to being associated with losses that have some level of negligence involvement.
Okay, so that top dollar number, which we're not going to say, is that a BHE premium amount you received in Discovery plus 10%?
The moderately large number is the 10%, and the very large number is associated with the 98.5% number.
Okay, so the total wildfire claims paid above $250,000, is that, I just want to be sure I'm clear, is that comes from Appendix 2?
Yeah.
Right, okay, and that's just the bottom line of all these claims that were paid, correct? Okay, and then total
I did not say anything. Let me confirm what you've said.
Question back, please, so
Would you repeat your question?
Or if she can read it back.
I can repeat the question.
Okay, that's fine.
Just to be sure, we're still on table 5.1, okay? And I said that total wildfire claims paid above $250,000. The number there in scenario A, you could calculate that number if you just took all of the claims in Appendix 2 and added up the claims paid, correct?
It is present at the bottom of the Appendix 2, and it ties directly.
Right, okay. So then the total negligent claims, the number in that column for scenario A is, after you've done your work here on Appendix 2 and attributed everything to negligence, you attributed 98.5% of the wildfire claims to negligence, and that second number is what is that, correct?
Yes,
Basically 98.5% of the bigger number.
yes.
Okay. Okay, well, you were saying that fed into the
That
figure
figures
one where I
into
started.
That plays into figure 5.1.
Okay,
That 98.5% is what's used to explain the increase in premium, which is the purpose of this exercise, the increase in premium, which appears to be attributable to loss activity which has some level of negligence involvement, after taking out the portion of the increase associated with the market average, which is the first increase after the large initial bar.
okay. So the first, we're looking at figure 5.1, the first large initial bar, and we won't say dollar numbers, is that then that smaller bar that is the second bar in the,
That's the 10% number.
which was just a market adjustment you adopted on your own, correct?
Yes,
Yeah, okay. I mean, it wasn't anything that the company gave you in discovery or anything like that. That was your,
the source of that is noted on the footnote on the prior page.
terrific. Okay, then let's go to the far right. The biggest bar over there on the far right. What's
Yes.
that number?
That is the next policy period premium.
Okay, so you looked, so the first bar is 23 to 24 policy period?
The first bar is the 2023 policy period.
Okay,
The final bar is the 2024 policy period.
okay. The one that began in 2024, I guess.
I believe that's true.
Okay. And so we've identified that second bar, and then that 1, 2, 3, fourth bar that's very small. What's that?
That is the portion of the increase associated with neither the market rate increase nor losses that have some level of negligent involvement.
So that's the 1.5% of paid claims you decided weren't negligent.
Yes,
Okay. And then that middle bar, am I correct that that's the amount that you would attribute to negligence?
that is the
Correct?
amount of the premium increase
Yes, the premium increase.
attributable to losses which have some level of negligent involvement.
Okay. So, and that's about the amount that you would suggest be disallowed in this proceeding from the company's insurance expense?
Absolutely not.
Okay.
I
me
am
more.
not offering an opinion on how cost legitimacy or the regulatory categorization of a cost that is outside my field of expertise.
Okay, so you're saying that that's in your mind the part that's attributable to your human activity negligence analysis in Appendix 2. That's all you're saying?
What I'm saying is that using my experience and a methodology like this, I believe that it is reasonable to assume that the marketplace has increased premiums to an extent of this number associated with losses that have some or appear to have some negligent involvement.
Could we look on the, I think it's the next page, on scenario B in figure 5.2, and I think we can go through this quickly. That's where, you said, in every case in scenario B, the negligence attribution was 88%, except one, which is the Beachy Creek fire, which you designated at 50%. Is that a correct summary?
That is correct. We felt that the Beachy Creek fire complexity and dual ignition sources and other factors led it to be a candidate for something less than 88%, even without the benefit of the report that we have today.
Is it the only complex fire on the list?
It is the only one that we felt had the kind of complexity and ambiguity where the 88% would appear to not be appropriate.
Okay. Now, and that number, we see what that number is, and I'm not going to say it, it's that number in the middle. And I'll just ask you hypothetically, if you had found wildfire.org and its attribution of 40% human-caused wildfires first and decided to use it instead of 88%, that would cut that number about in half, right?
Yeah,
Pretty sensitive.
May I finish?
Yeah.
That number, which I said has, I believe, lower credibility and is also, I believe, 20 years dated kind of information, it's 1/2 of the 88% in the more recent document. So any number that you would use that is a source of the 44 would reduce this calculation proportionately.
And just as a reminder, if we could look back at that exhibit, when you say it's dated, I'm sorry, I don't have the exhibit number in mind, but it's this document here, Human Exhibit 3, Cross Exhibit 3. When you say it's dated, this says 40% were determined to be human-caused from 1992 to
Yeah.
2020.
Right.
So
So this goes back to a very long time ago.
Uh-huh.
And
That makes it less reliable?
if there have been I accept the testimony of other experts that have been here that have been significant changes in wildfire ignition patterns over the last 2 decades. I'm not, but I will not say that I am an expert in that matter.
Okay, let's go to line 985.
Yes,
Okay. I'm sorry, in direct testimony.
I have it.
You say, and again, the numbers in this paragraph are not confidential. In fact, the $210 million was an original company request in this docket. So I'll say that, and I think this is one of the sections that's been de-designated. So one time only, we'll say dollar figures in the discussion. So you say here, combining this analysis, and when you say this, I'm assuming you mean the 100%, 88%, figure 5.1, figure 5.2 analysis. Is that the analysis you mean?
The work that's done from line 835 up until this point.
Okay. And I think that is the figure 1, figure 2, 5.1, 5.2 analysis we've been discussing, isn't it?
That is, the things we've been discussing are in that section. That's correct.
Okay. And those are derived from Appendix 2 in part. That's the discussion we've been having for some time, right?
Absolutely.
Okay. So you say, combining this analysis with the preceding analysis, one may reduce the cost pool from its $210 million, as noted in the companion actuarial expert testimony. What is that?
That will be the testimony of Mr. Gleba.
Okay. To arrive at an alternative cost pool of $164 million. That is, the original $210 million less $46 million. Then applying the adjusted allocation percentage, and I know that's in Mr. Gleba's testimony. It was 14.3%, now it's 18.6%. We'll get to that with Mr. Gleba. The cost amount that would be allocated to Utah for a non-negligence influenced excess wildfire liability insurance cost would be $23.5 million. I read that right.
You read that correct.
So is that your recommendation, that the commission make those exclusions from the real-world number of, it's now 185.7 in the record, but it was 210 million when he wrote this, I think. Are you recommending that the commission make that adjustment based on your analysis?
My analysis does not make a recommendation of a financial nature to the department, or the commission, pardon me.
Okay. Now, I'm going to take you back, unfortunately, to the front of your direct testimony. At lines 78 and 80. Just let me know when you got it.
I am there.
You there? Okay. You listed one of the purposes of your testimony as, and I'll quote, "to determine whether the company's various insurance programs are prudent and in the public interest." Did I read that correctly?
That's correct. You read a fragment of a sentence correctly.
Okay, well, is it correct that one of the purposes of your testimony was to determine whether the company's various insurance programs are prudent and in the public interest?
FTI, my firm, has been engaged, as I said in my opening statement, to provide underwriting and actuarial insights into these matters from an insurance perspective. We aren't bringing forth a regulatory expert or a legal expert. And the actual proposal of the costs, which are just and reasonable, are for other people to propose.
Okay, so when you're talking about the purpose of your testimony and you say the audit plan, I'm assuming that's your testimony and Mr. Gleba's, must be sufficiently comprehensive for FTI to determine whether the company's various insurance programs are prudent and in the public interest. I'm just asking you, did you make a determination about whether the company's insurance program is prudent and in the public interest?
No.
Okay. And I think you said in your summary, but you said it in your direct too, that as in your career as an insurance professional, you advise or have advised power generation and other utility type companies. Is that correct?
That is correct.
Okay. So hypothetically, if you had a client who was faced with the choices that the company had to make in 2023 when its insurers came to it with its renewal, would you have told them to buy the insurance?
I have not prepared an answer in advance for this question, so let me compose.
That's why I ask it. I'm just kidding, I'm sorry.
So the circumstances the company faced at this point in time were a dramatic increase in its premiums in the midst of a market which itself was dramatically increasing premiums. I certainly would have asked, if I were in the chair of the risk manager or advising the risk manager, those are the conditions which I would have insisted the broker or my own team to perform extensive analysis on alternative structures, extensive analysis, including multi-year components, cost controls, cost guarantees. Second event that covers, there's a huge number of things that one does because you are potentially at the pinnacle of cost pressure. So I certainly would have encouraged the broker and the forces that were supporting me to look at a lot of other options. I don't know if they did. I don't know if that's in the record.
Well, I think you heard Ms. Coleman talk a fair amount yesterday about the choices they were faced and what they heard from insurers. So I'll just ask you again, let us assume that they did due diligence, an adequate investigation, and considered other alternatives. Would you have bought the insurance or not bought the insurance?
I mean, in essence, it's asked and answered already. He gave an answer that he would consider all the available options. That's assuming that, his question is assuming that the company did their due diligence and is hypothetical, which I don't know how much use that is to the commission.
Okay, do you want to respond to that, Mr. Bangus?
Well, yes, I think the question of whether the company was prudent in purchasing that insurance in 2023 and 2024 is a pretty important question. And Mr. Kelly said in his testimony that that was one of the things he was hired to talk about. So I'm just asking him, in the role he plays in his real life, a client comes and asks for that advice, would he have bought that insurance, or would he have said, no, I'll go without it? What was the prudent decision to make, given what they were facing? That's what I'm asking. If he can't answer, he can't answer, but,
I think he answered the question already.
okay. I heard him say that he would tell them to do a lot more investigation, and I guess I followed up by saying, let's say they did. But I can leave it there, that's fine.
Oh, okay, all right, let's
All right.
move on.
Okay. Thank you, Mr. Kelly, that's all I have.
All right, does any other party have questions to ask Mr. Kelly before we return to the division for redirect? Anybody? Seeing none, I'm not gonna run down the line. I think we're gonna try to save time here. So we'll return to Mr. Grecu for redirect.
Thank you. I do have some questions for you. I'll try and sort through my notes here. I think first, I think you were able to partially answer this question, but I don't think you were able to give a full explanation. And referring to your appendix 2, there's a whole lot of questions. And that sort of flows into table 5.1, is that correct?
Yes.
Can you, well, first, can you, can you describe more fully what that analysis entails? And I'll leave it at that.
The company experienced a significant premium increase over and above what the marketplace was seeing, it appears. The question put before me was, to what extent is that increase likely to be associated with losses that involve some negligence? Now, these are paid losses on liability coverage. But this is not a straightforward analysis. It requires constructing some type of methodology. In scenario A, we look at the facts and circumstances of each individual loss. And based on the narratives that we can obtain, determine, is there a reason to not include this loss in the population of negligent losses, which are the kinds of losses that are paid on liability. And many of these losses have absolutely no, some have absolutely no documentation, language, or anything that we can find that indicates that there is negligence. So it doesn't belong in this population. We put a 0 there. Then other losses, there's some language, some facts, some circumstances that indicate there was likely to be some negligence present. That loss goes into the population of negligent-related losses. For the sake of calculations, we're going to put a 100% there so we can determine what percent of premium is associated with these losses. It doesn't say that it's 100% negligence. It just means this is one of the losses that has some negligent character to it, it appears. And we summarize the two of those and use that as one measure. And we aren't offering that this is a legal finding. It is reasonably connected to how insurers and underwriters look at it, reasonably so, including the use of extemporaneous information. Now in scenario B, we take a completely different look at it. Remember, we're starting with only liability losses. So the assumption is it's 100%, it's full of negligent claims. But let's get rid of scenario A and ask a different way of thinking about this. Across the nation in recent years, how many losses are involving human beings? It's an alternative way to think about it. Human beings should not be starting wildfires. A naturally occurring wildfire shouldn't involve human beings exacerbating the wildfire. So, again, we look at the facts and circumstances and we say this is not a wildfire involving human beings, 0. Or if it is, we put the nationwide statistic of 88% there. Unless there's something really odd about this loss, something really ambiguous, and we found one, and said 88% seems a little bit rash for that one. There's a lot of naturally occurring forces. In fact, there's multiple fires that are conflagrating later on in the process. Kick it down to 50. Admittedly, it's a judgment, right? Because it's going to be paired up against the alternative methodology. Anyways, when we did these two independent methodologies, we came up with two numbers that were roughly comparable. As one would expect, if you're going to have your premiums affected by the losses you've paid, and we're talking about liability premiums, most of those premiums will be related somehow to something involving negligence, as we would expect.
And just to clarify, so in that Appendix 2, you're not intending to conduct an analysis to determine to what specific amount the company was negligent with regard to those wildfires?
None whatsoever. It's a explanation of the extent to which the presence or absence of negligence in certain fires is associated with the unexplained premium increase after taking into account the market increase.
And moving on just a little bit, there was lots of questions referring to the different fires in that Appendix 2. Are there situations where if a fire is caused by utility equipment, for instance, if a power line is down by a fallen tree, could there be situations in where that conduct or that cause is would be attributed to negligence, and in this very same type of situation would be not negligent?
I can speak from experience as an underwriting person who sees a lot of claims. I cannot speak from a legal standpoint. You can have a downed power line from a fallen tree result in a moderate amount of loss, let's say where vegetation has been properly managed. And one would say there's no negligence with that. A fire does ensue, some damage happens, but no one is going to be found negligent. The exact same tree and the exact same power line falls on a meadow or an acre of land whose vegetation hasn't been managed for 12 years. Possibly, in that case, the fire that ensues would be associated with negligence.
And the company's counsel noted that Ms. Coleman yesterday stated that the James verdict is not in the company's loss history, correct?
The company's counsel did make that note.
Does that mean that an insurer would not consider that event at all when setting premiums?
Insurers would definitely consider that event when setting premiums. In the appendix to her testimony, I believe, she presents the excerpt of an underwriting guideline and manual. And indeed, there is one place where the paid loss history is brought in, and losses which are not paid would not include things like the James Fire. The rest of the narrative includes, as I would expect, at least 7 different places where judgment would be involved. The two I draw attention to are the loss rating and the exposure modifier, as I would expect would be there. The second thing I would say is this is not the underwriting manual of that company. This is an excerpt. It self-describes the fact that there are aspects of the document in the underwriting process and the underwriting guidelines which are beyond this piece of correspondence. As an underwriter, I would take that into account, and underwriters that I know would definitely take that into account. It is in my written rebuttal an explanation of how they would take that into account with respect to frequency and severity analysis, which I could give an overview of, but my colleague, Mr. Gleba, could give a much more detailed explanation of.
Thank you. I want to draw your attention to 2 of the cross exhibits. If you could look at RMP Cross 2, it's the National Interagency Fire Center Wildfire Investigation is at the top of it.
Yeah.
And if you could also look at RMP Cross 3, which is this document here that has the map of Utah and shows the 40% at the top. First, I'd like to look at cross number 2. And it's in the second paragraph, and this is what you used in your analysis. And just confirm I'm reading this correctly. It says, as of 2023, the 10-year average of human-caused fires account for 88% of all wildfires nationally. Is that correct?
Yes, that's what it says.
So can you explain, like, what time frame is that? That would be from 20?
That would be, as of my reading, it would be from 2014 to 2023.
And now if you go to cross number 3,
I think so.
at the very bottom in small print, it says data sources. If you read over to near the end of that line, what are the years that are provided for the data sources?
They are 1992 to 2020.
So that's not the same time period, correct?
That is not the same time period.
And could you explain why that might be different? And if the 88% is based on more recent data?
There are two differences. They're obvious. One is the entire nation. Many, many, many sources of ignition fires. This is a smaller data set, just the state of Utah. The second is that this is based on a period of time that is more recent and is not based on the long ago period of, say, 1990, to the extent that there are any exogenous factors, as some experts have testified, such as climate change. This is more likely to be commensurate with the current time that we are living within. And the more recent time period is what insurers use. They use something called time dependency in their underwriting and pricing. So they would heavily discount old data on small data sets, and they would overweight large data sets that are more recent, hence the word credibility.
And based on your professional experience and from your reading of, I believe, many of the parties' testimonies in this phase, has wildfire risk increased in relatively recent years?
Yes.
Would you say it has dramatically increased from possibly 2014 to 2025?
It's one of the most significant sources of increased loss that we see. And we believe, underwriters believe, it is on a trajectory to continue to increase. I believe echoing what other witnesses have said.
If I could have just a moment to make sure that's all my questions.
Sure.
That's all my questions. Thank you.
Okay, I just want to state, Mr. Kelly's been on the stand for over 2 hours, so we had estimated his time would be, for cross, would be about 45 minutes. I know, Mr. Magnus, you will not rehash the cross-examination you've already conducted, but if there's other recross that you have of this witness that, as a result of what came up in Mr. Graycue's redirect, please let me know. Do you have any other recross?
I do not.
Wonderful, thank you. Okay, we'll go to Commissioner Harvey.
Thank you for being here. I'd like to go kind of all the way back to where you started your summary, and make sure that I understand a point. Actually, sorry, it wasn't, it was right after your summary, the very beginning of the cross, that I understand this point. It seemed to me that you were saying that with respect to whether or not claims would be paid, insurance companies just essentially looked at the contract and didn't worry about legal liability. Is that, am I getting that right or wrong?
If I said that, I did not mean it. The insurance companies do not look at fault or causation or negligence. If a company is found to be liable for whatever reason, the liability policy will pay.
Okay. And then you contrasted that with what would happen at a renewal when the policy itself was up for discussion. And at that point, you seem to imply that the companies would look at a much broader. Okay. So that in terms of whether we're using the terms liability or negligence or cause or care, the analysis would be different in those two situations.
The policy is a critical legal contract, is a contract between the parties that must be relied upon. And when it comes to the renewal, the underwriters, people such as myself, will look at the losses, the exposures, and the human element. Those are the three main things you look at. If you've had a loss which involves some behaviors, there are places in the rating algorithm, typically, where you would modify what's called the human element factor. Human elements, for instance, if we were insuring this building and every fire extinguisher had things in front of it, storage or something like that, we'd say there's bad human element here, and your rate would be higher. So underwriters look at the behavior of companies and make modifications in their algorithms to historical losses. Are they applicable? To exposures, are they changing? And to human element, does it appear up to industry standards?
Okay, thank you. And I think you've mostly answered the next question, but just if there's anything else you want to add. Is there anything that prohibits an underwriter insurance company from using any information that they come across through any means in deciding what prices and at what, or deciding what policies and at what prices they're going to make an offer to a potential insured client?
There are limitations, but they are few and far between. You cannot use prohibited characteristics to write an insurance policy if a person is a member of a certain class, race, or whatever. There are promulgated certain restrictions, but they are very few and far between, and none are related to this case.
Okay. And then turning to the table 5.1 and the 5.2 that were discussed, just turning to them in the sense of we're going to talk about them, but I'm not going to ask specifics. I'm just asking what they are. Was your intent there to separate out what was happening at an industry level in terms of what might be driving cost as compared to a company-specific driven causes? Is that a way to think about those tables?
Yes.
Okay. And then, if I could have you turn to the Cross Exhibit 7, the report. And page A2. I'm sorry to make you do this, but I just want it out in the record. The first two full paragraphs at the top of that page, one starts with ODF's investigation was.
Mm-hmm.
Could you read those two paragraphs into the record for me?
ODF's investigation was impeded and delayed because the USFS would not allow their employees to be interviewed by ODF. The investigators were only provided with written statements from USFS employees, the last of which was received in July 2024. And the investigators were not allowed to interview them in person. ODF was unable to analyze electrical equipment and power line hardware in the Gates Mill City area. This was due to Pacificorp and their contract crews' work of repairing and restoring power, including the removal of damaged electrical equipment. The specific items and quantity of hardware removed is unknown. The potential evidentiary value of this equipment is unknown as well.
Thank you. And then on page A10, going to A11, there's a section that is labeled interviews. Do you see that?
I do.
Is there anywhere on the list of agencies or people or companies that were interviewed that that Pacificorp or any of its divisions were interviewed that you can see on that list?
I see none.
Okay, thank you. That's all the questions I have.
Commissioner Clark.
No questions, thank you.
Okay, Mr. Kelly, I don't have any other questions either. Appreciate your traveling here from the United Kingdom. I think that's a long way to travel, and appreciate you being here, and you're excused.
Thank you.
Okay. Well, Mr. Glebe is next on the list here. If we go down the DPU witnesses, and you can leave. I mean, it sounds like I'm not kicking you out of the room. You just don't have to sit on the stand any longer. You're free to do whatever you'd like. Thank you, though, very much, Mr. Kelly. That was very much appreciated. It just, they may be referred to by others, so just let's leave the is it- yeah. I don't know whether they will or not, but thank you. Okay. All right. What's your preference here? We can, I hear people grumbling that they'd like to go to lunch. I'm worried we need to pick up the pace a little bit, so let's break for lunch. We'll be back here in 1 hour and start with Mr. Gleba. Am I pronouncing that correct? Yes, that's correct. Okay, Mr. Gleba. Okay. All right, we'll break for lunch. We're going to be in recess. On the record, we'll continue with the division's next witness. Maybe the witness isn't here. Okay. Yeah, that's fine. I'll raise this one issue now. With respect to witnesses that are scheduled for next Tuesday and Wednesday. As you know, on January 10th, an independent evaluator that was retained by the commission issued an independent evaluation of the wildfire management issues. And I want to see if any party has an objection to the report being admitted into evidence. Is there any objections on that?
I'm not having.
I'm looking at Mr. Moskin.
No objection on our side.
Okay. All right. We're gonna admit that now. So then the next question is whether you have any questions for that principal author of that report, or whether the report will speak for itself, whether you, because it's not listed, his name is, why am I drawing a blank? Andrew, what's his last name?
Well, I'm missing a page from
Andrew Dressel. I wish the pause didn't show up on the record, did it? Okay.
Chair, I had one clarifying question. Is the independent evaluator available for cross-examination?
Well, that's what I'm trying to find out. He could be if necessary, but if, just trying to find if you've got any questions of him or not, because I would want to let him know today if he needs to be present for one of those days of the hearing, so.
Can we let you know at the end of the day?
Yeah, that's fine. You can let us know. So we've got the report admitted. I don't need him here for foundation to get the report admitted. You're all okay with that. But if you want to ask him questions about the report, Andy Dressel, I don't know why I had a brain block, but let us know and we can arrange to have him here. Okay, is Mr. Gleba, he is here. All right. Go ahead.
The division calls Mr. John Gleba as his next witness.
All right. Mr. Gleba, welcome. You raise your right arm to the square. Do you solemnly swear the testimony you're about to give in this matter pending before the Public Service Commission of the State of Utah will be the truth, the whole truth, and nothing but the truth, so help you God? Thank you. You may be seated.
Good afternoon, Mr. Gleba.
Good afternoon.
Could you please state and spell your name for the record?
It's John Gleba, so it's John. Gleba's Gleba.
And by whom are you employed and what is your position?
I'm employed by FTI Consulting, and my title is Managing Director.
And what is your business address?
200 North 2nd Street, Madison, Georgia, 30650.
And have you participated in this docket on behalf of the division?
I have, yes.
Can you briefly describe the scope of your participation in this docket?
So my firm, FTI, was engaged primarily to provide underwriting and actuarial expertise in Phase 3 of this rate case. In particular, I sort of had somewhat of a narrow focus, so I'm an actuary by trade. Insurance is my life, for better or worse. But I was primarily looking at the allocation of insurance premium from Pacific Corp as a whole to its individual jurisdictions based on actual principles. So I realize there are other factors and considerations involved, but based purely from an insurance actual principles, that's really what my focus was.
Have you provided testimony to this commission before?
No.
Can you provide a brief overview of your education and relevant experience?
Yeah, so I work for FTI Consulting. I am a consulting actuary. First thing I want to point out is I am a credentialed actuary, so I'm a fellow of the Casualty Actuarial Society. I'm also a member of the American Academy of Actuaries. And then related to that, we do have specific qualification requirements to practice every year, so I am up to speed on all my continuing ed and all my qualifications. So I am actually qualified, as we sit here today, to render the advice specific to the actual topic we're going to discuss. Over the past, let's say, I've been in the industry for 35 years. 30 of those have primarily been a consultant, but I've worked with a wide variety of entities, like insurance companies, large self-insureds, state regulators, insurance companies. I do a lot of public speaking, so I do a lot of work with actual committees doing volunteer work for professionalism and topics related to that nature. So I have a long history of actuarial services in this arena.
And did you review the company's filed application, amended application, exhibits, and testimonies in this docket, as well as the filings from the other parties?
I did.
Have you also reviewed responses to data requests?
I have.
Did you prepare and cause to be filed your Phase 3 direct testimony, rebuttal testimony and attachment 1, and surrebuttal testimony in DPU Appendix 1 and DPU Appendix 2 in this docket?
I have, yes.
Do you have any changes or corrections to those filings?
Not at this time.
If I asked you the same questions posed in that testimony today, would you provide the same answers?
I would, yes.
Do you adopt your pre-filed testimony as part of your testimony today?
Correct.
That's why I'd like to move to admit Mr. Gleba's testimonies and associated exhibits.
Okay, is there any objection to the admission of Mr. Gleba's direct rebuttal and surrebuttal testimony and exhibits thereto? Seeing none, they are admitted.
Thank you. Mr. Gleba, do you have a summary to share today?
I do, and in the interest of time, I'll try to keep it relatively short. But I do want to, so as I said, I'm testifying on behalf of the DPU, and we're looking at specifically the allocation methodology of the premium for Pacific Corp to the various states. I'm sorry?
Yeah,
Okay.
so you take your time to get out what you need, but the important thing is she can only take down the transcription at a
I understand.
certain speed, so you need to slow down a bit.
So, as I said, the purpose of my testimony today is I want to address the allocation methodology used by Pacific Corp to allocate a portion of its excess liability insurance premium, which includes wildfire liability, to Utah ratepayers. So I understand that currently Pacific Corp allocates these premiums using an agreed-upon formula, which is based on a formula called the 2020 protocol, using a factor called system overhead, or SO. And I don't believe, in my actuarial expertise, that this factor fully reflects the risks associated with the underlying premium. So because it's my understanding that the SO factor is primarily an exposure-based factor. And in fact, if you look at what the SO factor is used for in the 2020 protocol, most of it are sort of general expenses, administrative expenses. There's revenue in there, there's working capital. So I get that insurance premium is in there, but if you were actually to sort of parse it out, I do think the insurance premium component can benefit from a more thoughtful analysis of the underlying causation. So, when I look at that and I look at the insurance premium in this case, and this case is unique because the premium is significant. It's not, something to sneeze at. It's a relatively large amount. So I think because the dollars are so large, it does behoove us to sort of look at a more thoughtful analysis of what are the underlying risks associated with that premium. So what I've done or tried to do in my direct testimony, and I'm sure we'll discuss a lot of this, is to try to come up with an alternate method of allocating that premium that, in my opinion, is and I hesitate to say better, but it's a way of allocating the premium that would more fully reflect, I think, the causal underlying risk of the premium you're trying to allocate. So what ends up in my testimony is, and we'll get into how that happened, but I end up with a allocation factor of about 18%, and the current factor would be about 44%. So all other things being equal, I'm just saying purely actual principles. The allocation factor seems like, based on the information I have, would be less than if you just use the SO factor. But I do think, and I'm not naive, I do know that there are other considerations. So I kind of consider that maybe the high end of a range, because I know it doesn't consider things like legal environment. So for example, we've talked in the last few days about Senate Bill 224 and the cap on non-economic damages and how is that going to affect premiums. And so, I'm not an attorney, and I have not done an in-depth analysis on what the impact of Senate Bill 224 is, so I can't give you a number, but I do think reason says it probably should be something lower, because we're expecting less liability than we would have had absent that legislation. So when I do my allocation, I come up with a number, and then I'm sort of saying, okay, and now that's not the end of it. There's more, but any further adjustments would probably be downward from there. I do want to say, a couple things. And one is, I'm an insurance guy, and we've talked a lot about insurance, and I get that probably most people in this room are not insurance, don't have a lot of insurance background. So there's been a lot of terminology and words that have been thrown around these last few days, and I want to make sure we understand what they are, what they mean, and what they don't mean. And so one of the things I want to clarify, and we can talk about it later, but is this idea, a lot of people have said in the last few days, Utah has a high probability of wildfire risk, right? And then so one witness has said it's high, I say it's low, it's confusing. Well, when you say that, I think you have to qualify, what do you mean high probability of risk in terms of what? So one way to look at that is say, okay, if I'm just worried about the number of wildfires that occur, just the number, I could say, okay, yeah, Utah probably has a lot of wildfires. Big state, a lot of geography. And in relation to, pick a state, Maryland or Michigan or whatever state you want to pick, it probably has a higher wildfire risk of wildfires. That's true. But when I look at it, and when an insurance company looks at it, they're not looking at just the number of wildfires. They're looking at what is my potential cost? What are the damages associated with that wildfire? So a wildfire that occurs in a highly populated, like East Coast state, is probably going to be more from a cost standpoint and damages than a wildfire that occurs in Utah, somewhere in the western Utah in the desert. So when you say high wildfire risk, what do you, I just want to say, when someone says that to you, Utah's a high wildfire risk, the first question you should say is, risk of what? In terms of what? Because it's really important to make sure that you are all on the same page. We're throwing a lot of these words around, where it's high, no, it's low, no, it's, so in relation to what? So, yeah, Utah is a high wildfire risk of wildfires, correct. But if you look at where Pacific Corp, the 6 states that they operate, and all those 6 states have high probabilities of wildfires occurring, but if you overlay that with the actual damage estimates to say, okay, if I were an insurer, what would be my cost, what's my out-of-pocket cost for those wildfires? Utah, of those 6 states, is the lowest, and that's, at least the information I have has shown that. So that's one thing I just want to make sure we all kind of are on the same page, because I've heard that the last few days, and I think it probably needed some qualification. The other thing I've heard the last few days is people talk about loss history, paid loss history, what should be in it, what should not be in it. And I just want to clarify that when an insurance company goes to, and by the way, at the moment, I'm just talking generally, so I'm not talking about utility companies or this case specifically, but I'm talking very high generics. But when an insurance company goes to price a policy, their starting point is they have to come up with they say this is, what is our expected loss of this policy? So given whatever the limits are, the terms are, what is our expected loss? And that's sort of the starting point. And that's what actuaries do, right? So that one of their roles. So they would come to people like us, like actuaries, and they would say, okay, okay, Mr. Gleba, we want to write a policy with a 10 million limit. This is the coverage we have, whether it's GL, wildfire risk, workers' comp, whatever it is. And we would use our knowledge and our expertise and whatever resources we have to come up with an expected loss. Now you say, well, how do you come up with that expected loss, right? So there's really two fundamental components to that. It's either there's a frequency component, meaning how many claims do we think are going to occur? So we have some way of estimating that. And then given a claim occurs, what is its average value? We call that severity. So frequency times severity would be what we call loss cost. And then once you know the loss cost per unit of exposure, and then you know what your exposure is, you add it all up, and then you say, this is my expected loss for the policy. Now, is that the end-all to be-all? No. But there are other adjustments after that. But here's the thing, is in order to get that expected loss cost, we are looking at not just paid claim data, we're looking at all the loss data. So, like, when an insurance company has a claim, okay, when they become aware of an event that might give rise to a liability determination where they would be forced to pay, okay? They have to set up usually they have to set up what's called a reserve, because there's accounting guidelines that say if you're aware of a liability and you can reasonably estimate it on your balance sheet, you need to do so. So one of the ways they do that is a concept of a reserve amount. So a company a wildfire would occur, and they would say, well, we haven't paid anything yet, and we may not pay anything for a while. But we do have an estimate of what we think the damages might be. And so they would put up a reserve on that, okay? So when you go to look at an insurance company's claims history, you will see not just paid amounts, but you'll see reserve amounts, which is, and those reserve amounts will change over time as more facts come out. And then eventually at some point, you'll pay the claim and you'll be done. So actuaries want to look at not just paid claims, we want to look, and insurance companies will not look just at paid claims, they will look at all claims. And they're not going to focus on claims, just on claims reported to them or claims in the layer. They want the entire loss history. They want every claim that occurred. I don't care if we paid it or not, or you reported it to us, or we think we might have coverage. The entirety of everything that occurs is what we call loss experience. And that's something that's what the insurance companies use. So it's not just, oh, well, if I don't pay a claim, it doesn't count. It doesn't quite work that way, because there's other estimates of what that potential liability could be. I don't know if that makes any sense, but so with that, I think that those are only two things I sort of wanted to clarify.
Thank you. The witness is now available for cross-examination and questions from the commission.
Okay, thank you. Let's turn to Rocky Mountain Power.
Thank you, Mr.
Cross-examination.
Chairman. I appreciate you talking through some of the lingo, because one of the things you said in your, I guess it was your bio, you talked about the actual issue in the case. When you say actual issue, do you mean like in an actuarial sense issue, or like the real issue? What does actual mean to you? Is that an actuarial term, or is that just like we normally use it in day-to-day conversation?
Can you clarify what context
you said you had all your certifications up to date and you were qualified to
Oh,
testify the
yeah,
actual
yeah.
issue in this case.
Well, what I meant was did I say actual? I think I should have said actuarial.
You may have. I just wanted to be sure I didn't
think it
hear
said
it wrong.
actuarial.
I've learned a lot of new words the last.
It sounds like actual, but I think
Okay, gotcha. I want to start with your Phase 3 rebuttal. And I've passed out the exhibits we plan to use in the cross-examination. And I want to talk to you about Table 4.16. And so the first exhibit you'll see there is not really an exhibit. It's two things that are in your testimony. So you'll see the top of this document, is Table 4.16 from your direct testimony. The bottom is Table 4.16 from your rebuttal.
Yes.
And you can check them if you like, but do those look about right to
Yes,
discuss?
those look correct, yep.
Okay. And is it, I guess, in your rebuttal, I believe you said at line 25, that you were making a change, this change that we can see in table 4.16, where all three of the columns change, correct?
Well, yeah, because the first column is what actually changed, but the other two columns were calculations based on the first column, so those were all,
Okay.
yes.
So, and I think what you, let me know if I'm summarizing it right, it's pretty straightforward. You said that you had a calculation of market share, you see that column, market share, that the company, that Rocky Mountain Power, has in each of its 6 states. And I think what you meant by market share was like looking at the proportion of customers in a state that the company had.
Well, so how we got that number, market share, was we looked at the number of households in a state, which we got from like an industry-wide search, a Google search. And then that was the denominator, and then the numerator was the number of households served by Rocky Mountain Power. So it's not perfect, but it's just a proxy for what is the market share per state.
And then in, I think what you said in your rebuttal is that you got some data from the company's website, or you found some updated data, and so you made the change in your market share calculation. Is that correct?
Correct.
Okay. And some of them change, some of the market shares change pretty substantially. California went from 3% to 0.3%, for example. And I just want to point out, I mean, the Utah market share didn't change a whole lot based on your change in rebuttal, right?
Well, you're correct.
Okay. And then, just to sort of sum it up, this was where you changed your recommended allocation percentage for Utah from 14.3% to 18.6%. Correct? Okay. And so, from now on, we'll talk in terms of 18.6%, because that's your final number, correct?
Correct.
Okay. And I think as you already noted, the adjusted index relativity number also changed.
Because that's a factor of market share.
Okay, so did the adjusted relativity index figures, are those derived from data that that FTI obtained from Verisk?
Yes, correct.
Okay. And let's go to your direct testimony at line 1377. I believe it is.
Okay. I'm there.
Okay. You say at 77, 78, therefore FTI obtained industry data on wildfire risks from Verisk, a nationally recognized data analytics firm. I read that correctly, right?
Correct.
Okay. And then you go on at line 1385, and I guess over on to the next page, and you say Verisk uses a wildfire model that simulates 10,000 possible wildfire scenarios, or iterations in parentheses, by state, and compares this to an industry exposure database, parens, representing value at risk, such as residential buildings, commercial buildings, personal property, and business interruption exposure, close paren, to estimate the total potential loss values. These values are then used to estimate expected wildfire probability curves. And that from your perspective, describes the Verisk wildfire model and how it
It's a very
put
broad
together.
explanation, but yes, I was trying to keep it a little high level, but yes.
Okay. And if you'll look at the next exhibit after this summary sheet, which we could mark as cross exhibit 8.
Right.
I think you'll see this is a document dated March 7th. This is a response to an RMP data request. I think this includes 5.1 through 5.3.
Huh?
Yeah.
Well, it's 5.2, no, you're right, 5.1 to 5.3.
Yeah, it's
Correct.
double-sided.
Sorry.
So, yeah.
Yes.
So, and I'll just say that these, were you involved in responding to these data requests?
Yes.
Okay. Let me go ahead and mark this as Exhibit 9.
Okay, so let's make sure we know which is Exhibit 8. Is that Is this table, Rocky?
No, sir, I didn't offer it as an exhibit because it's already in the testimony. It's just.
I understand, which,
convenience.
what was marked as Exhibit A? And-
It's these RFI responses.
All right, this is gonna be Rocky Mountain Power's cross aid,
Yes,
okay.
yes.
All right.
And this is DPU's responses to Rocky Mountain Power data requests 5.1 through 5.3. Okay, so,
Do you wanna lay any foundation, or we're just, I mean, we can move to admit it?
I asked him if he had participated in responding to these, and he said he was, and is familiar with them. I could also ask you if.
You're good, you just wanna move admission, I'm good.
I'm happy to, yes. I
Okay,
move for
all-
admission.
All right, good. All right, without objection, we'll admit Rocky Mountain Power cross aid.
Okay.
Thank you.
And I'd like to look at 5.2 and just to kind of set the context. After you filed your direct testimony, would you agree the company asked you in data requests to, and it's in the data request, provide the Verisk model and identify data from the model used in Mr. Gleba's testimony?
That is correct.
Okay, and then in 5.A, we ask you that in 5.A, and your answer to 5.A is, the Verisk wildfire model is a proprietary confidential model and was not provided by Verisk. The data used from the model is shown in attachment 5.1. Okay. So Verisk didn't give, did you purchase this information from Verisk?
Yes, it came at a cost, absolutely. Yes, not
Okay.
free.
And so did FTI buy it?
Well, we purchased it, but the DPU charged it back to DPU.
Okay,
So DPU ultimately paid for it.
okay. And just to confirm, you said Verisk didn't give you the model, correct?
No,
They didn't give you any of the data that went into the calculations, did they?
not the data that went into the calculations, no.
Okay.
Now,
And
those are proprietary. I mean, those are confidential.
you haven't seen them, that's all I'm asking.
No, I have not
Okay.
seen.
And then in 5.2B, we had also asked you, I think referenced in the quote that I read to you a minute ago, that there's an industry exposure database.
Correct.
We asked you if you could provide that as well, and you said the industry exposure database is a separate proprietary confidential database.
Right. It's part of their modeling. I mean, they have more models than just wildfire risk. They do earthquake, they do hurricanes. So they have this industry exposure database that they use for a wide variety of things, but it's a database they own, they control. It's not something I have access to or can view,
Okay.
unless I probably pay exorbitant sums of money, maybe, I don't know.
And as I read your description in your testimony, the one you said was the high-level description, back at line 1385, you said the industry exposure database, and then you said in parentheses, representing value at risk, such as residential buildings, commercial buildings, personal property, and business interruption exposure. So this isn't a database that's focused on utility assets, right?
No.
Okay, do you know if it includes any?
I don't know, but I suspect it probably does, to the extent that you have an asset that is a building somewhere. Because the Verisk data actually goes down to the zip code level. No, I mean, the short answer to your question is no, I don't know for sure.
Okay,
But if
so-
I had to speculate, I would say yes, they're probably, to the extent they have physical plants and buildings, then yes, those may be included.
So you do know it includes residential and commercial buildings, but you don't know
I
either
mean,
way
I
whether
couldn't
it's
tell
got
you, I
utility.
couldn't tell you if,
You don't know either way whether it's got any utility data in it, that's all I'm trying to say.
and I don't know whether there's a grocery store in it, or a dry cleaners, or anything other than, I don't know the specifics of anything that's in it.
So, I mean, what do you know is in it? I mean, if we're using it to make a recommendation.
Well, I
to the
mean,
commission.
I trust that Verisk is a large data analytic firm, so that this is their data, this is what has been explained to me. But I don't have to know the specifics of what's in it to understand that it is a database that has property values, and these are the types of property values that they include in their database.
And so, is it fair to say that what Verisk is offering is, and I think you referenced this in your summary, if you have a certain type of property, this gives you some expectation of what kind of damage it might suffer.
Right, so they have, it's basically just a spread of property values, and they do go down to like the zip code level, but like I said, Verisk has a number of different models, not just wildfire models, they do other type of modeling, and in each case, whatever the incident is, they can look at what the associated property related, you know, in that particular area, and what the potential damages could be. So, for example, in their model, they would simulate they would do 10,000 simulations, but each simulation is a single wildfire, just they simulate a wildfire. And they have factors and assumptions that go into that.
Do you know what those are?
I don't know, I mean, that's their model. I mean, you'd have to, that's their lifeblood, that's how they make money.
It's a black box, right?
I
You've
don't
never
think
seen
it's a
it.
black box, it's definitely not a black box, and people have been, it has been vetted
By whom?
by various regulatory authorities. Insurers use these models in their rate making. I don't want to get too far down in there, but, I mean, it's not a black box. I mean, it's an industry norm. I may not know the actual factors and the parameters that go into it, but the fact that these models exist and the way they operate is generally an industry norm. But I want to get back to, and now you've, I don't know what we were talking about.
I'll take you back.
Sorry.
So I guess I wanted to understand what you had seen and what you understood of the
Right, no,
model. I think you
I
told
got
me.
you. I got you.
You
So-
told me. Now, if I could go to data request, the response to data request 5.1, where we did ask you, please refer to DPU witness Gleba's Phase 3 direct testimony, where Mr. Gleba states, FTI obtained industry data on wildfires from Verisk, a nationally recognized analytics firm. Please provide the data from Verisk identified in Mr. Gleba's testimony. And you referred to attachment 5.1. Is that right?
Correct.
Okay. Now, 5.1 is not the next document in your stack, but you can pass over this document that's in your stack that says consulting agreement.
Got
And
it.
that takes us to 5.1.
Got it.
Okay. And before we dig into it, you recall in data request 5.3, that's on the last page of this exhibit,
Okay.
in Part B, we ask you to provide all documents related to the estimated exceedance probability curves and relative risk indices created by Verisk that are referred to by Mr. Gleba, including communications between Verisk and FTI regarding the documents. And in your answer to Part B, you said, please refer to attachment 5.1 for the wildfire deliverable provided by Verisk. 5.3 is the contract. That's the document we just passed over that I don't need to look at unless you want to. Then you say there were no other specific documents or communication with Verisk, including email exchanges. So you told us all we had to look at is what's in 5.1, correct?
To develop the risk indices, correct.
Okay. So, let me go ahead and, I think it'd be handy if we mark this as an exhibit. This is in Mr. Gleba's testimony, but I think if we mark this as
I agree, let's do
cross
that.
exhibit 9, it's, DPU response to RMP 5.1, attachment 1. It's dated March 7th of 2025.
March what?
March 7,
Okay,
2025.
got those out of order. Okay, that will be Rocky Mountain Power's Cross 9, the document dated March 7th from Verisk. Is there any objection to that being received? Seeing none, we'll receive that into evidence.
Okay, and you didn't provide this document that's attachment 5.1, that's now Exhibit 9, with your direct testimony, correct?
Correct.
You didn't provide it with your rebuttal testimony, correct?
Correct.
Okay, you provided it in response to the data request like we just talked about, right?
Correct.
Okay. So then last Friday, when you filed surrebuttal, you testified, we provided the supporting work papers as part of DPU's response to RMP data request set 5. If I can stop there and say, I think that's just what we've established, right? Additionally, I've included the Veris data as Appendix 1 in this rebuttal testimony. That's what you testified, right? Can you say it out loud?
Yes, yes.
Okay, so I'm going to now ask us to look at the next exhibit in the pile, which is, I'd like to mark as Exhibit 10. And this is a little confusing, but it looks like the same document, but it's Appendix 1 to DPU surrebuttal testimony of John Gleba, and it's dated March 14th of 2025. And do you have that in front of you?
Do.
Okay, may I offer that into evidence?
Yes, the Appendix 1 dated March 14th, 2025, Rocky Mountain Power's Cross Exhibit 10. Is there any objection? Seeing none, we'll admit it.
Okay, so the document that we've marked as Exhibit 9, the one you provided in Discovery, it's a 3-page spreadsheet total, correct?
Correct.
Okay. And the one you attached to your surrebuttal is a 5-page spreadsheet?
Correct.
Right?
Correct.
Okay, and, I mean, you use Excel a fair amount, I imagine, right?
Yes.
Okay, so, I mean, to have separate tabs, it's not like you just forgot to copy the last 2 pages. These are separate tabs in the document,
I mean,
right?
if you want, I can try to explain the difference.
Let me just explain what we have in front of us, and then you can tell me why it's
Okay.
this way, okay?
I just want to make sure that we're not openly discussing confidential information because the cross 10 is labeled as confidential at the top.
If, I don't know, I didn't label it that way.
Are
I
you-
just want to make sure that that we're not, that it, make
I
sure,
mean, it's your-
identify if it is confidential and we need to.
It's your
do something.
data.
I mean, it's not, it's Veris data, that's not my data, but,
the-
How was it attached?
It's your evidence.
Testimony, was it attached as confidential?
Was it attached to your testimony as confidential?
it was not attached to my testimony, it was part of a data request.
Okay, and it appears from the label at the top that it is confidential.
But when believe when I attached it to my surrebuttal, it was confidential, I believe.
Okay, so if
I
we're
mean,
gonna.
I'm happy to discuss the specifics, I think that's okay. Just the actual numbers may be,
Okay,
and, which I don't think we're going to talk about actual numbers.
Well,
Okay.
the fact that there's a document from Verisk isn't itself confidential, it's the content of the document. So if he's going to respond to Mr. Magnus's questions about the document generally, I don't see a problem staying in open session. But if you're going to ask him questions about the numbers and the, what's in the document, then we probably ought to go into closed session. What do you think, Mr. Magnus?
I'm not anticipating digging into a lot of the numbers. I do not want to tangle with an actuary on numbers, but
Okay.
I do need to talk to him about the document because he submitted it as the only evidence supporting his allocation that was from Verisk, so.
I'm all right with that, as long as you don't get into, if it crosses into territory where you think that it's disclosing proprietary information, then let me know, and we'll deal with that at that point in time. But with that caveat, go ahead, Mr. Magnus.
Okay, so the first page on both of these, Exhibit 9 and Exhibit 10, they're entitled About This File. So I guess this is where we get text that explains what this document is. Is that correct?
That's what this does, yes, correct.
Okay. And I just want to run through some of the differences first. In the one that you submitted in Discovery, it has 2 tabs, map and relativities, is that right? Mm-hmm. The one you gave us last Friday and with your testimony has map, relativities, and then another tab called Relativities CA Updated EP. Is that right?
Yep,
Okay.
and it has a 4th tab called Relativities Adjusted, I believe, as well.
Relativities adjusted. I don't see it on the tab
Okay,
name, but
well,
there are
it's
5
the
pages
last
in the
tab.
document.
It's the last page of those 5.
Okay. And then if we look in the document, we flip over to the first page in both of them include maps, right?
They do.
A map of, would you agree it's 13 western states that were examined by Verisk?
Yes, correct.
Okay, and then each state has a number under its name, correct?
Yes, that's correct.
Okay, and those numbers are not the same in the two different maps, are they?
Okay, well, they are not
just-
correct. No.
They're not, okay. And then the way the map describes itself, if I could put it that way, it's also different, right? One says industry market share wildlife, AAL relative to California. One says add some additional language, right? And then if you look over at the key on the map, on the right side where it says AAL and then a number scale, the number scale is also different, right?
It is, correct.
Okay. And as you said, this one has 5 sheets ultimately. And in the next tab that's called relativities, and again, I won't say any of these numbers, but as far as I could tell, the numbers look the same.
They're
Is that right?
identical, correct?
Okay. But then there's 2 new pages of numbers that follow, correct? And the numbers on, let's just talk about the new one, the one from Surrebuttal. The numbers are different in page 3 and in page 4, right?
Yes.
Okay. And then in page 5, you've got another set of numbers that look, they're different numbers. It all looks sort of the same. But at the bottom, it says FTI Calc. What does that mean?
Those are calculations that I made from the prior 2 tabs, so not provided by Verisk.
Okay, so when we ask you in the RFI, in the discovery data request, give us everything Verisk gave you, you did not do that, did you?
Okay, so I believe that I did, and it turns out, well, I know you're looking at me incredulously. So first of all, let me explain. So these are spreadsheets, right? So these are Excel documents. Now, I did not actually print these out for today's testimony. But in these, first of all, if you look at these maps that you're looking at and you say, well, they're different. Well, the numbers are actually, if you look at the numbers for the actual states, they're not different. But if you actually open it in Excel, it's actually a function where you can like click a box to aggregate. You can change the numbers.
May I make a note? We knew that.
Okay.
And we set them both to aggregate before we printed them.
Oh, okay. Okay.
So the numbers are still different, right?
It looks like the numbers, and if I look at the states, the numbers are the same. Washington,
So they're different if I'd have set it to the other setting.
well,
they'd
yeah,
be
but that's
different.
a different set. That's a different setting, yeah.
Okay, and there's no explanation of what any of that means in here, right?
Well, there is in the first tab. I mean, there's a difference between occurrence and
Okay,
aggregate.
go ahead. You were explaining.
Sorry. So, what happened was Veris sent us a file, which was a file we attached. So when we got the data request, send us what Veris deliverable, we attached that file. As I was, and I believed, to the best of my ability and my heart, that was exactly what it was. But then I realized as we were doing the Surrebuttal that there was an extra piece of information that I'd asked Veris for that I'd inadvertently forgot to attach. And that's what the second file was. And so let me just explain a little bit.
Can I ask you one question before you explain a little bit? You know it's possible to supplement a discovery response, right? Like you could have told me, oh, I made a mistake. That isn't the Veris data. This is the Veris data. You didn't do that, did you?
I mean, I didn't say that.
You just said in your Surrebuttal, I provided the Veris data in response to a discovery request, and here it is.
No, I get that.
That's not correct, is it?
In hindsight, no, that was not correct.
Why'd you do that?
As I said, I mean, it was not intentional, it was in good faith, but I mean, I did realize after the fact that there was another piece missing, but I can just explain sort of what happened.
Well, I have one more question before you do that. You said all this is Veris data. We asked you, what's all the data you got from Verisk? You generated this 5-piece spreadsheet. Now you're telling me the last page is actually your work, not Veris work.
Correct.
Okay, so this isn't just stuff you
Well, it's
received
still
from
all the
Verisk.
data, well, it's all the data received from Verisk, and then I made an additional calculation.
Data
on
that
top.
it's Veris data, changed, manipulated, whatever verb you want
No,
to
I
use.
would
by
not say
you.
changed or manipulated. I mean, Verisk.
Due to it.
Objection, this is bordering on argumentative.
I
I think
don't-
he's answered the question of what information Veris provided to him and he provided to the company, and then when he realized that there's information you didn't provide, it was incorporated into testimony and also provided as a response to a data request.
Okay, you said,
Sustained as to the argumentative point, but I think you can ask the question, perhaps we ought to wait for each other to ask and then answer. I think it appears that the tone is getting a little heightened as far as or it could be construed as argumentative. So I'll allow you to ask the question to try to understand the differences, and that's what I think you're trying to drive at, so.
and we were on the road to you explaining, so go ahead and explain.
Okay. So,
Thank you.
as I said, I just want to preface this by saying the various data provided was the same in both files, but one, and I understand your point, there was one piece of information that was missing, and so, to be fair, I do totally understand that. But if you look at page 3 of either one of these files, because they're exactly the same, if what you've got sort of across the top is you've got ignore the first 2 columns that have letter abbreviations, but if you look at the numerical columns, and it starts with 10, 25, 50, so those are return periods, like a 1 in 10, 1 in 25, 1 in 50. But then if you look at any one of those columns and you look down the column, okay, just solely down the column, everything in that column is relative to California. So you see how California is always a 1? Always a 1. If you look in every column, California's a 1. So every column in and of itself is indexed relative to California. The only different, and again, this is Veris data, we didn't do anything, this is what was actually provided. When we started to look at it, we realized we were missing one piece of information because we wanted to look at the 1 in 100 year return period. And so we wanted a way, the piece of information that was missing is what is the relationship of the California 1 in 10 to a California 1 in 100? Right? Because so in other words, within each column was sort of consistent, but it wasn't across the rows. So if you turn to the 4th page, on the 4th page, this table is identical to the one we just looked at with one exception. The California row, which is bolded, and it's hard to tell, but it's bolded, is now all been indexed to a California 1 in 100. So now the only number in that row, the California row going across, that's a 1, is the 1 in 100. So, and for practical purposes, you can ignore all the other data on that page because it's not used, but it's just there, but I didn't use it. On the last page, which says FTI calc, all I did was just took the prior 2 pages, and instead of having each column relative to a California 1 in 10 or whatever, I rebased the entire spreadsheet to be to California 1 in 100. So now if you look at the final table, and this is what I used in my testimony, all the numbers on that page are relative to California 1 in 100. So that's the only difference. The numbers are identical. I didn't try to introduce anything different. And again, so the 5th page was not something Veris provided. I had to do that calculation. But they did give me those bolded numbers on the 4th page.
And when you talk about California being at 1.0 with 4 zeros all the way across the line, or you talk about a California 1 in 10, is the 1 the average annual loss, this column called AAL? Because that's where it appears.
Well, it appears in every column. I mean, so it depends on what column you're looking at, but.
I'm looking at the AAL column.
Okay, so what is your question about?
1 what?
So so there's some dollar number that represents California average annual loss. Veris didn't give me that number because that's proprietary. We didn't ask to provide that number. But what they did provide us was, let's say in Arizona, for example, there's another number that's in Arizona represents average annual loss of wildfires. that number happens to be 9.96% of whatever the California dollar number was. So it's a relativity. Or if you look at, I guess in this case, Utah, and you look at Utah aggregate, the index is, or relativity is 0.0192, which is what I show. And again, I think it's okay to say a couple of these numbers since I can't really do anything with them. But relative to, so that's relative to California of 1.
It's not my numbers.
I think you can refer to, if a number is smaller or larger, I would
Okay.
refer to the actual number.
Okay, well, I was just trying to say the number because there's so many numbers on the page that I try to get to focus on. But anyway, that would say that the average annual loss in Utah, whatever dollar amount that is, and I don't know what it is, but it's that percentage of whatever the California number is. And again, I don't know what the California number is, I don't know what the Utah number is, but I know that the relationship between them is this number.
Okay. Could you look at the next document we have, which is from the Verisk website? And we provided this Tuesday, I think, when we exchanged exhibits. And we'll mark this as 11, cross exhibit 11. This has a rather odd title, but it's called 5 Things Cat Modeling Every Insurer Know.
Yeah, I got it.
I guess they skip a few words here and there.
And I get it.
But, and it introduces itself by saying, whether you're new to the field of reinsurance or a veteran in need of a quick refresher, here's 5 things that reinsurance underwriters, other folks, should understand when interpreting catastrophe modeling output. And I want to turn you to the second item, which is, here's average annual loss. That's the AAL value, right? And as you referenced, there's a difference between aggregate AAL and occurrence AAL. But occurrence AAL, yeah. And when it says AAL is the mean loss or the expected value that occurs in any given year. And is that like a property damage loss? What kind of loss?
Well, I guess it depends on what model you're talking about. I mean, but if, in this particular instance, the way I understand it is it's the expected value of the damages resulting from 10,000 wildfire scenarios in a given state. So they do 10,000 iterations. Each iteration has a value with it. They add it all up and divide by 10,000, and that's the average.
And so that's like, if you had a fire in California somewhere, then the kind of property damages you should expect is a number.
Some number, right.
Now, as I look at this explanation of how to work with these models, it says to calculate AAL, sum the losses from each year in the catalog divided by the number of years in the catalog. That's the catalog of their data, right? Verisk data.
I assume so. I mean, this is a generic document. I mean, this is not something I looked at, but I can't really speak what catalog means, but the way I understand it is, again, they do 10,000 simulations. Each simulation, maybe you want to call it a catalog, whatever you want to call it. Each simulation has a value associated with it. If you add up all the values, you get a grand total, and if you divide it by the number of iterations, you get the average, and that's what I understand.
And those values are all dollar amounts, right?
It's my understanding, yes.
And there's not a dollar amount to be found in anything we have before
No.
us right here, right?
That is not something we were provided by Verisk.
So if the commission's going to adopt this allocation, it's got to adopt it basically based on faith that a property damage model put together by Verisk is using, we don't even know, I mean, we don't know what they're using.
You don't know, but I mean, you could know if you wanted to. If you pay them enough money, you can get it. I mean, and it's not some, it's not some, like I said, you want to call it a black box. I mean, and I know I don't want to repeat myself, but it is an industry norm. I mean, just step back for a minute. I mean, we're talking about allocating a sum of premium, right? Okay, I don't know, and I'm not making any judgment about whether that premium is the right amount or not. But that premium was based on, and we just went through this morning with previous witness, we talked about how underwriters get to how that number comes up with and all the things that an insurer comes up with. But one of the things that these insurers use, these reinsurers use, is they use this model. So, I mean, Mr. Kelly, who was here this morning, I mean, as he said, I mean, he works with these reinsurers. This is the model they use. So you might want to poke holes in it, and you very well may be able to, but the reality is everybody are using these models. This is the reality we have. And these models are going to get tested. They're going to get refined over time. Verisk is only one of the 3, global firms that does this sort of data. They've been around for 50 years. When a wildfire occurs somewhere in the West, and you want to have an estimate of what is the insured damage, who do you turn to? It's Verisk. I mean, you see them in the news all the time. We just had all the wildfires in California in January. Very devastating, very unfortunate. Verisk already has estimates of what the damage are going to be. How do you think they got those estimates? This is the model they have. So, this is an industry norm, widely accepted, used. I know the California Insurance Department, I think, is one of my exhibits in my rebuttal. Just recently is now looking at Verisk, letting insurers in California use Verisk for rate making. Other states I'm aware, Nevada, for example, also lets their insurers use Verisk model in their rate making. And I know BHE has a subsidiary in Nevada. BHE has a subsidiary in Nevada as well. So all I'm saying is, these are the models that people are using. Are they perfect? No, but there is nothing that's going to be perfect. We can't perfectly predict the future, but we can use these models that everybody is accepted to use, and this is what we have. And they're refined and they get better all the time, but this is what we've got at the moment.
Well, I mean, just to be clear, I mean, I have no beef with Verisk.
No, I get it.
I think I'm not saying they're not a credible source. I've been reading their blog post for a week trying to understand your exhibit. So that's not the issue, I don't think. It's what does this say? Well, what does it tell us, right? And you can't give us any background on the data that went into it or how you would adjust it for new data. Let me just ask you, you can't tell us those things. The one thing I would like to know is, when this is used in the industry by insurers, as I understand what you're saying is, you'd say, okay, I want to figure out for Utah, if there was a wildfire, what kind of property damage could I expect, correct? Is that a use for this model?
Right, that's what they.
So they've run 10,000 Monte Carlo simulations, and they've got all these ideas about what a wildfire would look like, and then they tell you, here's the kind of property damage you would expect, right? Okay.
I'm sorry. Sorry, yes, that's a yes, sorry.
Okay, so that doesn't tell us how many wildfires to expect anywhere, does it?
It is not it's not a frequency measure,
Okay.
correct?
Does it tell us anything about how utility infrastructure in a state might affect the likelihood of wildfire?
Not to my knowledge.
Okay. And does it tell you anything about the likelihood of third-party excess liability insurance claims?
Not specifically, no.
Okay. I think this case is about excess liability insurance. Is that your understanding?
Correct.
Okay. Let's go a little bit further into this. If you could look at your testimony at figure 4.11. And that's
Mr. Magnus, before we move on, are you going to move for the omission of RMP Cross 11?
yes, sir. I'm sorry. Yes, ORP, I'm sorry. Cross Exhibit 11 is, I think I read the title, 5 Things Cap Modeling Every Insurer Know, from the verisk.com website. We have the site at the top.
Okay, is there any objection to the admission of RMP Cross 11? Okay, it is admitted. Thank you.
Okay, now we're at page 75 of your direct. We're at figure 4.11. And this is when you start calculating what you call wildfire liability exceedance probability curves, right?
Correct.
Okay. I only have one question about this table at the moment, which is, does it include an AAL column?
No.
Okay, so the AAL data is not mentioned in this table?
I didn't use that I didn't use that data.
Okay. And let's see, let's go to line 1416, which is, I think, the next page. Excuse me. Now, here you say, we can use these indexed relativities as another measure of estimating how much insurance premium should be allocated to the 6 jurisdictions in which Pacificor operates. Just kind of a broad question here. Why would we do that if this is not related to excess liability insurance premiums or third-party claims?
So, I mean, it is related, right? Because if you have a liability claim, and what are your damages based on? So, I mean, say for example, you have a wildfire and you have damages. I'm not trying to ask you the question, it's hypothetical, but I'm just saying, what are the damages based on? Well, the damages are based on in most cases, property damage. That's what you're trying to recoup from your insurance. Your building burned down, your house burned down.
For excess liability insurance? That's property insurance, right?
No, it's liability insurance because the
Somebody else's property.
somebody else's, it's
Fair
what
enough.
we call third-party liability insurance. Somebody else's property burned down, you're liable. The property insurance you're talking about is first-party property damage. I own a house and it burns down. That's property damage, that's not liability. Liability is, I own a house and then you come and burn it down, you're liable for my house, so that's liability insurance.
And in the, I think it's here at 1416, you talk about indexed relativities. There's another table that's called relativities, I guess CA, California Updated EP. There's a tab in the exhibit from Veris that's called relativities adjusted. Then you have indexed relativities. Are those all the same? Are those different?
No,
They're all the
so,
same?
actually, that's a good question. So, the relativities that I got from Verisk, which is the data that we were looking at, those Excel spreadsheets, those are, what do you call return periods calculations. They're kind of looking at average relativities. But I actually do an adjustment to that. I actually calculate what we call an exceedance probability curve. So I take that data and then I try to estimate, and there's a little graph in my testimony, and it might help if you look at, it's 1370 in my direct testimony, figure 4.10. I think this is helpful to look at because I think graphs always help. But if you look at that figure, so what this is in very generic terms is trying to map a loss distribution. So the x-axis is the actual loss value, and the y-axis is the probability of it occurring. And you can think of it as a bell-shaped curve, but in insurance, these types of distributions tend to be highly skewed, especially when you have a long tail line. And so what you end up is the little hump, which you would think would probably be, and I know but it'd probably be normal bell shape, gets shifted to the right, and then you would have a really long tail. And so what we're estimating is this concept called tail value at risk, or in other words, or given that you're at a certain probability level on the curve, what is the area under the curve to the right of that value? And that's what we're trying to do. So to go back to table 411, which is in line 1406, that table is after I've already gone through and tried to estimate the areas under those curves state by state, and then index them. Again, I don't know actual values, but I know relativities. I can index them against each other to get actual relativities.
But just to be sure I've got it straight, when you say you can do that, are all of the numbers that are underlying any of your use of the word relativity or relativities numbers you got from Verisk, or did you calculate some of them?
All of those numbers are based on information from Verisk.
Okay.
Yes, but to answer your point, I did have to make my own calculations.
For why?
Because they only provided me the relativities, and then I wanted a value at risk exceedance probability curve, so I had to do that calculation.
Okay, so that,
I could have asked Verisk to do it, but that would have cost me more money, and I knew I could do it myself, so I just got the raw data and did it myself.
in table 15, 4.15 on page 76, line 1420. Here you have, you call it index full state relativity in the 1 in 100 return period. And you take this regional look at the Pacific Core region, you add up, it appears to me, tell me if I got this wrong, on the indexed relativity that you added up the numbers in that column and got to a total.
Added up numbers in what column?
This is table 4.15. There's a column called indexed relativity. And if I look at those numbers in the indexed relativity column, when you get to the total, is that a total of those numbers added up?
I believe so, yes.
Okay, so you got the regional total by adding up the relativities, right?
Correct.
Okay. I'd ask you to look at the Verisk document, we've had several, the Verisk 5 Things You Should Know document, which is
Okay.
Exhibit 11, correct?
Okay.
I think. On the page 3 of 3, item 5 is evaluating portfolio risk based only on regional losses can overestimate overall aggregate risk. And in table 1, it's got a table. And what is EV in that table? Do you know?
I mean, I don't know for sure, but if I had to guess, it means expected value, if I had to guess.
Summing regional EP percentages erroneously overestimates the risk of your portfolio. And then the next note, later it's got a note that says, the only metric you can sum on a standard EP curve is the expected value. Now,
Yes.
when you summed index relativities, were you summing an expected value?
No, what you're looking at, this has absolutely nothing to do with what I've done. So all I've done in Act Table 4.15 is I'm trying to come up with a state distribution. So the index for California is 41.31. What percentage of that is of the total? So you just add them up and you divide 41 by 56 to get, so you say 73% of the premium looks like it should be in California. Because remember, those numbers are indexed to, and I also re-index them to Utah. So what you're looking at in this column that says indexed relativity is, and this is a 1 in 100 period. This is important to understand. There's a dollar value, and I don't know what it is, but there's a dollar value, say on Utah. So we're looking at, remember, go back to that chart I showed with the little really skewed bell-shaped curve, right? There's a dollar value on that curve somewhere where 90% of the losses are below that and 10% are above. We call it, what's the 1 in 100 return period, or 10% exceeds probability. I don't know exactly what that number is, but that's okay. There's also in California, there's another curve. It looks similar, but it's, you know, it's probably skewed more. I don't know what it looks like. There's another value on that curve where 90% of the California losses were below that and 10% are above. That dollar value in California, whatever it is 41 times as high as the dollar value in Utah. So that's
Your
saying,
calculation, right?
well, based on the Verisk data. So when I looked at the Verisk data, and they did the simulations of property damages and what the average values were. And by the way, this has been adjusted by market share for Pacific Corp. So I recognize that to the extent that California is certainly a high-risk state, but I'm not giving them a lot of weight. Is a high-risk state, I'm not giving them a lot of weight. But in any case, that's all I'm doing here. So when you look at this relativity, that's all I'm looking at. It's just a 1 in 100 return period. What is the average relationship between these loss values at this 1 in 100, at this 90% probability level on these curves? And then I'm using that to say, okay, well, California loss value is 41% higher, and of the 6 states, if we were to sort of if our universe were only these 6 states, that would be about 73.4% of the total. If we added all the dollars up, I don't know what the dollars are, but if we added them all up, divided by 6, or whatever the percent, no, I'm sorry, not do that.
Okay.
If you just added up all the numbers and figure out what the California number is, what percent of the total, it's roughly 73% of the total.
So when Verisk advises, when they give this example in this exhibit of somebody trying to add up Florida, Gulf, Southeast, and East Coast, come up with a regional total or to come up with a US total, you're saying that's different from you taking California, Oregon, Washington, Idaho, Utah, and coming up with a Pacific or, I'm sorry, when you add up California, Oregon, Washington, Idaho, Utah, and Wyoming to come up with a Pacific or regional total, that's not the same thing.
These are two completely different concepts.
Okay. How would anybody reading this testimony know that from what you've provided from Verisk, which is a row of a bunch of numbers?
How would they know what?
What this is supposed to mean? I mean, it looks like you added these things up. I just, we just have rows of numbers. We can move on. Okay, let's look at your surrebuttal at line 107.
Got it.
You say, the Verisk data on wildfire risks by state, as referenced to my testimony, consistently shows that wildfire risks in Utah are the lowest in the 13-state western region. And just to be sure we're clear again, when you say wildfire risks, do you mean the risk of wildfires occurring, or do you mean the risk of damage when there is a wildfire?
Thank you for asking that question. You paid attention this morning. So what I'm talking about is actually including the cost causation, the severity component. So I'm just saying,
I'm sorry, sir, but I ask you, is it this thing or that thing? Could you just tell me if it's this thing or that thing, and then we can get into the rest?
okay,
I ask you, is it the likelihood, when you say wildfire risks are lower in Utah, does that mean the risk of there being a wildfire is lower, or does that mean the risk of there being property damage when there is a wildfire is lower?
that's not a yes or no question.
Okay, well, I didn't ask a yes or no question. I ask, is it this or is it that?
It's not a.
Either one?
Well, you have to quantify that a little bit because
Okay,
it's not just either this or that.
Okay, well, let's try something else. So you're not saying, I guess, that Verisk backs up the idea that Utah has the lowest risk of experiencing wildfires among
No.
the 13 states? Okay,
No.
okay.
I mean, maybe this will help. What I am saying is that of those 13 western states, the cost associated with potential wildfires on average is lower, and Utah is the lowest of all of these 13 western states. I'm not saying it's the lowest of the entire country, but when you include the fact that, and when you overlay potential damage estimates on top of the frequency of wildfires, Utah has consistently come out lower based on the Verisk data that I've been given.
Okay. I'd like to now look at the next exhibit, which is, we can mark as Exhibit 12. This is it's another Verisk document. It's entitled Wildfire Risk Report 2024.
Yes.
Subtitle is State-Specific Reports Provide Essential Data to Help Address the Wildfire Threat. You've read this?
I've looked at it. I can't say I've read every line, every detail, but I'm aware of it. I've looked at it.
I'd like to introduce this as Exhibit 12.
Okay, the Wildfire Risk Report 2024 is Rocky Mountain Power's Cross 12. Any objections? Okay, we'll admit that.
And if you flip to the table of contents, I think you'll see, tell me if you disagree, there's state-specific risk reports on 13 states, correct?
Correct.
Those are the same 13 states that you got the numbers on that are in these spreadsheets, right?
That, I'm not sure about. I have to cross-check that, but I will take your word for it.
Okay. And it includes data on Utah, correct?
It appears so, yes.
Okay. And this report, according to what it represents about itself, includes various measures of wildfire risk for each state on separate pages. Did you see that?
Yes.
Okay. And if you go to Utah, I think you'll find Utah on page 14. Are you there?
Yes.
Okay. You see, when Verisk looks at what the wildfire, I guess they're saying these are indicia of wildfire risk, they list, I guess it's 7 categories. Do you see that under wildfire risk at a glance?
Yes.
And so, would you agree with me that they seem to be measuring based on what's likely to create wildfire risk in a state?
Well, I don't think I can agree. I don't know what they're based on. I don't think I can agree to that, no.
Because this is Verisk data and you don't know what the Verisk data is?
I don't know what data they're using to come up with these conclusions. I've not been involved in creating this report.
Okay, I understand. But if they say the percentage of structures at negligible risk, and they footnote where they get the data, and they say it's 77% for Utah, you have any reason to believe that's not
No,
accurate?
no.
Okay. So that's one of the criteria that is an indicia of risk. And they say Utah is 77%. Now, this might be a little tedious, but I'm going to represent to you that 7 of the 13 states in this document have lower risk on that criteria than Utah. And if you want to go through and look at each one of the states
Okay,
to verify that, I'm happy for you to do it.
I will take your assessment of that.
Okay, so 7 of the 13 states have lower risk on that criteria. The percentage of structures that are at high to extreme risk, do you see it lists Utah at 6%?
No, mine said, well, hold on. High to extreme, yes, 6%, yes.
Okay, and would you have any reason to question that 7 of the 13 states in the report have the same or lower risk on that criteria?
Okay, I'm gonna take your word for that.
Okay? And then they list, I'm not gonna read all of these, they list largest historical wildfire. And then for Utah, that's a fire that burned 363,100 acres. You see that?
Yes,
And would you have any reason to disagree that 5 of the 13 states that Verisk list have lower risk on that criteria than Utah?
I'll take your word for that.
Okay. And would you agree with me that the first sentence of the Utah summary says, the increasing severity of wildfire in Utah has made them a substantial financial threat to insurers?
Yes.
Okay, is there anything in this report that you've looked at where Verisk says Utah has a relatively low risk among the 13 western states?
There is nothing that says that in this report.
Okay, and this report, it was free. All I had to do was give my email address. But you didn't look at a report called Verisk Wildfire Risk Report that focused on the 13 western states in preparing your testimony?
I did not, no.
Okay, did you know it existed?
No, I did not look
Okay.
at this.
You didn't look around for the reports from Verisk that are publicly available to base your recommendation on?
I used the data that Verisk provided that we paid for.
Okay. And when it comes to, let me ask you just one question. The term wildfire peril risk, I think Verisk uses in the spreadsheets. What's the difference between wildfire peril risk and wildfire risk from an insurance or actuarial perspective? Do you know what that term means?
I mean, when you say peril, you're specifically talking about a wildfire. I mean, I think, as I said earlier, when you say risk, that's more of a generic term, but I'm not sure what they mean by the difference, but the word peril is just kind of thrown around
Okay.
interchangeably.
And if you're looking at how much property damage to expect, and you're looking at it on a per state basis, would it be a big surprise that there's gonna be a whole lot more property damage in a place like California that has cities all up and down a large territory than a state with a smaller population?
No, that would not be a
Okay.
surprise.
And again, that doesn't have any relationship to the likelihood of wildfires occurring, does it?
Well, no, because there's two parts of that. There's the probability occurs, and then once it occurs, the value. So yes, no, that has nothing to do.
And it has nothing to do with,
There's two parts of that. There's the probability a wildfire occurs, and then there's the damage associated with that. And so I agree, this is just the damage estimate.
and it doesn't give us any insight on the likelihood of a wildfire being caused by or related to utility causes, does it?
No.
Okay. Could you hand this to him? And I'm going to ask Joe to hand you Mr. Einfeld's direct testimony. I want to ask you one question about his
Okay.
testimonies. So we'll hand that to you.
You may.
But I got, just to sum up on Veris, the 18.6% allocation factor is your calculation that took the Veris data that we've discussed at some length, and then you calculated that by the market share that you described earlier for the Pacific Core states, right?
Right, I did a number of adjustments, so
That-
I calculated exceedance probability curves, and then I figured out the relativities, and then I adjusted those for market share. So to your point, California has a lot more people, a lot higher damage, but I also adjusted that for the fact that Pacific Corp has a very small market share in California.
Okay.
So,
And if you look at Mr. Einfeld's direct testimony at line 335, and I'm showing this to you because it's a place where he cites your testimony.
okay,
I believe he says FTI calculates an allocation factor of 14.3%, and of course, we know that's now 18.6%. FTI calculates an allocation factor of 18.6% based on an analysis of distribution and transmission lines in high fire risk areas, or FHRA. Is that what you did?
no, that's not
Okay,
correct.
so your allocation isn't based on any examination of
No,
transmission lines or distribution lines?
No.
Fair enough. Okay. Now, one last thing, I promise. If you could look at your direct testimony at line 635, and it's table 4.5.
okay,
Let me get there myself. Well, actually, before we get to table 4.5, actually, there was some text. Okay, line 631, it's on the previous page, I'm sorry.
I got
Okay,
it.
so, the question you're answering is, what are some specific exposure measures within Pacific Core that could be used as a basis for allocating liability premium by state? And you say, the table below shows a summary of several liability exposure measures that could be used for allocating insurance premiums by operating state within Pacific Core's jurisdiction. I read that correctly, right?
Correct.
Okay, then you get into table 4.5, and it's basically a list by state of various, what you call exposure measures for wildfire. And I'm gonna walk through these.
Can I just clarify, they're not exposure measures for wildfire specifically, but they're just exposure measures?
Exposure measures, what does that mean, generally?
Which, it's just, I mean, they're not specific to wildfire, it's just, we're just saying for Pacific Corp, these are operating metrics. How many miles, how many transmission miles they have in various states, and we just list them up. But it's not, we're not saying it's a wildfire exposure.
It's kind of surprising, because on the page before you says, this is a summary of several liability exposure measures. Is that what they are? Liability
Well,
exposure measures?
they're measures that could be used for, to measure liability.
So they're
But
they're liability exposure measures?
yes.
Okay, great. And just to walk through them,
I'm not sure how deep into this we're gonna get, but that is marked as confidential.
I am not going to say any of the numbers, and I don't think that will cause the staff to go into closed session. And I think this is,
Does that satisfy you, Mr. Grieco?
I mean, in that, it's not just the numbers that are marked as confidential, it's the whole table, so I don't know, if Mr. Gleba is okay with, discussing it without disclosing the numbers, I guess that will work, but the whole table is labeled as confidential.
Okay, let's go forward and see where we get.
you marked this as confidential as a courtesy to Pacific Core, to the company, right? This isn't your data.
Correct.
Okay. So if you look at total overhead transmission miles, would you agree with me that the most total overhead transmission miles of the 6 states are in Utah?
Yes.
Would you agree with me that total overhead distribution miles, Utah is number 2 among the 6 states?
Yes.
Would you agree with me on total overhead miles, Utah is number 1 among the 6 states?
Yes.
Would you agree with me that on HFRA, I think we've established that's high fire risk areas, HFRA transmission miles, Utah is number 1 among the 6 states.
Yes.
HFRA distribution miles, would you agree with me that Utah is number 3 among the 6 states?
Yes.
Total HFRA miles, would you agree with me that Utah is number 2 among the 6 states?
Yes.
Okay, I'm going to skip the percentages. Number of total transmission poles, would you agree with me that Utah is number 1 on that criteria?
Yes.
And then you continue the exposure measures table on the next page. It's still called Table 4.5. Would you agree with me that the number of distribution poles, Utah is number 2 among the 6 states?
Yes.
Would you agree with me that in service territory, in miles, Utah is number 1 among the 6 states?
Yes.
Would you agree with me that in total retail customers, Utah is number 1 among the 6 states?
Yes.
And just scanning the numbers, would you agree that Utah's got about half the customers in the entire 6-state region?
Yes.
Okay. Now, based on those factors, which I understood you to be characterizing as some form of liability exposure measures that could be used by the commission, when you did your Verisk analysis, before you worked in the market share, I mean, did it surprise you that, you know, you testified that the data implies that Utah should be allocated approximately 1.8% of the total premium allocation? Did that kind of surprise you, given all these exposure measures that where Utah's kind of at the top?
No,
No?
no, doesn't surprise me.
Yes,
That's what the data shows.
Fair enough.
Data is what the data is.
Data is what the data is, and we haven't seen any of it except what you've provided in the spreadsheet, right?
I mean, yeah, that's correct.
Okay, that's all I have. Thank you.
All right, thank you, Mr. Magnus. Is there any other of the parties that has cross-examination of Mr. Gleba? Okay, seeing none, we'll come back to Mr. Griecu for redirect.
Yeah, thank you. First, could we have just a moment?
Sure, it would. I hate to take a break now. Okay, good.
I just want to make sure that RMP Cross 10, that exhibit, is admitted as confidential because it was marked as such.
I don't think we admitted it as confidential, but we'll amend it and admit it as confidential in the record. Thank you for pointing that out.
Thank you. Mr. Glebe, I have some follow-up questions that's going to cover a range of the topics that RMP's counsel discussed with you. My first question is your analysis more reflective of the type of analysis that an insurer would undertake?
That's correct.
And counsel has characterized the Verisk data as a black box. Is that true?
That's how counsel characterized it, yes.
Are the Verisk models widely used in the insurance industry?
Yes, they are.
And why would insurers or other people pay for that type of product?
Because Verisk has a long history and credibility of providing this data. Their models have been reviewed by numerous regulatory bodies, submitted for evidence in various cases. I don't have all the details behind that, but they're an industry norm. Reinsurers use them, insurers use them. They're used for rate setting. And we're not talking just about wildfire specifically, but other models as well are used in the same manner.
So it's fair to say, in your opinion, these are viewed in the industry as credible and reliable models.
Not only are they credible and reliable, that is what people are using. That is, this is the only thing they have to use for large catastrophic losses.
And in your discussion of the Verisk data with counsel, he asked if it tells you anything of the occurrence of wildfires, and said that this case is about insurance.
Right, so I just want to clarify that. So and maybe I didn't say this, but part of the Verisk modeling process does involve things like geography, climate change, weather. So it's not just where they say, well, we have, what is the probability of a loss occurring? I mean, they actually take into account geographical conditions, climate change, weather patterns. All of this is all built into their model. So I guess to that extent, and maybe I was premature earlier, I mean, it does reflect potential occurrences of wildfire as well. So that is part of their model.
And so, in using, well, to say that the use of the Verisk data is very much about insurance, because insurers use this model, correct? I'm going to move on to a little different topic. So can you,
Did you withdraw the question? Because he didn't answer it.
oh, sorry, I apologize. Can you read it back to me, please?
And so in using, well, to say that the use of the Verisk data is very much about insurance because, very much about insurance because insurers use this model, correct?
Yes,
Thank you.
thank you.
Can you turn to me to RMP Cross Exhibit 12? It's the Wildfire Risk Report 2024.
Okay.
And I know you've read this once, but could you turn to the page on Utah, it's page 14, and read that first sentence at the top for me?
The increasing severity of wildfires in Utah has made them a substantial financial threat to insurers.
Can you turn to the page on California on page 5 and read the first sentence for me?
The devastating wildfires that have ravaged California in recent years have underscored the escalating financial risks faced by insurers.
Can you turn to page 7 on Idaho and read the first sentence?
The escalating frequency and intensity of wildfires in Idaho have made them a major financial concern for insurers.
If you could, on your own, just flip to the remainder of the pages and read that first sentence to yourself. Are those exactly the same or substantially similar to one another?
The wordings are slightly different, but the way I read them, they're substantially similar in what they're saying.
Thank you. So I apologize. We're going to go back to California on page 5. There's one of the lines of information listed is called the largest aggregate insured wildfire loss in year. Could you read that, what it says for California?
Largest aggregate insured wildfire loss in a year was $14 billion, and that occurred in 2017.
Thank you. Could you turn to the page for Oregon, which is page 12,
Got it.
and read that same number?
Largest historical wildfire was Myford Flat, was it? And
Oh,
that's
sorry, Oregon. On page 12.
Oregon. I'm sorry. My apologies. Largest historical wildfire in Oregon was a bootleg fire, and then occurred in 2021. And then there's a notation that there were 413,700 acres burned.
Oh, sorry. The information just above that, the largest
I'm sorry.
aggregate
No.
insured.
Sorry. The largest aggregate insured wildfire loss in a year was $2.7 billion in 2020.
And then if you could turn to Washington, page 15, and read that same information, the largest aggregate insured wildfire loss in year.
Largest aggregate insured wildfire in Washington was $300 million, occurred in 2023.
Now, if you go back to the previous page for Utah, is there any largest aggregate insured wildfire loss in year provided?
No.
Thank you. That's all my questions. Thank you.
Recross, Mr. Magnus.
I just asked Mr. Glebe, you don't have any reason to believe that the 2024 wildfire risk report produced by Verisk is any less reliable than the spreadsheets that you got from Verisk, do you?
No.
Okay, thank you.
All right, thank you. We'll go to Commissioner Harvey and see if he has any questions.
just one area. Going back to your calculations that you discussed with Rocky Mountain Power's council, one of the columns was market share. In using that throughout your analysis, did you treat that just as an average number that was just plugged in, or was there any actual location-specific information where Pacificor had customers in a given state, or was it just that market share number that was used?
Well, just use, the market share number was based, so it was based on, and again, it was just a proxy. I mean, we could have picked a bunch of different measures, but we chose households in the state. So the denominator was the total number of households in a state, and that was based on a Google search of industry data, or, available data. The numerator was Pacificorp's number of households served, which was actually provided by Pacificorp. So in terms of location, I mean, we did it by jurisdiction, by state, but not in any other detail.
That's all I have, thanks.
Commissioner Clark.
No questions, thank you.
Okay, I think my questions have been covered. Mr. Gleba, thank you very much for your testimony. You may be excused.
Thank you.
Appreciate it. Now, I have the last DPU witness, Mr. Einfeld. It was 60 minutes scheduled. Because we're going to go a little later, I'm hoping that you can bear with me, and we'll start down the road and probably break about 3 o'clock. All right, go ahead, Mr. Grecu.
Thank you. The division next call is Mr. Jeffrey Einfeld.
Mr. Einfeld, welcome. Welcome, Mr. Einfeld. Will you raise your right arm to the square? You solemnly swear the testimony you're about to give in this matter pending before the Public Service Commission of the State of Utah shall be the truth, the whole truth, and nothing but the truth, so help you God.
Yes.
Thank you. You may be seated. Mr. Grecu.
Mr. Einfeld, could you please state and spell your name for the record?
My name is Jeffrey S. Einfeld. Jeffrey is Jeffrey, middle initial is S. Einfeld is EINFELDT.
By whom are you employed and what is your position?
I'm employed by the Division of Public Utilities. I'm a utility technical consultant.
And what's your business address?
This is the one that always trips me up. I believe it is 160 East, 300 South, Salt Lake City, Utah, and I'm going to say 84111.
Have you
It's the
part-
Heber
to
Wells
check.
building.
It's the
close
Heber
enough
Wells
for us.
building.
Okay. All right.
where
thank
you're
you.
at right now?
Where I am at right now.
Have you participated in this docket on behalf of the division?
Yes, I have.
Could you briefly describe the scope of your participation in this docket?
Briefly. I've read numerous items that have been filed in this docket, researched data, tried to find additional data. I've done searches, tried to talk with other people with regard to wildfires and what they're experiencing over the last, I want to say, approaching 2 years, something over a year and a half. So, and I've performed several analyses and considered and evaluated various data and information to try to form an opinion and come to an informed opinion for the DPU to help inform the commission on its task of determining just and reasonable rates for the ratepayers of Utah.
So it's fair to say that you reviewed the company's filed application, amended application exhibits, testimonies, as well as the filings from all the other parties,
Yes, and some of those a number of times.
and also reviewed responses to data requests.
Yes, and I even understood some of them.
You'll have to bear with me because this is going to be a little bit long, but did you prepare and cause to be filed your Phase 3 direct testimony and DPU exhibit Phase 3 10.1 DIR through 10.9 DIR on February 7th, 2025? Your amended Phase 3 direct testimony and DPU exhibit Phase 3 10.1 DIR through 10.9 DIR on February 11th, 2025, and your Phase 3 surrebuttal testimony and DPU exhibit Phase 3 10.1 SR through 10.3 SR on March 14th, 2025.
Yes.
Do you have any changes or corrections to those filings?
I have one comment to make with regard to the exhibit 10.1 SR, I think, which is a restatement of, or an update of my original testimony, updating for the numbers that were changed in Mr. Gleba's testimony and Mr. Kelly's testimony, which their testimonies were revised based on the 210 million request down to the 185.7 million. We did not title that in the headers or in the headings like we did on 10.2 and 10.3, but that testimony, if those here want to write down 10.1 SR, that's what that is. And I apologize for not having it in the header when we printed it off.
So as corrected and already filed, if I asked you the same questions posed in that testimony today, you would provide the same answers?
Yes, I would.
Do you adopt your pre-filed testimony as part of your testimony today?
Yes.
At this point, I'd like to move to admit Mr. Einfeld's testimonies and associated exhibits.
Okay, we will see if there's any objection to the admission of Mr. Einfeld's direct, amended direct, and surrebuttal testimony in Phase 3 with their accompanying exhibits as have been identified. Seeing no objection, those three sets of testimony exhibits are admitted.
Thank you. Mr. Einfeld, do you have a summary to share today?
Yes, I do.
Please proceed.
Good afternoon, Chairman Fan and Commissioner Clark and Commissioner Harvey. Thank you for the opportunity to address Rocky Mountain Power's request for a deferred accounting order to record its increased insurance costs as a regulatory asset, or the DAO request, and its requests relating to its excess liability insurance costs, or ELI costs, for the test year. The division continues to recommend that the Commission deny Rocky Mountain Power's DAO request to recover the increase in its ELI costs for periods prior to the effective date of the current rate case, for reasons discussed in my testimony in docket number 2303540, the DAO docket. The company should not be authorized to retroactively recover its increased ELI costs for this period. Rocky Mountain Power could have filed a general rate case coupled with an interim rate request to more timely and thoroughly address the increased insurance costs when they became known. Rocky Mountain Power declined to do so even after DPU suggested that approach. Further, Rocky Mountain Power still has not demonstrated that its tortious conduct is not a substantial or primary cause of its increased ELI costs. The division also recommends that the Commission deny Rocky Mountain Power's request for a new balancing account, its proposed Schedule 92 Insurance Cost Adjustment, or ICA. This proposed balancing account would allow Rocky Mountain Power to record ELI costs separately and bill its customers separately from rates that are established in a general rate case. Creating this new balancing account will remove or significantly reduce Rocky Mountain Power's motivation to seek efficient methods and strategies to mitigate very high and increasing insurance costs. General rate cases are and should remain the favored method for changing rates to reflect changed conditions. The division has also reviewed Rocky Mountain Power's request to recover Utah allocated ELI costs of $82 million annually in the future pursuant to the current rate case. The division has determined that the amount of ELI premium allocated to Utah should be significantly reduced. As a result, the division recommends approval of Utah allocated ELI costs ranging from $3.9 million to $10.6 million annually, with an upper boundary of $25.98 million. This reduction in RMP's ELI request is due primarily to an adjustment to the allocation factor assigned to Utah and an adjustment to the ELI growth rate applied to the ELI amount currently in rates. The allocation methods I propose are significantly more likely to reasonably assess the costs of providing insurance attributable to Utah ratepayers because they account for different risk profiles between the states and plausibly segregate distribution and transmission risks. They bear a relationship to the wildfire risks that are primarily causing the significant increase in ELI premiums. Rocky Mountain Power and its witnesses are quick to point out possible deficiencies in the division's analysis, especially regarding the sample of utilities used and the size of the sample relied on. Data for these utilities were provided by the company's own witness. The division's requests for additional relevant information from RMP and its parent Berkshire Energy were denied. This concludes my summary.
Thank you, Mr. Einfeld.
Thank you. The witness is available for cross and for questions from the commission.
Okay, let's turn to Rocky Mountain Power, cross-examination.
Thank you. Good afternoon, Mr. Einfeld.
Good afternoon.
I think I want to start, I think where you made the correction, but I'm not positive. I'm looking at exhibit number phase 3, 10.9 DIR revised. I think it's the list of alternatives.
Right.
Looking at the version that you corrected, I guess, in your
Rebuttal.
yeah. Could I still use that, or is there something new?
That should be the same as my rebuttal 10.3.
SR?
Yeah, rebuttal SR 10.3.
Okay, great. We're looking at the same thing. So if you could look there. I counted 15 alternatives for the commission to consider for recovery of the company's excess liability costs. Is that accurate?
Yes.
And each of those, sort of I guess the starting point for each of those would be the current amount of excess liability costs in the company's rates. Would you agree that number is $10.5 million?
Yes.
Okay.
Except for the bottom three are not based on the $10.5 million starting point of
I
that
understand.
page.
Okay. And you mentioned this in your summary, and you have it here in these scenarios, that you have scenarios at 400% and scenarios at 100%. Would it be correct for me to say that's the option you mentioned in your summary about comparing to industry peers and the relative percentage increases they've seen in excess liability premiums?
Yeah, those peers serve to help form the selection of 100% and 400%.
And I hope this makes you as happy as it makes me, but I'm not going to talk to you about how those percentages were calculated today. I think we did quite a bit of that yesterday. But as I understand your testimony, if the commission chose to adopt either the 100% or 400% increase scenario, the new number of excess liability premiums being recovered, you would consider that a just and reasonable rate as far as recovery of excess liability premiums. Is that fair? You'd recommend it to the commission for adoption, I guess.
Yes, in fact, if you look at 10.3 SR, Exhibit 10.3 SR, I believe, if you go down to the line I have titled IJ, under the hybrid scenario at 100%, that calculates out to the 3.9 million that I included in my summary and also in my testimony. And then the 10.6 million is the hybrid scenario at 400%, using an allocation factor of 18.6%, that we were informed with from our experts that you referenced in their testimonies. And that range is what the division feels is a very reasonable and just range.
And I guess I was asking really, if you just applied the 100% or the 400%, just set aside the allocation for a minute. If you increase the excess liability insurance premiums 100% or 400%, and that was the new expense being recovered, again, setting aside allocation, would that, in your view, generate a just and reasonable rate?
Just the 100% and 400% allocation. Seems like I had that calculation. I thought I had included it here. Maybe it's in my direct testimony. That helped, when I included that, that was to inform us what happens if just that variable is changed. That helps us to inform kind of like a sensitivity analysis, if you're aware or familiar with those types of concepts, which I assume you are, to help inform the division of, okay, what happens if we change it for just this or just that? Well, this is what happens. Okay, another scenario or another variable that the division strongly believes or is strongly of the opinion that is inappropriate is the current SO factor. So to say that just 100% or just 400% adjustment forms just and reasonable rates, I would be remiss if I said yes to that.
Do you believe you need to change the allocation so that a lower percentage is recovered from Utah, as well as setting a rate for the expense premium, the premium expense, in order to achieve a just and reasonable rate?
Yes.
Okay.
Yes. And so when we did those analyses, I did it one for 100% and 400% without changing the allocation factor, which currently is the SO factor. So we could identify how much of the change is from just the growth factor change.
Okay.
And then we did another analysis of just changing the allocation factor and leaving the amounts the same that are requested. Okay. And then we combined those two, which in our opinion then helps inform us to what truly is a just and reasonable range.
And, excuse me, in the first 6 scenarios you have on 10.3 SR, scenarios at 400%, scenarios at 100%. If you could look at line 306 of your direct testimony.
Sorry. Okay.
I should have said 303 because the question that's asked is, excuse me, what is the effect of applying a different allocation factor to the revised amended request of $185.7 million for ELI costs? And you say at the beginning of line 306, for illustrative purposes, and then you record what the reduction at a 5% allocation to Utah, a 10%, and a 20% allocation to Utah would be. Is that correct?
That's correct.
Okay, so when you say for illustrative purposes, is it fair to say that there's not an independent analysis of the reason why you would apply one of those or the other? You're giving the commission information about if they want to go there, that's what it would look like. Is that fair?
Right, and to help educate the commission and other parties involved, what is the effect of, basically, it's an easy calculation or a fairly simple calculation, is what if I multiply that by 5%? What if the allocation factor was 5%? And then that's what the result is.
Okay.
And then just multiply by 10%. What is that result? And so it's just kind of that very initial sensitivity analysis.
Okay. So it's not linked to the allocation recommendations that any of the other witnesses have made for DPU?
No.
Okay.
It's not, if I'm understanding fully, is it related to the 18.6% that Mr. Gleba and Mr. Kelly land on? No, these are separate from there. Although, when I'm looking at that and when we became aware of their calculation, 18.6% is pretty close to 20. The difference between 20 and 18.6% is close.
So if I look then down at the hybrid scenarios and the ones that follow, all of those require the use of the 18.6% allocation factor, right?
Correct.
Okay. And that includes not just the ones that say scenarios using FTI analysis, that includes the two hybrid scenarios in the middle of the page.
Correct.
Okay, so you need to be a believer in the 18.6% allocation factor and the methodology supporting it if you're gonna back up one of these scenarios, right?
I don't know about the word believer, but you need to understand that it's based on the 18.6%.
Okay.
And the division's opinion is that 18.6% would fall in that just and reasonable range
Okay.
for calculation of rates.
And that's based on Mr. Gleba's calculations? right?
Correct.
Okay. And then in the FTI analysis, you combine that 18.6% allocation with what you record as RMP amended request of 185.7 million, less prudence adjustment. And when I went through your testimony, I didn't see a reference to something called a prudence adjustment. So could you tell me what that is?
Where are you referring, just so I'm clear, are you referring back to the revised 10.9?
I'm still on 10.9,
Okay.
that one we called 10.3 SR.
Right, 10.3 SR, which is what I have in front of me.
And then your last three scenarios are
Okay.
called scenarios using FTI analysis.
Okay,
And you see where I am on line 2A,
okay.
less prudence adjustment. And I guess when I read your testimony, I didn't see you calling a particular thing a prudence adjustment. So I'm trying to understand what that is.
That's the adjustment. I refer to it here as a prudence adjustment. I could have possibly titled it differently, maybe a little more descriptively. That is from Mr. Kelly's testimony, is my recollection, and that's the 46 million downward adjustment that he calculated. So we're applying that 46 million to the 185.7 million, and also the 18.6% that they had developed.
Okay, so while Mr. Kelly told us today that he was not recommending a $46 million disallowance, that's how you're using his analysis to suggest or recommend to the commission a $46 million disallowance.
Yeah, my understanding was that it was a recommendation, with our discussions with him, that it was, this would be an appropriate, how he presented it to us was, this would be an appropriate conservative adjustment to the request, the actual request.
Okay, and I had a very difficult time today talking to Mr. Kelly about whether he had any recommendation on prudence, and I think he demurred. And so I guess this is you're calling this a prudence adjustment without any testimony supporting it, or?
Right, and we could call it just, we could drop the prudence, we could just drop the recommended or
Okay.
Adjustment.
So again, you need to support the credibility of all of the analysis that's underlying the $46 million disallowance to get to any of those FTI scenarios, right?
Could you repeat that one?
You have to, you didn't like belief, but I'll say you would have to credibly, believe there is credibility in
I'd have to
adopting.
accept, okay.
I think you're on the right track. You answer the question.
I have to place some credibility in their analysis. Yes, and I have.
One last thing, if you could turn to your direct at line 231.
Okay.
Oh, I've got one exhibit I neglected to hand out. It's the only exhibit we have, so let me distribute that now if we could. That's it, yeah. Have you got it, Mr. Einfeld?
Yes, I do.
Okay. I'm not sure if you're in the room, but earlier today, there was a cross-exhibit introduced from a U.S. Department of Agriculture, U.S. Forest Service, wildfire risk to communities website. Did you hear us discuss that?
Yes, I did.
Okay. Is this a source that you consulted at all in coming up with your recommendations?
No.
Okay. I ask you to look at line 231 because you I think it's at line 231. Yes, you attached some data regarding the number of acres burned in Utah compared to other Pacific Coast states. You see that?
Yes.
Okay, so I understand you looked back at wildfire events in the past. Did you do any assessment of current or future looking likelihood of wildfire in Utah?
No, I did not.
Okay. And
I
would you
didn't feel like I had the expertise to adequately and thoroughly analyze future risks.
So you have the expertise to analyze the past, but not the present?
The future?
Okay, well, let's look at this exhibit, and I'd like to mark this as Exhibit 12, 13. This is wildfire risk to communities, and if you flip to the second page, this is Utah-specific data. This government source advises that Utah has a very high risk of wildfire, higher than 90% of the states in the U.S. And if you flip to the next page, it drills down to Salt Lake County, which it reports has a very high risk of wildfire, higher than 96% of counties in the U.S. Now, when insurers decide on renewing policies, aren't they looking at sure, they're looking at the past, but they're looking at the present and the future as well, aren't they?
Based on prior testimony, that sounds like what is the case.
Okay, so an analysis that only looks at the past might be missing something. Is that fair to say?
Oh, yes, yes.
Okay. Finally, I'd like to ask you to turn to, I'm sorry.
Just a second, do you want to move for admission?
Yes, sir. I move for admission of Cross Exhibit 13.
Okay, Rocky Mountain Power's Cross Exhibit 13 from the USDA and the U.S. Forest Service entitled Wildfire Risk to Communities. Is there any objection to its admission? Okay, it's admitted.
As I said, finally, I'll repeat that because it's true. I'd like you to turn to line 335 in your direct. And here at are you there, sir?
Yes.
Okay, line 335, about the middle of the way down, it says, FTI calculates an allocation factor of 14.3% based on an analysis of distribution and transmission lines in high-risk fire areas, or HFRA. I mean, that's incorrect, isn't it? Did you hear Mr. Gleba say that that's not what the calculation's based on?
I did hear that. I know and I'll have to go back and double check because I heard that and it's like, whoa. And because I know we pulled the information on exhibit 10.2 SR, which is the previous 10.7 direct exhibit. That page 2 has calculations that are based on distribution miles and transmission miles that are listed. My recollection is I pulled that from some information or a tab that is included in their testimony. My understanding is also that information was provided in a data request from the company to get to the transmission miles and the distribution miles.
Okay, and we went through with Mr. Gleba a few minutes ago, the data on the transmission miles and number of poles, et cetera, in the Pacific or territory and in each state. But I believe Mr. Gleba told us that his allocation, the 18.6%, is based on the Veris data, those spreadsheets we looked at, and his interpretation of what they mean, and then against the market share that Pacificor has in each state. Do you disagree that those are the components of his allocation methodology?
No, I do not.
Okay, so I'd ask you to turn to line 365.
Okay.
It says the use of line miles in high-risk areas as a base for allocating the risks against which ELI is purchased for wildfires is significantly more cost-causative than the SO factor. Again, the division doesn't have a recommendation that's based on line miles in this case, does it, for an allocation?
If you look at exhibit 10.3 SR, those numbers that are presented in lines 2A, 2B, and 2C calculate based on use distribution miles and transmission miles as part of the calculation to get to those numbers.
Well, but you're applying a calculation percentage to those miles, right? You're applying 18.6%.
Yeah, there are
Those miles?
various scenarios with regard to that. We use 18.6%, and we also use, say, for applied to distribution, and then the SO factor to transmission, and then the 18.6 to distribution and half the SO factor, and then 18.6% applied to the distribution and to the transmission subtotals.
So the 18.6% allocation factor, which does not include distribution transmission miles, is then applied to, multiplied against, however you want to put it, the transmission line and distribution miles. Is that
Right.
Right you're doing? Okay.
Right.
Okay, that's all I have, Mr. Einfeld, thank you.
Dang, we're gonna catch up.
Okay, thank you, Mr. Don't ever make bold predictions like that. All right, thank you, Mr. Magnus. Is there anyone else who has questions of Mr. Einfeld? Okay, we'll return to Mr. Gricke for any redirect.
Thank you. Since the company used this cross exhibit 13, which was provided just a few days ago, and in order to provide the commission with full and fair comparison and information, I'd like to introduce two exhibits that are from the very same website, and ask Mr. Einfeld just a few questions about them.
Could you describe what you're?
They're the same page that was provided to Mr. Einfeld, but they include all the Pacific Core states and not just Utah.
Okay,
It also has a disclaimer that's from the website. That's the other.
have those documents provided to other council? Or is this
No,
not
I,
yet?
No.
This is just something that's come up now on,
right.
okay.
Mr. Chairman, it's redirect. I mean, I think if council wanted to introduce these exhibits to Mr. Einfeld, he had him on direct. I don't understand why they're sprung on us and redirect afterwards, but
Well,
I don't mind them coming in, actually,
Yeah.
because it's from the same website.
Yeah.
It's fine, it's no problem.
Okay, well, since you have no objection, and I appreciate your notation, but you raised the cross exhibit 13 with him on cross, and so I think that, I think it's appropriate. We'll allow these to come in. We'll give them whatever weight we choose to give them, but you can, well, let me see if there's any other objections to them being admitted. Okay, we're going to admit, this will be, what are we numbering these? This is, you'll be your
I believe it's 1 and 2.
DPU redirect 1 and 2. Okay.
Thank you. May council approach.
Yes. Okay, which one is 1 and which one is 2?
Excuse me. The packet with all of the Pacific Core states will be 1, and the other exhibit, which is of
that's
just
okay.
a few pages, will be 2.
Thank you.
So just to help me, the one that has at the top, Washington has a high risk of wildfire higher than 94% of states?
That would be number 1.
Okay. This is DPU redirect 1,
We have 2 of these. We have 2 of these.
and the other is,
Oh, yeah, one's fine, yeah.
Yeah. Yeah.
okay, are we all ready to be, we're still
I
just,
think you have 2 copies
just take
on
a
this
second.
side. Oh, I see, and when there's.
Okay.
I'd like to thank you for your prediction, Mr. Einfeld, on how long this was going to take.
Look at me.
We're at 96.
Is there still some confusion on exhibits here? Are we ready to proceed?
Could we have just one moment?
Sure.
Thank you. Okay. Make sure that everybody has, when you do this, make sure everybody has everything, because I have 2 looked up and I'm not sure how.
Apologize for the delay. Mr. Einfeld, could you, in the first packet that has Washington at the top,
I don't see that. Maybe it's coming.
You jinxed us here.
Thank you.
and I presume they're in the same order. If they're not, we can
Change
work around that. So as noted, from this website, Utah is listed as having a very high risk of wildfire, higher than 90% of states in the U.S. That's correct. Is that true?
That's what this page 2 says of council's, Rocky Mountain Power Council's exhibit.
So if you turn your attention to the first state should be Washington, if you could read that first sentence there.
Washington has a very high risk of wildfire, higher than 94% of states in the U.S.
And then the next one should be Wyoming, if you could read that.
Wyoming has a high risk of wildfire, higher than 70% of states in the U.S.
We've already covered Utah, so let's move on to Idaho. If you could read that.
Idaho has a very high risk of wildfire, higher than 96% of states in the U.S.
Next should be California, and if you could read that one.
California has a very high risk of wildfire, higher than 98% of states in the U.S.
And the last one should be Oregon.
Oregon has a very high risk of wildfire, higher than 92% of states in the U.S.
Thank you. So from reading all those, it would indicate that only one other state has a lower wildfire risk than Utah in Pacific Coast Service area, according to this website.
Yes.
Thank you. If we could move on to the next exhibit. I believe it's on page 2. There should be a highlighted portion. If you could read that sentence.
Wildfire likelihood is simply a probability that any specific location, pixel, may experience wildfire in any given year. It does not say anything about the intensity of the fire if it occurs.
Thank you. Oh, yeah. I'd like to move to omit both these exhibits.
We've done that already.
Thank you. I have no more redirect.
Okay, thank you. We'll turn to Commissioner Harvey and see if he has any questions.
Can I ask one question?
Yes, one question. We'll let you ask. We normally don't have multiple rounds, but in this, since you haven't seen these before, go ahead and ask one question.
Would you agree, based on this data, all the states in Pacific Coast Territory except Wyoming are in the 90th percentile of wildfire risk?
I don't know if I can say that they're in the 90th percentile. They say they're 92%. They're all greater than 92% on here, except for Wyoming, which I recall is 70%. They're all kind of close.
Okay, thank you.
Thank you, Mr. Magnus. Okay, Commissioner Harvey, do you have any questions? Okay.
Thinking about DPU's recommendation overall, is DPU concerned with the likelihood of a wildfire or the likelihood of a utility-caused wildfire?
The DPU is primarily concerned of a utility-caused wildfire or a wildfire that could be enhanced by utility, somehow be attributed to a utility in some degree.
Okay, thank you. I think everything else has been covered by other folks.
Okay, Commissioner Clark?
No questions, thank you.
Thank you, Mr. Einfeld. Appreciate your testimony. We'll excuse you from the stand.
Thank you.
All right, I think now's the time to take our 15-minute break. We still have, seven witnesses left. Okay, thank you for counting those up for me. We'll take a 15-minute break. I told her that we would do this at the end of the day, but I think just so I don't forget, I told Ms. King and I had a conversation. I don't think it constitutes ex parte. Let me reveal it. She has a request that she wants to make, but she told me what it was, and she can make that request now.
Thank you. It sounds so suspenseful.
Yeah, yeah. I do my best to try to keep everybody hanging on my every word.
Since I didn't have any cross-examination planned for the next phase of this Phase 3 scheduled for next week, I would like to ask the commission's permission for me to participate remotely.
Okay, we are unanimously agreed you may do so. Thank you.
Thank you.
All right, let's move forward. The next witness would be Ms. Anderson from OCS. Is that correct, Mr. Moore?
Yes, that's correct.
Okay, thank you.
The Office of Consumer Services calls Ms. Allison Anderson to the stand and asks that she be sworn.
Ms. Anderson, welcome. Nice to have you with us. Would you raise your right arm? You solemnly swear the testimony you're about to give in this matter pending before the Public Service Commission of the State of Utah will be the truth, the whole truth, and nothing but the truth, so help you God.
I do.
Thank you. You may be seated. Okay, Mr. Moore.
Ms. Anderson, could you please state and spell your name for the record?
My name is Allison Anderson, Alysson, Anderson.
What is your business address and how are you employed?
My business address, good question. I'm with Jeff.
We're gonna,
One-
we'll take
160
notice that you are at the Heber M. Wells Building in Salt Lake City, Utah.
Yeah.
All right,
160
continue.
East, 300 South, Salt Lake City, Utah.
And how are you employed?
I'm employed by the Office of Consumer Services as a utility analyst.
In your capacity as a utility analyst, have you worked on this general rate case, reading the filings, preparing and offering testimony, and filing and reviewing discovery requests, etc.?
I have.
On February 7th, 2025, did you prepare and cause to be filed redacted and confidential direct testimony in Phase 3 of these proceedings?
I did.
On March 7th and 14th, 2025, did you prepare and cause to be filed rebuttal and surrebuttal testimony in Phase 3 of this docket?
Yes, I did.
If I asked you the same questions that are contained in your written testimony, would your answers be the same?
They would.
Do you have any changes you'd like to make to your testimony at this time?
I just have one typo correction. It's in my Phase 3 direct testimony at line 26. And the word requested should be changed to request. Just drop the ED on it.
I'm going to ask you a question again. With that change noted, if I asked you the same questions today, would your answers be the same?
They would.
I'd like to move to admit Ms. Allison's direct, redacted and confidential testimony and her rebuttal and surrebuttal testimony.
In Phase 3 of this docket.
Phase 3 of this
Is there
docket.
any objection to Ms. Anderson's redacted direct, her rebuttal, and surrebuttal testimony being admitted? Okay. It is admitted. Thank you.
Have you prepared a summary of your testimony in Phase 3 of this docket?
I have.
Please proceed.
Good afternoon.
Good afternoon.
My Phase 3 testimony starts with introducing the other Office of Consumer Services, or OCS witness in this phase. OCS witness Mark Ellis presented a white paper showing that there are potential benefits to self-insurance and a likelihood that it would be a workable solution to mitigate escalating ELIP costs. My direct testimony also addressed 4 issues. First, my testimony shows that Rocky Mountain Power did not provide additional evidence, as they indicated they would, to bear their burden of proof that the James verdict did not affect the ELIP costs for which Rocky Mountain Power has requested a deferred accounting order, or DAO. Thus, I take the position that the PSC should not approve the DAO. I further recommend that if the PSC authorizes a DAO, then a sharing of those costs between ratepayers and shareholders would be reasonable, since shareholders also benefit from ELIP. Second, I address why the SO factor is no longer appropriate for allocating test year ELIP costs to Utah ratepayers, and that an allocation based on wildfire risk would provide a more equitable assignment of costs. Again, I recommend that the excess liability insurance benefits both shareholders and ratepayers, and therefore the costs should be shared. Third, I reiterate the reasons why the OCS opposes Rocky Mountain's proposal for an insurance cost adjustment, or ICA, to recover liability insurance cost premiums as premature. And fourth, I articulate the OCS's recommendation that the PSC require Rocky Mountain Power to report back on the viability of self-insurance within 6 to 9 months. In my Phase 3 rebuttal testimony, I observed the similarities of other non-company parties' positions and recommendations to the OCS recommendations regarding the DAO, the ICA, and test year ELIP. I also offer some refinement of my view on allocating ELIP costs informed by the positions presented by other parties. In my Phase 3 surrebuttal testimony, I corrected my rebuttal testimony for the test year ELIP costs requested by Rocky Mountain Power, and also corrected some misconceptions about my previous testimony. Today, I recommend that the PSC should deny the request for a deferred accounting order, as Rocky Mountain Power has not shown the James verdict did not impact the ELIP, and therefore would likely be recoverable in rates. The PSC should deny the request for the ICA, which is premature and not fully developed. If an ICA is approved, the PSC should reject the alternate interclass cost allocation proposal put forth by the UAE and Utah Large Customer Group. The PSC should reject the use of the SO factor in allocating test year ELIP costs to Utah customers and consider the totality of evidence of the different proposals in determining just and reasonable rates. And finally, the PSC should require Rocky Mountain Power to provide an initial evaluation of viability and relative cost of self-insurance within 6 to 9 months so that stakeholders can review and input prior to the ELIP renewal in February 2026. And this concludes my summary.
Ms. Anderson is now available for cross and questions from the commission.
Okay, thank you, Mr. Moore. Cross-examination from Rocky Mountain Power.
Rocky Mountain Power has no cross for Ms. Anderson.
Okay. Division,
No
doesn't-
cross.
Okay, Mr. Russell?
No cross.
Okay, Ms. King?
No cross.
Ms. Hayes?
None,
Oh,
thank
no,
you.
Captain Rivera?
No cross, sir.
Okay, all right. Well, okay, we'll see if Commissioner Harvey has any questions.
Well, I was going to ask one very slight clarification, but I think I'll just go with the flow.
You've turned over a new leaf, that's just... All right, Commissioner Clark.
I don't have any questions, thank you.
Ms. Anderson, you may have beat the record. I think I did. That was very, very good. Okay, you're dismissed. This is because it's late in the day and we're wearing down. I was expecting 30 minutes of cross here, so thank you for that pleasant surprise. Okay. The next witness is appearing virtually. Is that correct?
Yes, Mark Ellis is, I believe he's with us on the screen. And the office would call Mark Ellis and ask that he be sworn.
Mr. Ellis, would you raise your right arm to the square, please? You solemnly swear the testimony you're about to give in this matter pending before the Public Service Commission of the State of Utah shall be the truth, the whole truth, and nothing but the truth, so help you God.
Yes, I do.
You're gonna need to speak up, get closer to a microphone. We're having a hard time hearing you. Would you?
Yes, I do.
Great, thank you.
Mr. Ellis, could you state and spell your name for the record?
My name is Mark Edward Ellis, M-A-R-K, E-D-W-A-R-D, E-L-L-I-S.
What is your business address and how are you employed?
My business address is 8595 Nottingham Place, La Jolla, California, 92037. I am self-employed.
For whom are you testifying today?
The Office of Consumer Services.
Since this is the first time you testified before the Public Service Commission of Utah, could you please provide the commission with a brief summary of your qualifications?
Yes. I have worked in the energy industry for over 30 years. Before becoming an independent consultant 6 years ago, for 15 years, I was the Chief of Corporate Strategy and Chief Economist at Sempra, the parent company of San Diego Gas and Electric, Southern California Gas, and Encore Electric Delivery in Texas. Previously, I was a consultant for McKinsey & Company and a financial and economic analyst for ExxonMobil. I have an MS from MIT and a BS from Harvard. Of relevance to my testimony today, I previously developed PG&E's wildfire liability self-insurance program, which has been successfully implemented and has saved customers over $1 billion to date. Southern California Edison also implemented a program similar to the model developed for PG&E.
Did you prepare and cause to be filed direct testimony together with exhibits 2.1D and 2.2D on February 7th, 2025?
Yes.
Do you have any changes you would like to make at your testimony and exhibit at this time?
No.
If I asked you the same questions that are in your written testimonies, would your answers be the same today?
Yes.
I move to admit Mr. Ellis' direct testimony and exhibits.
Okay, is there any objection? We'll admit Mr. Ellis's direct testimony and the exhibits into the record. Thank you.
Mr. Ellis, have you prepared a summary of your testimony to provide to the commission at this time?
Yes.
Please proceed.
Thank you. Good afternoon, Chairman Fenn and Commissioners Clark and Harvey. I appreciate this opportunity to testify before the Commission. My testimony addresses the topic of utility wildfire liability self-insurance for Pacific Corp. Given the increasing risk of catastrophic wildfires across the western U.S. and the rising cost of commercial insurance, self-insurance offers a potentially more cost-effective and flexible alternative. My key findings and recommendations are as follows. Pacific Corp and the PSC can design a utility wildfire liability self-insurance program that both is more cost-effective and provides greater flexibility in allocating risk than commercial insurance. This would involve careful consideration of various factors, leveraging this experience of other states, including economic comparison of self-insurance and commercial insurance. This would involve a thorough cost-benefit analysis, considering the long-term savings potential of self-insurance against the initial setup costs and the risk against its initial setup costs and the risk of large unexpected wildfire events. Leveraging the experience of states like California, which has seen utilities facing significant challenges in the commercial insurance market due to wildfire risks, can highlight the potential cost advantages and disadvantages of self-insurance. Analyzing the financial performance of utilities that have transitioned to self-insurance or utilize wildfire funds can also provide valuable insights. Coverage and terms. Self-insurance offers the flexibility to tailor coverage to Pacific Corp's specific risks and mitigation strategies, potentially including events like public safety power shutoffs, PSPS, and specific mitigation investments. Coverage in terms also involves examining the coverage terms of state-sponsored catastrophic insurance programs, like they have in California, which can offer models for structuring self-insurance coverage, including setting appropriate deductibles and coverage limits. Another important factor to consider is incorporating a prudency review process. A crucial consideration is whether and how to incorporate a prudency review similar to those in state catastrophic fire funds to ensure accountability and fair allocation of costs between shareholders and ratepayers. California's established prudency review process for utility wildfire costs provides a detailed example of its legal basis, the role of the Utilities Commission, the reasonableness standard, and the factors considered.
Mr. Ellis, hang on just a second. Would you start that, going back probably 15 seconds into your summary of your testimony and just present it a little slower? It's late in the day. We've got a court reporter that's got to keep up with you.
Yes, sir. Yeah. I will go back to incorporating a prudency review process.
Thank you.
A crucial consideration is whether and how to incorporate a prudency review, similar to those in state catastrophic wildfire funds, to ensure accountability and a fair allocation of costs between shareholders and ratepayers. California's established prudency review process for utility wildfire costs provides a detailed example of its legal basis, the role of the Commission, the reasonableness standard, and the factors considered, such as the utility's Wildfire Mitigation Plan, WMP. Understanding the benefits, drawbacks, and criticisms of California's approach is essential for designing a suitable process for Utah. My testimony notes that Utah's process would likely differ due to the absence of California's inverse condemnation doctrine. Another factor to consider is organizational and institutional requirements. Implementing self-insurance requires developing robust internal risk assessment and management capabilities within Pacific Corp and establishing clear regulatory frameworks for oversight and consumer protection by the Utah PSC. Learning from states that have implemented self-insurance or wildfire funds can provide insight into the necessary organizational structures, expertise required, and regulatory mechanisms for ensuring the adequacy and transparency of the program. Another factor to consider is allocation of wildfire liability costs across Pacific Corp service territory. Given the varying physical and legal wildfire risks across Pacific Corp's 6-state service territory, traditional cost allocation methods may not be appropriate for allocating self-insurance costs. A risk-based allocation approach may be fair. Understanding how other multi-state utilities handle the allocation of similar risks or insurance costs can inform Pacific Corp's approach. Another factor to consider is exploring alternative self-insurance mechanisms. My testimony proposes a revolving credit facility as an alternative to a traditional reserve fund. Leveraging the experience of other states with securitization of utility costs, such as the wildfire cost recovery bonds issued by PG&E and approved for Southern California, Edison, and California, can inform the feasibility and design of a revolving credit facility, or RCF, backed by securitized bonds. Understanding the regulatory approvals and financial structures used in these cases is crucial. And the final factor to consider is transitioning from commercial insurance to self-insurance. Careful planning is needed to ensure no gaps in coverage during the transition, and examining how other utilities have managed this transition, whether through a phased approach or other financial instruments, can provide valuable insights. By carefully considering these factors and researching the experiences of other states, particularly California, which has significant experience with utility wildfire liability and mitigation, the Utah PSC and Pacific Corp can design a self-insurance program that is tailored to Utah's specific circumstances, that is also cost-effective and protective of both customer and shareholder interests. As part of my testimony, I also conducted an illustrative, hypothetical, probabilistic analysis of Pacific Corp's wildfire liability risk to provide insights into the nature of this risk and the relative merits of self and commercial insurance, as well as the design of the self-insurance program. While not intended to reflect Pacific Corp's actual costs, this model highlights several key dynamics. One, even though the risk of a major wildfire loss exceeding a reasonable annual coverage limit is low in any one year, the probability of exceeding the coverage limit at least once in a multi-year period, like 10 to 15 years, can be quite high. 2, the relative contributions of Pacific Corp's 6 states to the aggregate wildfire risk profile may differ significantly from typical cost allocation methods based on physical plant or revenue, potentially by a factor of 3 or 4. Allocating self-insurance costs based on risk would be fair to customers and it could address potential moral hazard concerns. 3, due to the skewness of the wildfire loss probability distribution, expected losses are relatively small relative to the large losses insurance is intended to cover. So wildfire risk is characterized by infrequent but very large losses. As the coverage limit increases, the share of expected losses covered also increases, but at a declining rate, which means the fund becomes increasingly idle. The larger the fund, the less you end up drawing, the smaller percentage of the total fund, on average, you end up drawing down. 4, a cap on annual payments below the reserve fund's coverage target, for example, annual payments of $250 million for a $1 billion fund, would erode the share of insured losses covered compared to commercial insurance, which pays up to the limit annually. If instead it is assumed the fund will be fully replenished immediately after a loss, financially, that is equivalent to having no insurance, but with an added upfront cost to fund the reserve. 5, self-insurance reallocates wildfire liability risk rather than changing the underlying exposure. Capping annual payments below expected losses means customers are not bearing the full risk. And finally, a self-sustaining financing model for a reserve fund where investment returns alone cover expected losses will require a very large fund that is likely unaffordable. Utilities' unique business model as regulated monopolies with captive customers and cost of service-based rates offers unusual flexibility in the timing of payments for self-insurance coverage. This flexibility can significantly reduce the cost and potential regret of self-insurance and increase liability coverage. In my testimony, I propose an alternative approach to a traditional self-insurance reserve fund, a revolving credit facility, RCF, that can be drawn upon to cover claims as they are incurred and then repaid afterward over time. An RCF can address the early year coverage erosion of a reserve fund and the issue of idle capital, by delaying customer payments until actual losses occur. An RCF can reduce the potential for regret associated with funding a reserve that may not be used. An RCF can potentially provide more coverage at a lower cost than the reserve fund. For example, a $1 billion target and a $250 million annual payment cap over 15 years, an RCF covered a higher percentage of both total and insured losses compared to reserve fund with lower average customer payments. An RCF allows for optimizing coverage within a customer payment cap by extending the replenishment period, thus increasing the coverage limit and the share of total losses that can be self-insured. An RCF can incorporate a prudency review process, allowing regulators to disallow cost recovery if the utility's actions were not prudent. There are finally, the final point with an RCF is that there are industry precedents for securitizing utility wildfire liability costs after the fact, which can be used to reduce the financing cost of the RCF. I'll close with some proposed next steps for the PSC and Pacific Corp to consider. Further research and detailed design considerations for incorporating a prudency review process into self-insurance, detailed analysis and quantification of Pacific Corp's wildfire liability risk to provide a robust foundation for any insurance program design, and a thorough exploration of the feasibility and design of the revolving credit facility in consultation with financial and risk management professionals. In conclusion, Wildfire liability self-insurance holds promise for managing Pacific Corp's wildfire risk in a manner that protects the interests of both customers and shareholders by potentially lowering costs and increasing coverage. Thank you for the opportunity to participate today in this proceeding and to present this summary of my testimony.
Thank you, Mr. Ellis. It's my understanding that we can see you, and we have been able to see you through your summary. You cannot see us, though, is that correct?
Yes.
Okay. All right. Go ahead, Mr. Moore, go back to you.
Mr. Ellis is now available for cross and questions from the commission.
Okay. Is there a cross-examination of Mr. Ellis?
No cross for Rocky Mountain Power.
All right. Does any other party have cross-examination for Mr. Ellis? Okay. Let's turn to Commissioner Harvey.
I can't do two in a row. Could you give us your professional opinion on the pros and cons of thinking of a revolving credit facility on a multi-state, whole company basis versus a state-by-state basis?
So the issue of multi-state application is separate from the consideration of, or the comparison of a reserve fund or a revolving credit facility. So in other words, that issue has to be wrestled to the ground regardless. I have not thought through the securitization per se of these, how you would do that if different states allow securitization versus others. That's not something I've investigated in detail.
All right, thank you. And then in reading your testimony, you spoke a bit about a divergence, at least I understood it this way, between shareholder interest and customer interests. Could you explain what that difference is and how it might impact the formation of a, say, a revolving credit approach?
Yeah, I'm not sure. Could you elaborate on the divergence? I don't have my testimony in front of me. Could you perhaps read the passage or elaborate a little bit?
Actually, I'll withdraw that if it's not ringing a bell. That's fine.
Yeah.
And that I'll conclude with that. Thank you.
Commissioner Clark, do you have any questions?
No questions, thank you.
Okay.
Can I comment
Please.
One to the previous question?
Yes.
So I think the issue of the potential divergence of customer and shareholder interests is inherent to self-insurance, period, regardless of the funding mechanism. So there's always a risk that if the insurance covers things, there's always the risk that the insurance program could be designed in a way that covers things, covers risk that rightly ought to be the responsibility of the utility, and vice versa. That ought to be, hey, this is a act of God, should be socialized risk. And that just gets into the details of the design of the insurance program, and probably is less relevant to how that the insurance is funded, whether through a reserve or an RCF.
Thank you, Mr. Ellis. My understanding is Ms. Stewart, on behalf of Rocky Mountain Power, has also expressed interest in looking at alternative insurance mechanisms in the future, including self-insurance. Give me your, if you have one, an estimate of the complexity of this process and how long it would take to, if it was done on a multi-state basis versus which is, I assume, was what Pacific Corp is considering versus if it was a standalone state basis, and if is it even possible to do this on a standalone state basis, in your viewpoint?
So, if you don't mind, restate, it sounds like there were several questions.
There were, I apologize, that wasn't a very good, I wasn't trying to do cross-examination, I was just trying to
Yeah.
get out the concept. Do you think, I think you understand what I'm asking generally.
Yeah. So I'll address the easier question first, which is how quickly. So I mentioned in the beginning that I designed a self-insurance program for PG&E, and that was basically within the GRC. It went from not on the radar screen, or on the radar screen, but not seriously considered, to, no, that's what they ended up doing, to the exclusion of commercial insurance. Their commercial insurance was very, very expensive. And so they decided to build a reserve instead. So it could be done quickly.
Well, just let me just interject there, the quickly, as I understand it, California does not have a 240-day statutory period to complete a general rate case, is that correct?
Yes.
Is your understanding? So how long did it take you altogether approximately? Was it 18 months, 6 months, 12 months? What's your, got any recollection?
You know, my work, yeah. So I parachute in for specific issues on the GRC, not the whole process. I do know that this issue was accelerated and they were able to implement it quicker than the entire GRC because they were forced based on the renewal of existing policies to say, are we going to renew or are we going to do something different? And so from that basis alone, they had to do it within less than a year.
Okay.
And so they were able to reach a sort of, on this one issue, all parties will agree. The rest of the GRC will continue along its ordinary course, is how this was implemented in that case.
And that was just a standalone mechanism for California, correct?
For PG&E, yeah.
For PG&E in California?
Yeah.
Yeah, okay.
Yeah, self-insurance is widely used across all types of industries, not just utilities. So they were able to basically cut and paste or copy what has been done and all the established procedures for ensuring arm's length dealing and so forth for self-insurance that are used elsewhere. So then I think does that satisfy the
Yes, that satisfies my inquiry.
First question. Then the second question around how to handle it across multi-states. So that is new. So Pacific Corp, I think, is the first to have to really wrestle with that issue with respect to wildfire liability insurance.
Yeah.
So that could slow things down. I think you asked whether, hey, would it make sense to set up a reserve or a self-insurance by state? So it's probably less than ideal, but it's possible. And in particular, if you go down the path of the revolving credit facility where you only pay after the fact, that actually lends itself a little bit more to, if you're forced to set up insurance by state because you can do securitization in one but not the other, or for other reasons, cost allocation and so forth, then the RCF may be a way to skirt that issue by setting up RCFs per state.
Okay, thank you, Mr. Ellis. Well, the issue has been raised in this docket, and where it goes, we'll see. But there appears to me to be some complexity, given the fact that there's an April 25th date for a final order. But the issue and the comments have been made by various parties. I think we're obviously interested in seeing what direction that takes in the future. So thank you, Mr. Ellis. You're excused. Appreciate you appearing today remotely. Okay. Thank you. UAE's witness.
The Utah Association of Energy Users calls Kevin Higgins.
Mr. Higgins, welcome. It's nice to see you again. Would you raise your right arm to the square? You solemnly swear the testimony you're about to give in this matter pending before the Public Service Commission of the State of Utah shall be the truth, the whole truth, and nothing but the truth, so help you God.
Yes, I do.
Thank you. Please be seated.
Good afternoon.
Good afternoon, Mr. Russell.
Could you state your name for the record, please?
Kevin C. Higgins.
Can you tell us who you work for and in what capacity?
I'm a principal in the consulting firm Energy Strategies.
And on whose behalf do you offer testimony in this proceeding?
I'm here on behalf of the Utah Association of Energy Users, or UAE.
And did you cause to be filed direct and surrebuttal testimony on excess liability insurance premiums in this Phase 3 proceeding?
Yes, I did.
And I'll identify them individually. The direct testimony is labeled as UAE Exhibit Phase 3 7.0, along with Exhibits 7.1 through 7.6. And surrebuttal testimony was labeled as UAE Exhibit Phase 3 9.0, along with Exhibit 9.1. Does that sound right?
Yes,
Okay. And with respect to that testimony, do you have any corrections to make?
I do not.
And if asked the same questions today that you were posed in your pre-filed testimony, would you answer the same?
Yes, I would.
And at this point, I'll move for the admission of Mr. Higgins' Phase 3 ELIP testimony, both direct and surrebuttal.
Okay, UAE has made the request to admit Mr. Higgins' direct and surrebuttal testimony in Phase 3. Are there any objection to it? And the exhibits? Okay, seeing no objections, we'll admit it. Thank you.
Mr. Higgins, have you prepared a summary of your testimony?
Yes, I have.
Please proceed with that.
Thank you. Good afternoon, Chairman Fenn, Commissioner Clark, Commissioner Harvey. My testimony in this phase of the case addresses the subject of wildfire-related excess liability insurance expense for Rocky Mountain Power. I offer the following primary conclusions and recommendations. Number one, I recommend against adoption of the company's proposed insurance cost adjustment, or ICA, to the extent it could be used in the future as a mechanism to change the revenue recovered from customers for wildfire excess liability insurance costs or self-insurance costs between rate cases. The very name insurance cost adjustment suggests that the mechanism would be used to periodically adjust the amount collected from customers for this single item of costs. Rather, I recommend that the test period excess liability insurance costs continue to be recovered in base rates. Number two, it is clear that wildfire-related excess liability premiums have been increasing significantly in the western U.S. Yet I am not aware of any utility in this region whose premiums have increased as dramatically as PacifiCorp's since 2019. In my opinion, the company should bear the portion of any increase in excess liability premiums that is attributable to insurers considering the company to be riskier than other utilities because of its past performance in managing wildfire risk. I acknowledge that it is difficult to identify with precision what this amount is, but I believe a conservative estimate of the share of incremental excess liability costs that should be borne by shareholders is approximately 9.5%. While the company has been able to demonstrate that the James verdict is not included in its lost history, other 2020 Labor Day weekend fires attributed to the company are included in that history and have impacted the increase in the company's excess liability insurance premiums. The company's request for deferral and/or recovery related to the excess liability premiums is not accompanied by any evidence regarding the prudence of its actions with respect to those fires or any basis on which to conclude that its conduct was different from that considered by the jury in the James verdict. What we do know from the record is that one of the company's insurers, Energy Insurance Mutual, or EIM, is levying a special charge of $24.5 million
applied to PacifiCorp's 2024 through 2026 excess liability insurance premium. This special charge is called a loss premium assessment, and it is being applied by EIM because EIM paid a full limit loss of $127.5 million for PacifiCorp's 2020 Labor Day weekend wildfires. I note that the full limit loss, and therefore the loss premium assessment, is not associated with the James verdict. EIM is charging PacifiCorp a loss premium assessment on a going-forward basis because of the magnitude of the past claims EIM paid out as a result of the 2020 Labor Day weekend fires. To be clear, I am not arguing that the company's decision to pay the EIM loss premium assessment was imprudent. But absent sworn testimony from an insurance provider, this explicit charge may offer the best insight available to us regarding the additional company-specific costs attributable to the 2020 Labor Day weekend fires that PacifiCorp is facing from the insurance industry. Accordingly, I am recommending a downward adjustment to the test period revenue requirement for excess liability insurance of approximately $16.7 million on a total company basis, which is about $7.4 million on a Utah allocated basis. This adjustment corresponds to approximately 9.5% of the company's incremental excess liability costs. Point number 3. In Rocky Mountain Power's Phase 3 direct filing, the company requested authority to defer approximately $112.1 million on a total company basis for excess liability insurance premium expenses, which is approximately $49 million on a Utah allocated basis. However, in its Phase 3 rebuttal testimony, the company has more than doubled its requested deferral to approximately $104.4 million on a Utah allocated basis, because the company has expanded the requested deferral to go beyond the expenses from the 2023 to 2024 coverage period to also include the 2024 to 2025 coverage period through April 30th, 2025. I recommend against allowing an increase in the amount of the company's requested deferral at this stage of the proceeding, and in particular including costs that coincide with the 2025 test period in the ongoing general rate case. In the event the Commission concludes that it would be just and reasonable to permit PacifiCorp to recover some portion of the initial requested deferral amount, it would not be unreasonable for the Commission to apply a conservative disallowance of 9.5% of the requested deferral, which is the same percentage disallowance I am recommending with respect to the incremental excess liability insurance costs for the test period. And finally, point number 4, is I am recommending that wildfire-related insurance costs remain in base rates. I also recommend that the Phase 2 stipulated rate spread apply to the overall base revenue requirement approved by the Commission in this case, inclusive of the wildfire-related insurance revenue requirement. However, to the extent that wildfire-related insurance costs are recovered in a separate rider, like the insurance cost adjustment mechanism proposed by the company, then it would be necessary to recover these costs using a reasonable cost-based approach. In the event the Commission approves the ICA, then I recommend that wildfire-related insurance costs be functionalized to transmission and distribution, and then allocated on the basis of each class's share of gross transmission and distribution plant. And that concludes my summary.
Thank you. Mr. Higgins is available for cross-examination and Commission questions.
Okay, cross-examination of Mr. Higgins, Rocky Mountain Power.
Rocky Mountain Power has no cross.
All right, see if the division has any cross.
No cross.
No cross from the office.
Okay,
No cross.
Ms. King,
No cross.
Ms. Hayes.
None from me.
Okay, let's go to the commissioners and see what questions we have.
Just clarification for your last point, talking about the settlement and how rates will be charged. The hypothetical, I can think of two different cases. One is the ICA is approved, as you talked about in that. What if it's not?
If it's not approved, then I'm recommending that it be treated within the framework of the Phase 2 settlement agreement. It would remain in base rates. And one of the virtues of the Phase 2 settlement is that it's applicable to any revenue requirement. And so in that case, these wildfire-related insurance costs would be part of the base revenue requirement and treated just like all the other Phase 2 revenue requirement for the purpose of rate spread.
Okay, thank you. That's all I have.
Commissioner Clark?
I have no questions, thank you.
Thank you, Mr. Higgins. I don't have any questions either. You may be excused.
Thank you.
Thank you very much for being here. All right, the Utah Large Customer Group has a witness, Ms. King.
Thank you. Thank you. The Utah Large Customer Group calls Ms. Billy LeConte to the stand. Ms. LeConte, can you hear me? I can't hear you. I can see you.
We think your mic may not be turned on. Still can't hear you.
No, we can't, unfortunately. Maybe we can try calling in. The test worked before, so I apologize for the delay.
Can I just pause and go off the record? So
We've got
it
a
shows that she's
mark.
muted
Yeah.
on the top right of her screen, so she needs to unmute in the program.
I'm sorry.
Now we can hear you.
Wonderful.
Okay, thank you.
Okay. Good afternoon, Ms. LeConte. Can you please state and spell your name for the record?
My name is Billy LeConte. It's spelled BILLIE, LACONTE.
And by whom are you employed and in what capacity?
I'm an associate at J. Pollock Incorporated.
Okay, and let's stop right there after you've given that information because I haven't sworn her yet.
I'm sorry. Got so excited the sound was
Well,
working.
we had problems with our audio, so that's understandable. Ms. LeConte, would you raise your right arm to the square, please? Do you solemnly swear the testimony you're about to give in this matter pending before the Public Service Commission of the State of Utah shall be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you very much. You may proceed, Ms. King.
Thank you. And Ms. LeConte, I trust that you've provided true and correct answers to the questions I previously asked you, right?
Yes, that's correct.
Thank you. Have you testified before this commission before?
I have not.
Can you please provide a brief summary of your credentials to testify here today?
Yes, I've been involved in the regulatory utility commission field for 30 years. I've represented large industrial customers on issues related to regulated utilities in over 15 states and several provinces in Canada. I have a bachelor's degree in mathematics from Boston University and a master's of business administration from Washington University in St. Louis.
Thank you. And are you the same Billy LeConte who submitted Phase 3 direct testimony and exhibits as amended on February 25th, 2025, including exhibits BS1, BS2, and BS3 on behalf of the Utah Large Customer Group?
Yes, that's correct.
And do you have any further corrections with respect to your direct testimony and exhibits?
No, I do not.
And are you the same Billy LeConte who submitted Phase 3 surrebuttal testimony on behalf of the UTLCG in this proceeding?
Yes, I am.
And do you have any corrections to offer with respect to your surrebuttal testimony?
No, I do not.
If I were to ask you the same questions as contained in your pre-filed written testimonies, would your answer be the same?
Yes, I would.
With that, I would move the admission into the record of Ms. LeConte's direct testimony as amended and exhibits, as well as Ms. LeConte's rebuttal testimony.
Okay, thank you. It's been moved that we admit the amended direct testimony of Ms. LeConte on behalf of the Utah Large Customer Group, as well as her rebuttal testimony as well, and any exhibits that there may have been attached to that. Is there any objection? All right, it is admitted. Thank you.
Ms. LeConte, have you prepared a summary of your testimony and your recommendations in this Phase 3 rate case?
Yes, I have.
Please proceed with that.
Good afternoon, Chairman Fenn, Commissioner Clark, and Commissioner Harvey. My name is Billy LeConte, and I'm here today to present a summary of my testimony and recommendations on behalf of the Utah Large Customer Group. At the outset, I'd like to thank you for allowing my remote participation in today's hearing. I'd much rather be there with you all in person and greatly appreciate the accommodation.
You're welcome.
My summary today concerns RMP's proposed excess liability insurance, or ELI expense, its proposed deferred accounting order, DAO, related to ELI expense, incurred prior to the test year in this base rate case, and its proposed insurance cost adjustment, ICA rider. RMP is seeking to recover $185.7 million total company, or $82 million Utah allocated for ELI expense in the test year. In addition, RMP seeks approval of the deferral of approximately $104.4 million Utah allocated of ELI premiums incurred since 2023 that were at issue in the underlying DAO proceeding, which the Commission denied. RMP seeks recovery of these ELI expenses through a newly proposed ICA rider. After the test period, RMP proposes that the ICA surcharge could support a self-insurance program in lieu of potentially higher commercial premium costs, or some combination of self-insurance and commercial insurance, to be determined in a future standalone proceeding. RMP's ELI expense has increased significantly compared to other similarly situated utilities, which reflects the impact of the James v. PacifiCorp verdict against PacifiCorp, finding it grossly negligent, willful, and reckless in causing wildfires that occurred in Oregon during 2020. The Commission should limit the allowed test period ELI expense to $61.7 million, which is $20.3 million less than RMP's proposed $82 million ELI expense. My recommended adjustment is actually a normalization of the costs based on PacifiCorp's own ELI expense history. My adjustment recognizes the higher ELA costs that RMP may face, while also protecting Utah ratepayers from being adversely impacted or subsidizing the James v. PacifiCorp verdict in Oregon. The DAO expense should be denied. This issue is consolidated into this proceeding for a rehearing to understand the issues of whether RMP's tortious conduct is a substantial or primary cause of its increased premiums, and specifically whether RMP has presented additional evidence to further demonstrate that the James v. PacifiCorp verdict did not cause the increase in the company's excess liability insurance premiums expense. Based on my analysis, it is apparent that RMP's incurred ELI expense is indeed largely attributable to the James v. PacifiCorp verdict and associated liabilities and litigation. While RMP may claim that its insurers determined the James v. PacifiCorp verdict did not affect its ELI expense, its proof falls short and fails to consider the discretionary adjustments that its numerous insurance providers may have made. Thus, it does not appear that RMP has met its burden, and the DAO should be rejected. If the Commission elects to authorize the DAO, then I recommend a normalization adjustment similar to the normalization adjustment for ELI expense, which would lower the DAO amount by $5.8 million. The proposed ICA rider to recover ELI expense and potential future wildfire-related expenses should be denied. The proposed ICA rider is an example of piecemeal or single-issue rate making, which, once approved,
allows RMP to track and potentially adjust rates to recover changes in a specific cost in isolation, separate from the context as a whole. This lacks any holistic consideration as to whether a rate increase is needed to provide an opportunity for RMP to earn a reasonable rate of return. Because piecemeal rate making allows rates to change outside the scrutiny of a general rate case, irrespective of the utility's earnings, and effectively guarantees dollar-for-dollar cost recover, it reduces RMP's incentives to minimize costs and shifts risks from shareholders to customers. Without further specificity and a clear justification of whether and to what extent the ICA rider is needed, it provides RMP a guarantee rather than an opportunity to earn a reasonable rate of return. Therefore, the ICA rider should be rejected. If the Commission authorizes the ICA rider, I recommend that the cost be allocated similar to the costs in the wildfire mitigation balancing account, which is based on transmission and distribution costs. Finally, I recommend that the Commission consider reducing RMP's authorized return on equity to recognize that the proposed ICA rider significantly reduces RMP's financial risk. That concludes my summary.
Thank you, Ms. LeConte.
Thank you. With that, Ms. LeConte is available for cross-examination and questions of the Commission.
Okay, thank you. We'll turn first to Rocky Mountain Power for any cross-examination.
Rocky Mountain Power has no cross-examination.
Okay, division?
No questions?
No questions, thank you.
No questions, thank you.
Okay. And, okay, so none of the parties have any questions on cross. We'll turn to Commissioner Harvey and see if he has any questions.
No questions, thank you.
Commissioner Clark?
And I don't have any questions either. Thank you.
Okay, thank you. Well, I'm looking here. Thank you, Ms. LeConte. We appreciate you being able to be with us remotely today, and it appears that there's no questions after your summary. Thank you very much. You may be excused.
You're welcome. Thank you.
Okay. All right. It looks to me like it's Ms. Hayes' witness next.
Yes, my turn. Thank you. Western Resource Advocates will call Carl Boothman.
Welcome, Mr. Boothman. Will you raise your right arm to the square? I solemnly swear the testimony you're about to give in this matter pending for the Public Service Commission of the State of Utah shall be the truth, the whole truth, and nothing but the truth, so help you God. Thank you. You may be seated.
Good afternoon, Mr. Boothman.
Good afternoon.
Will you please state your name for the record?
Yes, my name is Carl, middle initial G, Boothman.
By whom are you employed and in what capacity?
I am employed by Western Resource Advocates, or WRA, as a senior policy advisor.
Have you previously testified for this commission?
Yes, I submitted testimony and rebuttal testimony in Phase 1 and Phase 2 of this proceeding.
Thank you. Did you submit for filing confidential and redacted versions of Phase 3 direct testimony on February 7th, 2025, along with exhibits KB7 through KB12?
Yes.
And did you submit for filing Phase 3 surrebuttal testimony on March 14th, 2025?
Yes.
Do you have any changes or corrections to any of your pre-filed testimony?
No.
If I asked you the same questions today, would your answers be the same?
Yes, they would.
I will now offer the admission of the pre-filed Phase 3 testimonies and exhibits of Carl Boothman.
Okay, thank you. It's been moved that we admit thank you, Ms. Hayes. Motion to admit the testimony exhibits of Mr. Boothman in Phase 3 of this document. Any objection? Seeing none, they're admitted.
Do you have a summary of your testimony for the commission?
Yes, I do.
Please proceed with that.
Good afternoon, almost evening, Chair Fenn, Commissioner Harvey, and Commissioner Clark. In my Phase 3 testimony, I addressed test period excess liability insurance premiums, and I addressed the Insurance Cost Adjustment Proposal, or ICA. On the ICA, I reiterated the conclusions and recommendations that I offered in Phase 1 of this rate case, and I resubmitted the portion of my Phase 1 testimony that addressed the ICA at length. It is my position that the company's justification for this surcharge is based on a premise that has not been established in the record of this rate case, that the ICA is necessary to propose a future insurance mechanism that may include self-insurance or other approaches to wildfire liability risk management. There has been no evidence presented that the absence of such a surcharge has hindered the development of a new insurance mechanism. Because no details of the company's forthcoming insurance mechanism exist, and approval of that mechanism will take place in a separate docket, the ICA would collect annual excess liability insurance premiums via surcharge outside of a rate case. This diminishes the principal incentive for the company to control insurance costs, regulatory lag. Therefore, I recommend that the Commission reject the company's ICA proposal. Turning now to the test period excess liability insurance, or ELI premiums. First and foremost, I believe the primary consideration for the Commission is to distinguish the portion of rising insurance premiums that are based largely on exogenous factors, such as increasing climate-induced wildfire risk and other human factors, from the cost drivers that are influenced by the company's conduct and business practices, such as loss history, findings of negligence, litigation and settlement payouts, and other operational decisions. In direct testimony, I provided contextual evidence regarding insurance procurement and pricing from other jurisdictions and utilities of similar size and wildfire risk. Given that the company's ELI expense has risen far beyond that of comparable utilities with similar coverage amounts, the purpose of this evidence was not to estimate a true cost of ELI premiums for the company based on other utilities, but rather to inform the Commission on the portion of ELI expense that could reasonably be attributed to exogenous factors and the portion that could reasonably be explained by the company's conduct or actions judged at the time the action was taken. The secondary purpose of presenting information from other jurisdictions is to highlight the complicating factors of asymmetric information and asymmetric risk that are inherent in insurance procurement. As insurance expense has ballooned from an insignificant line item to a significant one, increased visibility into the industries and the company's procurement practices becomes much more important. I acknowledge the company is in an unenviable position. However, regulators and interveners must have proof that the company took every available opportunity to mitigate the cost of ELI premiums so that only prudently incurred costs are passed through to ratepayers. The issue of asymmetric risk is now apparent as ratepayers bear the entirety of the risk of insurance premium cost increases for the company's practices over which ratepayers have no autonomy. Based on the evidence, I calculated a range of insurance expense that could reasonably be explained by exogenous factors and by following best practices to mitigate insurance costs. I believe the company's recoverable test period ELI expense should fall within this range. This concludes my summary.
Thank you, Mr. Boothman. Mr. Boothman is available for questioning.
Okay, thank you for your summary, Mr. Boothman. Appreciate that very much. Any questions from Rocky Mountain Power?
No cross.
Okay, does anybody else have any cross-examination? Okay, seeing none, we'll turn to Commissioner Harvey.
No questions, thank you.
Commissioner Clark.
I have no questions, thank you.
Give me 1 second. I don't have any questions either. We'll excuse you, Mr. Boothman.
Thank you for the suspense.
Well, it would have gone down the road I don't think I needed to go down today. Okay, thank you. Wow, we're making great progress. I think Mr. Mitchell's next. So are you, Ms. Hayes, are you, once again,
Yes, I have been asked by Utah Clean Energy to call Dr. Logan Mitchell.
okay. Dr. Mitchell, good to see you again. Will you raise your right arm? Do you solemnly swear the testimony you're about to give in this matter pending before the Public Service Commission of the State of Utah shall be the truth, the whole truth, and nothing but the truth, so help you God? Please be seated.
Good afternoon, Dr. Mitchell. Will you state your name and title for the record?
My name is Dr. Logan Mitchell, climate scientist and energy analyst for Utah Clean Energy.
Did you submit direct rebuttal and surrebuttal testimony on behalf of Utah Clean Energy in Phase 3 of this rate case? And I should add, did your direct testimony have an Exhibit B attached to it?
Yes, I did.
Do you have any corrections to any of your pre-filed testimony?
No, I do not.
So if I asked you the same questions that are in your
Sorry,
pre-filed
your call has gone on longer than allowed. Goodbye.
We faced this yesterday, and so just, you may have one or two other interruptions. We'll just pause for a second when that happens, but I think you can continue right now.
All right. If I asked you the same questions in your pre-filed testimony, would your answers be the same?
Yes, they would.
Thank you. I will now move to admit the direct rebuttal and surrebuttal testimony and exhibit of Dr. Mitchell to the record.
Okay. Is there any objection to the admission of the direct rebuttal, surrebuttal, and the exhibit attached to the direct testimony of Dr. Mitchell? Seeing none, it is admitted.
Dr. Mitchell, have you prepared a summary of your testimony today?
Yes, I have.
Will you go ahead with that?
Okay.
You need to have no fear. The voice on the phone will not contradict you, I promise. Go ahead. I think we're probably, it's finished now, I think.
Good afternoon, Chair Fenn and Commissioners Clark and Harvey. Thank you for the opportunity to provide testimony today. My Phase 3 testimony builds upon my Phase 1 testimony that greenhouse gas emissions have already changed the climate system, resulting in material impacts that we're experiencing today, and which will significantly worsen in the future if we do not reduce emissions. No party contests that the climate is changing and is dramatically increasing wildfire risks and costs. During Phase 1, I recommended the Commission distribute climate-induced costs and risks, and in particular, wildfire risk, between ratepayers and company shareholders. I also recommended that the Commission incentivize the company to mitigate its contribution to the climate risks facing its system. I asked the Commission to tie the company's cost recovery for wildfire and other climate-fueled costs to cost-effective emission reductions. In response, the Commission requested more detailed proposals for how to balance climate-induced costs and risks and incentivize the company to mitigate its contribution to climate risks. To that end, I proposed 3 approaches that the Commission could take. Before I get to my proposals, I wanted to take a moment to note that any action that the Commission takes regarding climate-induced costs, such as these skyrocketing excess liability insurance premiums, this crosses into novel territory. The costs of climate change will now directly appear on ratepayer bills. My proposals focus on managing these costs, the costs that are before us now, while also incentivizing the company to reduce their emissions and help mitigate future escalation of these climate-induced costs and risks. So let's get to these proposals. The first option would be to create a static 50-50 sharing band for climate-induced costs and risks between ratepayers and the company. This would provide a strong motivation for the company to manage their excess liability insurance premiums. Since these ELI premiums are affected by climate change, the company would have an indirect incentive to reduce emissions. The second option would be to create a flexible sharing band, which would start at 50-50 but would then shift to a 70-30 ratio if the company is pursuing near-term actions that reliably and cost-effectively reduce their emissions in line with electricity sector's emission reduction target to limit climate warming below 2 degrees Celsius, above which critical climate impact thresholds become much more severe. This target would necessitate that the company achieve an 80% emission reduction target by 2030, with continued emission reductions beyond that time. I'll note that Utah Clean Energy prioritizes an affordable, reliable, and clean energy system, and that the 2023 Integrated Resource Plan shows that we can meet these goals cost-effectively while maintaining reliability. This is Utah Clean Energy's preferred option. I'll note that these first two options are not a disallowance of cost recovery of ELI premiums, as I expect the company would contribute their share to the sharing band, nor am I expecting the company to seek less wildfire insurance or to go without insurance for these first two options. The third option would take an unconventional approach that relies on first principles. First, affordable and reliable electricity service is essential to modern society. Second, electrification is a key strategy to reduce economy-wide emissions in the transportation, industrial, and residential sectors. Third, impacts from the changing climate are imposing new and rising costs and risks at a societal level across all aspects of society. An approach that distributes societal costs to society at large would be for the Commission to deny cost recovery in electricity rates for any of these costs associated with climate-induced impacts, such as these soaring excess liability insurance premiums. And instead, cost recovery could come from state or federal governments, such that climate-induced costs are borne by taxpayers, not electricity ratepayers. Note that I said cost recovery could come from state and federal governments, but whether that actually happens is beyond the scope of the Commission. For this option, the action of the Commission would only be to deny cost recovery for these climate-induced costs and risks. The company could then seek cost recovery from other sources or bear the costs themselves. A hypothetical analogy here is the National Flood Insurance Program that provides flood insurance to property owners, renters, and businesses and is backed by the federal government. To my knowledge, nothing like this currently exists for wildfire insurance, but if the company was bearing the costs of climate-induced impacts, they would have an incentive to find such a solution. The principal concern of the Commission, however, is that electricity ratepayers in Utah would not bear the costs of climate-induced costs and risks. I will also note that it is my view that it is in the public interest to have a financially stable electric utility, which is the most cost-effective approach to decarbonizing the electricity sector. Therefore, in my view, it would be best to implement this option, this third option, where there's already state or federal policy mechanism to recover these costs, so that the financial stability of the utility is not endangered. In my rebuttal testimony, I responded to Office of Consumer Service witness Mark Ellis's recommendation for a detailed analysis and quantification of the company's wildfire liability risk. I noted that this is similar to my recommendation in the second part of Phase 3 for a comprehensive Utah-focused utility climate resilience, adaptation, and risk planning effort. This effort would be broader than only wildfire risk, but it would certainly include analysis and quantification of wildfire risks as they exist today and as they might exist and evolve into the future. Also in my rebuttal testimony, I addressed Division of Public Utility witness Jeffrey Einfeld and John Gleba's proposal to use Veris model and data to calculate a new allocation factor for Utah and ELI premiums. I examined Veris wildfire risk report that has been admitted into this hearing earlier today, and it appears that this report only uses historical data and does not account for how wildfire risks will change into the future. It seems to me that any decision about changing state allocation factors must also examine future risks. Otherwise, there could be large changes in allocation factors from year to year. As a concrete example of this, Mr. Gliba's testimony lists the top 10 costliest wildfires in the United States as of January 2023 in his table 4.7. He emphasized in his testimony that 9 of the 10 costliest wildfires have occurred in California, implying that California should bear a higher proportion of ELI premiums. However, I would argue that the more pertinent observation from that table is that 9 of the 10 costliest wildfires have occurred since the year 2017. This is in part a function of climate change, and I expect that large, costly wildfires are becoming our new normal, as several witnesses in this hearing have discussed. If hypothetically we had followed Mr. Gliba's historical approach in 2016, we would have made a very costly mistake. And I feel that it's imperative that Utah not make such a costly mistake today by only looking at historical data. I'm not necessarily arguing in favor of using the system operating or SO factor, only that I do not think that the methodology proposed by Mr. Einfeld and Mr. Gliba is appropriate for a rapidly changing environment. I'll also note that there was some discussion earlier today about wildfire recurrence intervals in the VERIS data. That wildfire recurrence interval, or that recurrence interval concept, is a fundamental component of climate change, and climate change changes the recurrence intervals of natural disasters. So how the climate is changing is important to consider as we're thinking about recurrence intervals and how they might play a role in our allocation methodology. This is another area where I think a comprehensive, robust climate resilience, adaptation, and risk planning effort would assist the Commission. Such an analysis could lead to a comprehensive understanding of past, present, and future wildfire risks, and therefore lead to a robust multi-state allocation factor for ELI premiums and perhaps other climate-related costs. As an indicator of these risks, I included a temperature record from the Salt Lake City Airport showing annual average temperatures and the number of times the maximum temperature exceeded 100 degrees Fahrenheit and the minimum temperature fell below 32 degrees Fahrenheit. All 3 of these metrics show a clear signature of climate warming in Utah, which is a significant factor that's driving increased wildfire weather, affecting hydrology, forest ecosystems, and many other components that affect our wildfire risk. In my SIR rebuttal, I responded to company witness Joel Stewart's claim that conditioning cost recovery on voluntary emission reductions is well beyond the scope of this proceeding and perhaps the jurisdiction of the Commission. While I'm not a lawyer, it is my understanding that the Commission has broad authority to address our request generally and in this rate case specifically. The Commission is empowered to ensure just and reasonable rates and uphold the public interest as well as the well-being of the state of Utah. The rapidly escalating ELI premiums are material and significant new costs that must be actively managed. This is at the very heart of the Commission's statutory mandate. The Commission may adopt rate regulation methods that include incentive-based mechanisms, may conduct investigations if it deems them in the public interest, is expressly authorized to allow utilities to pass the cost of renewable energy to ratepayers, and more. My SIR rebuttal highlights a number of areas in Title 54 that are germane to this question of the scope of the jurisdiction of the Commission, although I'm sure it's not an exhaustive analysis. I also addressed Ms. Stewart's claim that voluntary emission reductions may result in shuttering of existing generation that serves Utah customers. This is inaccurate because there are many ways to reduce emissions, such as building new zero-fuel resources, increasing energy efficiency, demand response, harnessing innovation, optimizing flexible operations, to name just a few. PacifiCorp's own draft 2025 IRP that came out earlier this year highlights this because the 2025 IRP preferred portfolio removed all thermal resource retirement dates, yet it was still able to reduce emissions by 80.1% in 2030 compared to their 2005 baseline. Now, this was only the draft IRP, and it remains to be seen what is in the final 2025 IRP that will be released in 8 days. But it illustrates the point that cost-effective emission reductions do not necessarily equate to shuttering of existing resources. Lastly, I also addressed Ms. Stewart's comment that the company must balance any transition with maintaining reliability. I noted there's a growing body of literature and evidence showing that increasing penetration of renewable resources, meaning adding more renewables into the mix of energy sources, actually mitigates extreme weather vulnerability for the bulk power system and increases its reliability. I presented an analysis of the System Average Interruption Duration Index, or I don't know how to say it, SAIDI, collected by the U.S. Energy Information Administration for each state, which is an index of bulk system power losses or interruptions in each state. I used the index that excludes major event days for things like hurricanes and major storms to examine normal utility operations. I compared that with wind and solar penetration in each state, which means how much wind and solar are used state by state across the entire country. This is yet another metric that shows that higher amounts of wind and solar actually appear to slightly decrease the amount of SAIDI, which means that more wind and solar are correlated with an increasing reliability on the bulk power system. So to conclude, we are at a time of urgency and opportunity. Climate change is no longer a theoretical problem for future generations to address. It is materially affecting us here and now, and is a key driver of rapidly escalating ELI premiums that must be managed. The electricity sector in Utah is responsible for 48% of Utah's total energy-related greenhouse gas emissions, and the company serves around 85% of households in Utah. So the company is responsible for a significant share of Utah's greenhouse gas emissions. If we do not reduce economy-wide emissions, climate impacts will continue to worsen and will further threaten the well-being of the state of Utah. There is urgency in addressing this challenge because the degree of climate change is a function of cumulative carbon emissions. Thankfully, we also have enormous opportunity to address this challenge. We're living in times of rapid innovation in the electricity sector, and there are cost-effective ways to rapidly reduce our emissions while also increasing reliability. And Utah is blessed with an abundance of clean energy potential. Utah has a long legacy of balancing environmental stewardship and economic development. We have successfully navigated many energy transitions in the past, such as, for example, from coal to natural gas for home heating. And each of these transitions has led to more affordable, more reliable, and cleaner energy systems. Today, it's our turn to write the next chapter of Utah's history. And at a decisive time when climate-induced costs and risks are rapidly escalating, and to fulfill the Commission's mandate to ensure the company provide a service that is just and reasonable and in the long-term public interest. Thank you. This concludes my summary.
Dr. Mitchell, for your summary. Appreciate that very much.
Dr. Mitchell is available for questions from the Commission and other parties.
Okay, do any of the parties have questions, cross-examination of Dr. Mitchell?
None for Rocky Mountain Power.
Okay, and I don't see any from anybody else. Okay, we'll turn to Commissioner Harvey.
I'd like to go back to your very first point, which was that climate change is a primary driver of wildfire risk. You recall saying that at least towards the start of your summary?
Yeah.
With respect to the ELI, which is one of the primary focuses of this phase, could you give us your opinion about the connection between the increase in ELI, which is specifically tied to the utility doing something that causes a liability and results in a claim, versus simply a broader wildfire risk which may or may not cause a claim?
Well, there's several nonlinear relationships there. If you have a warmer climate system where wildfires are more conducive, then say some spark lands on the ground and the ground is wet, you might not cause any wildfire. But if you have wildfire conditions that are conducive to starting a wildfire and spreading it and rapidly spreading it, then you could lead to a very large claim. And so that's one of those, that's a relationship that is affected by the climate system. I think that that would be the most important metric there to be thinking about. Of course, also if you have a warmer climate system, then your mitigation needs to be, your mitigation costs need to be higher to make sure you're not causing those sparks, clearing the brush or undergrounding the lines, or whatever those mitigations are. And of course, those mitigation actions, the level of mitigation needed is going to be, it might be one of those factors that insurance companies would consider as they're considering ELI premiums.
Thank you, that's helpful. That's all my questions.
Okay. Commissioner Clark, do you have any questions?
I just have a quick question. Where does advanced nuclear technology fit in your view of our abilities to address climate change?
Advanced nuclear is it's zero carbon emissions, so that would be a beneficial energy resource to address. It's a non-emitting resource, so that would be fantastic. I mean, I think one of the challenges with advanced nuclear is that it's got a long lead time right now, and we just heard on one of the more recent public input meetings for the 2025 IRP that one of the first SMR demonstration plants that's being proposed for Rocky Mountain Power's territory, it was supposed to come online in 2030. It's just recently been delayed till 2032. So, and it's still a number of years out. There's still a lot of things that have to go right and on time to be on time and on budget. But it's certainly in the mix. And I kind of, our view is that there's many resources that are having an economic competition to see which will be cost effective as part of a resource mix. And that's certainly one of them in the mix. I think geothermal is one that we're also very excited about as well.
My next question was just answered. Thank you.
Okay, thank you, Dr. Mitchell, for your testimony. We'll excuse you. Appreciate it. I have down that we have one final witness from the federal executive agencies, Captain Rivera.
Last not least, sir.
We'll be the judge of that. So, I was completely joking. I was completely uncalled for, and I apologize.
Set myself up,
but it's
sir.
after 5 p.m.
Set myself up for that, sir. All good. The federal executive agencies would call Michael P. Gorman to the stand. He's currently virtual.
Okay.
Good afternoon.
Mr. Gorman, we can't see you yet. Do you have your camera turned on? Can you hear us? Can you speak? Oh, there you go.
Yeah, there we go.
Okay, I think we're good. Would you raise your right arm to the square? Do you solemnly swear the testimony you're about to give in this matter pending before the Public Service Commission of the state of Utah shall be the truth, the whole truth, and nothing but the truth, so help you God?
I do, yes.
All right, thank you. Captain Rivera.
Thank you, sir. Mr. Gorman, can you state your name, your location, and your company, please, for the record?
Yeah, my name is Michael Gorman. My company is Brubaker and Associates CAI, and I am in Chester, Missouri.
Thank you, sir. Did you cause to be filed direct testimony in the Phase 3 portion of this case, sir?
I did, yes.
Did you also cause to be filed testimony in the Phase 1 part of this case?
I did, yes.
And in the Phase 3 testimony, did you have some exhibits attached to that testimony?
Yes, I did.
How many exhibits, sir?
3 exhibits.
And the numbers of those exhibits were, if I have them correctly, 7, 8, and 9 MPG?
That's correct.
Okay, sir, and you stated previously that you testified in the Phase 1 part of this hearing as well, correct?
I did, yes.
And part of that testimony did include testimony regarding the excess insurance liability premiums, is that correct?
It did, yes.
And would that be in Section 4 of that direct testimony?
Yes, it would. That's correct.
And if have you read over all of that testimony before testifying here today?
Yes, sir, I have.
Do you have any corrections to that testimony?
I only have one correction, and that's in my Phase 3 testimony at page 2, on line 15. The number 82.02 million should be corrected to 82.2 million. That completes my correction.
Would that be kind of like a clerical error, sir?
Yeah, the typographical error.
Thank you. And if I ask you the same questions that you provided in your testimony here today, would your answer be substantially the same as if you testified here today?
Yes, it would, yes.
Other than that correction that we mentioned before?
Correct.
And I would like to submit the testimony of Mr. Michael Gorman into record. Sorry. Submit the testimony and exhibits 7, 8, and 9 in the Phase 3 part of this hearing into the record as it would have been read.
Okay, thank you. Is there any objection to submitting Mr. Gorman's Phase 3 direct testimony as corrected on line 15, in addition to these 3 exhibits, 7 through 9? Seeing none, we'll admit that that testimony and exhibits.
Mr. Gorman, have you prepared a summary of your testimony for the commissioners and other parties in this case?
In my Phase 3 testimony, I comment on the company's proposed allocation of excess liability insurance premium cost across various jurisdictions, including that cost allocated to Utah. In the company's testimony, it outlined the significant change in the market for excess liability insurance that has occurred more recently due to significant wildfire events, including the James event, which led to the decision in 2023 against Pacific Corp. Nevertheless, despite the changes in excess liability insurance market, the company still proposes to allocate its excess liability insurance cost across its jurisdiction using its overhead allocation factor, SO, and assigning its excess liability insurance cost to its various jurisdictions. The company's evidence demonstrates that the cost for excess liability has changed more recently, and the amount and the price of insurance covered has changed due to the significant wildfire events that had happened more recently. In the company's excess liability insurance cost, in this case, it shows it continues to buy a liability coverage that provides sublimit coverage across all of its jurisdictions and allocates that cost across the various jurisdictions. But it also buys additional excess liability insurance coverage that only provides liability coverage to California and or Oregon jurisdiction. Nevertheless, the company is proposing to allocate a portion of all of its excess liability insurance costs to all of its jurisdictions, including Utah. My adjustment in this case removed the additional insurance purchase to provide liability coverage for either California or Oregon and exclude those policy premium costs from the pool premium costs that provide coverage to all jurisdictions, including Utah. Removing the excess liability coverage that is dedicated to California and Oregon has the effect of reducing the company's total excess liability coverage cost that should be allocated in part to Utah from approximately $185 million down to $152 million. The allocated share of that cost to Utah would, based on removing liability coverage that's provided only to Oregon or California, would reduce the allocated share to Utah from $82.2 million as proposed by the company.
Sorry,
down to
say that number again.
67
Sorry?
$82.2 million
Thank you.
allocated to Utah as proposed by the company, down to $67.6 million with this adjustment. That concludes my summary of my Phase 3 test.
Thank you, Mr. Gorman.
Thank you, Commissioner. I'd like to tender the witness for cross from the other parties.
Okay, does anybody have cross-examination of Mr. Gorman? I see no. Shakes of the head, yes. I see a bunch of shakes, no. So we'll turn to Commissioner Harvey and see if he has any questions.
No questions at this time.
Commissioner Clark.
I have no questions, thank you.
Okay, Mr. Gorman, thank you. I have no questions, then you may be excused. Appreciate it. Okay, let's, thank you. Let's talk a bit about that. Concludes the witnesses for this bifurcated first part of the Phase 3 hearings. We will begin the second part of on the wildfire mitigation plan and issues on 3/25. That's Tuesday. We'll begin at 9 o'clock. On my sheet that I have in front of me, I have no information that indicates that any witnesses need to testify at a time certain or to appear remotely. Is that okay? Go ahead, Captain Rivera.
Yes, sir. The federal executive agencies filed a motion on 14 March regarding our participation in the next phase of Phase 3. I believe the commissioners did not rule on that motion. We would like for the commissioners to rule on whether the federal executive agencies can be excused from the second part of Phase 3, sir.
Okay. Okay, we've ruled on a number that came in a day or two ago. We must not have seen that one, but you may be excused from the second part of Phase 3.
Thank you, sir.
And thank you for being present with us during this part of the hearing. So, are there any corrections to what I just said? Do any witnesses need to appear at a time certain or to appear remotely? Okay, all right, we'll expect all of those witnesses to be there. Then earlier today, I asked about the, is there a question? Oh, well, and Ms. King. Ms. King is also excused, so I'm sorry. I already, yeah, I'm glad you mentioned that. Thank you. Earlier today, we asked if anyone had any objection to the admission of the Charles Rivers Associate Independent Evaluation. The actual name of that report is the Independent Evaluation of Rocky Mountain Power's Utah 2023 to 2025 Final Wildfire Mitigation Plan. And I asked if any of the parties plan to cross-examined a representative of Charles Rivers Associates. At the time, we had no one who indicated that was in their plans, with the exception Mr. Moskin, who was going to review that and make a determination. Mr. Moskin, what's your decision?
Yeah, no, you do not need to bring the witness just for us. If other parties question the witness, we of course would want to not be limited by the scope of their testimony, but you do not need to bring the witness just for us.
Okay, if it changes and somebody wanted to examine them, now's the time to bring it up And because we do have a scheduling problem with this independent evaluator. So based upon what has been said or has not been said, the plan is that you will have the report. You've already had it since January 10th. The report speaks for itself, and I think we've established enough of a foundation that we admitted it earlier today. You can talk about the report, but we will not plan on having a live witness to defend the report present during the next part of the hearing that begins on Tuesday. Okay? Is there anything else that we need to bring up before we adjourn this phase 3, part A, I will call it, of the hearing? Anything else anybody has? Thank you for your patience and your long suffering to go long days with few breaks and short lunch periods. It's very much appreciated, and I appreciate your professionality, and we'll now adjourn this proceeding until Tuesday at 9 a.m.
Off the record, Mr. Chair, may we leave binders